came lower than 12 members, she interprets it as non-existent. And I'm asking the question, is that what we want to put in? We can always refine it with the lawyers later on.
Chair, the section 13.1 opens with, at the time of adopting this report. At the time when we adopt this report, there will be no more, right now the board is non-existent, and when we adopt it whenever we do, there still won't be.
No, that's fine. Wherever there's non-existent, we'll put non-existent stroke dysfunctional, and we'll clean it up to yeah, all right? Round robin, we spoke about common practice, and then Honorable Waters, I think, said, no, common practice is too light, let's call it manipulation. What is the sense we're saying? We'll put it in here. Remember, it's a working document. We can always think about it, but we can't have so many this is but that. What we can eliminate, let's eliminate. Do you want dysfunctional, not dysfunctional? We had tried to couch it that it was not common practice. He was saying it was manipulation. Which one do we prefer? Common practice. We'll argue about it tomorrow. I mean, we will note it tomorrow. You'll have another opportunity, another bite. And then the public protector, I think we said failed, and somebody said opposed. There shouldn't be too many difficulties. Did they oppose it, or did they fail to implement? Although the public protector came and she said they failed to implement. I mean, that was the words of the public protector.
But the issue there, Chair, will be the implementation. I understand the point, opposed, but the fact is that is to implement remedial action. So I think let's stick to the implementation rather than put in the oppose. Because we are expected to implement,
just for the two of you, and Mr. Swartz, you're a lawyer, the compromise is, as opposed to opposed, failed, we say did not implement fully, because that is the safer one. The board did not, wherever we refer to that, we'll say they did not implement fully. Is that it?
Can I convince the committee otherwise? The thing is, to fail to implement means that you tried and you did not achieve. But actively seeking to find a different solution is opposing. And I think that's a much, and it has, I think it has serious implications on the character of this board.
That's fine.
Or we can put both. We can say they failed to implement and directly imposed directly opposed by seeking opposing.
Let's take Honorable Khoza. We're doing this before you go in. Honorable members, bear in mind that we want to give you as, what do you call it, as perfect a document as possible. But if there are 17 views on, let's say, point 1, you make it literally impossible for us to prepare a document. Then we might as well do what we did yesterday, argue it out and get it to a document. That's the only thing that I'm worried about, that we'll come back and we'll say opposed, failed, rebellious, all those things. And all we'll be doing is repeating what we should have been doing today. So you guys must assist us in this, because it's not our document, it's our document. So all I'm saying is, in your input, assist us to prepare a document. Otherwise, we'll have to go back to what we did yesterday, because it was more practical. We take a point, we argue a point, we agree on a point, but we can't have 10 different interpretations and expect us to take the decision on what it should be. On this one, the board failed to, the board opposed, the board did not implement. That's what we're arguing now. Khoza was the next
I
one.
wanted to sponsor a way out. I am suggesting that we don't deal with semantics now. What you then do in the document, where there is a contested terminology that is adopted, that is used, we probably bold it or we put it in a different color, so that when we do the editing of the document, we can then agree which terminology we will go for.
If that's, the-
Rather than wasting a lot of time dealing with the deciding on which term is failed or posed or whatever.
if that,
The legal guys will be there to assist as well.
if members want to do that, that's fine. Just on the process that we've done now, there's been 13 amendments. All I'm saying is, on Tuesday, you'll come back. At some point, we're going to have to resolve these 13 things. The question is, do we do it now or do we do it on Thursday? I thought that the deliberation would have meant we take all these views, put them in the pot and try and refine them. Because all you guys are doing now, all honorable members are doing now, is just airing your views and putting them into a wish list. When are we going to take this wish list and make it a committee report? That's all that I'm asking. 1, 2, 3, 4, just in the process. How do we deal with
I'm
it?
going to propose that, Chair, we throw in as much as we are throwing in issues there. And then we can then clean them up. Because as you clean them up, we look into the terms of reference so that we don't differ much with what terms of reference says we must do. So I will propose that you take that process, we throw up issues there, and then we pass on. Because if we're going to debate those issues again, it will create problems. We'll never finish. So we'll throw them to you there with the table, and then you'll note them. As you clean up the document, you'll definitely have to apply a proper a terminology in the process. As Honorable Makosi was proposing that maybe we sort of list them up, but I will throw them to you, and then you can then process those issues. It's easy.
Right. So you'll get an unedited document, except that it'll have reflected all the views of every member. Is that what you are saying? Yes, ma'am.
Thanks, Chair. This report doesn't live or die by what word we choose. So I would suggest we use contravention or violation, which are generally accepted legal terms. But I'd also like to add that this was not only in violation of a Public Protector Act, but also of a constitutional court judgment which found that the Public Protector's remedial action is binding. This judgment was handed down on the 31st of March 2016, which gave enough time for the SABC board to then act on the remedial action ordered by the Private Protector. But I've written all my suggested edits, which I'll send to Cindy, and I'll include that if we agree that we include that.
All right, I thought we were talking on the what is it? Let me put it differently. If this was the end of the process, honorable members, if this meant we had gone through everything, would you expect us to come to you on Tuesday with a document that has this question mark, as Chauke is saying to it? No, can I finish speaking? Are you expecting a document that comes that says on point 1, this was Singh's view, this was Vincent's view, this was so-and-so's view? Or do we want to come to a point where we say this was the committee's view? Because right now, let me give you an example. Right now on this point of let's take practice versus manipulation. Let's just take that one, practice versus manipulation. Sitting here, we're not clear what the committee is saying, because somebody is saying put practice and manipulation. That's what one person is saying. Somebody else is saying, no, come back. It's just how we're going to work with this thing. What is it that you want so that we can do? Let's take Loliwe first and okay, let's take Loliwe, you'll take you. Just on what is it that we must do? 1, 2, 3, 4, 5.
Chair, our product should be a document which meets the legal requirements. So what I suggest should be done, as we are debating here, our scribes are catching the thrust of what we want to reflect. So what is legally acceptable should be what is what should reflect in our document. And then we'll debate that on Tuesday. Thanks, Chair.
Chair.
Okay, I'm informed that you guys will throw everything on the table. We'll try and get some sort of a general view, and we'll have a second bite on Friday. Oh, not on Friday, on Tuesday. Yeah?
Yeah, so,
No, let's take Mokwena. You'll come in, Mokwena?
yeah, no, Chair, I agree, because I was going to suggest that you must take charge of the situation, so that we'll give you what we think, right? You will get a general sense of, right? And then, yeah, so don't ask us what we should put in there or not. I think this session that you're engaging in now, we should cut it out. We must just put what we put, and then that's it. And then we'll,
Okay, no, that's fine. If you then give us the responsibility of trying to synthesize it, remember you'll get it back even before Tuesday, and you can still disagree with what we thought we are hearing you saying. Is that okay? All right? You're fine, okay. All right,
Way forward, because you feel that we're not moving fast enough. I just think that what we must do as a committee today is just, in line with what we now resolved, look at the bigger picture, the content issues that will lead us to the resolutions or the recommendations. For us now to express huge gaps, etc., but I would like to suggest, Chair, and I don't know if I will be shut down, but can we not perhaps look at all of the observations? Because I would argue that some of the observations could also fit in under the fitness of the board, etc. You know, and then there's one heading, for instance, corporate governance, which actually refers more to the management failures. And that was also an oversight of the board. But be that as it may, the issue that I'm just making is, it is a little problematic to work in the headings, and it's going to delay us. Can we not focus on broadly observations and say, this is the foundation, because we have this mandate, this is our terms of reference, and we must come up with recommendations based on the observations as a whole, not necessarily categorized.
No, we learned by trial and error. I thought that was the first suggestion we made. We said to you when we started, do you want to talk to everything so that we get a sense that this captures it and you'll add new things? And everybody said, I can't. Let's go with, and it's fine that we do it that way.
No, Chair, I want to maybe agree that maybe we amend the earlier position that we took under Mr. Singh, because it's clear that they will not definitely be able to follow and finish now. And then let's go back to this new position that will then help us to speed up the process. That is why I was a little bit disorganized from the start, because I prepared myself in line with the general input that I was going to do. But I'm not going to come back, because I know those issues will be already raised by colleagues. Thank you.
Honorable Singh, we are draw.
no, Chair, can I put the spanner in the works and say, I think it would be dangerous for us to make decisions based on time, right? The primary thing here is not time. It is to come up with a document that will fix the situation and I think the approach that we're taking now, which is to look at each and every heading specifically, I think it gives us focus on the specific issues. I think the approach to just, throw everything in one bag is going to defocus us. I'm therefore suggesting that we stick to what we're doing, but maybe just put time limitations on what we're doing, because I think we're running into the danger of not giving a proper focus on this thing. And these two sections are extremely, extremely important.
No, Chair, one, I wanted to say, I wish I lived in Mokwena's world. In our world, you work with time, and we have to be efficient with time. If we don't set time frames, we won't be able to finish. And two, I wanted Honorable Singh to withdraw his proposal because Honorable Singh can see that his proposal
Talk
has
to
not
me.
worked.
No, talk to me.
No, I'm
talk to me.
talking through you to you, Chair. I know that Honorable Singh, by the way, we are from KZN. We have this thing of talking, you know, and he understands what I'm saying. And I know that, Chair, if you can give him the opportunity, because if we attend to this thing, each one of us will then zoom into those sections that we are really feeling strongly about. And that way we will be able to save time.
Chair, I think we must guard against contradicting ourselves. We have got to take a decision and stick by it and not retract what we have said before. Our prime motive is to work on the mandate, on the resolution given to us by the House, and ensure that we do some constructive work with regard to that. And we're able to come with strong recommendations that will assist the House and assist Parliament, assist the Portfolio Committee, correct SABC. So I would therefore think, Chairperson, we have agreed that we have a document before us, we have been working on it. We didn't say it was perfect, but it was a springboard from which we could start, and we've been working on this document. Now, we've been giving views. They are collated, put together in a bowl, but at the end of the day, the technical document will end up with the legal team and come back to us. So there is no harm in us giving you the principal decisions, because there is no disagreement at the moment. We are giving principal decisions and we give them to you, and thereafter, when the document comes, we look into it and we try to reshape it, and the legal team will eventually work on the document. Thank you.
Right, honorable members, I was just reading this thing. Outside of adding any new one that we could add, but as it stands here, there are about 8 sections. I'm just talking about observation, so it's 13.1 to 13.8. So there are 8 sections if we take Mr. Singh's route. And I tend to agree that we can't, for the sake of time, compromise quality. But I'm saying in these 8 sessions, we either take a decision that it's an hour a session, it's whatever the case might be a session. No, what I'm saying to you is that that's the practical reality that we're faced with. Because you guys can't say to us quality and then you say to us time. You make it extremely difficult for us here. You've got 8 sections on recommendations. Not on recommendations, on observations. The question is, can we agree that it's so many minutes per section, we divide it equally? Or you talk to everything. We do not want to compromise on the quality. 5 minutes per section per man. Okay. Cindy is saying and I mean, she doesn't have to dictate to us. But I'm saying these are the technical people that help us. She's suggesting that let's give every member 10 minutes to talk on globally the observations. Remember, because with the recommendations, we're going to zoom in word for word around the recommendations, because that's the crux. So she's saying if every member had, because on observations, we all know, I want to talk about HR, you want to talk about finance, and so on. That's the suggestion being made for Cindy. We are talking only observations. Recommendations, we're going to do it with a fine-tooth comb. Are we comfortable with that approach? We are. What time is it? Okay, we'll start from scratch with everybody again, yeah. Welcome, Honorable. We did get your message, Honorable Kubis. You're going to have 10 minutes to talk to all the observations. You're just at the point where we're saying, around observations, we're going to give members 10 minutes, and you zoom into the important ones. And we'll try and capture them, and we will try and put them in. What time is tea? Oh, all right. Tea is 11:30. 10 minutes, and at 11:30 we'll break and we'll come for the other people. We are not changing from that now. And we're dealing only with observations. We'll try and capture what you're saying, and we will try and fit it in and give you a document, and then we want to get to the recommendations. Honorable Chauke, maybe we'll start with you. Must we start somewhere else? No, I know you've just come in late, Kwankwa. Let's start with you, Honorable Matlangu. We'll go up that way, come all the way down here. You only got 10 minutes to give us, because you should have read this document for the past 4 days anyway. Around observations, you've got 10 minutes to show us which are the priorities you want us to change, touch, and then we will debate them in detail on Tuesday. I think that's the decision we're taking, and we're not changing that decision around observation. We're not. Your 10 minutes starts now, sir, on everything around observations.
Chair, I will lead by example and save you time. I will not take the whole 10 minutes. On the shareholder area, role of shareholder, because that's not the next matter. There is one matter I'd like to speak to. There's a question here about which of the two acts, the Companies Act and the Broadcasting Act, as to which one is superior with regards to the areas that we are looking at. I think what colleague Gillian said, and she's been raising this thing throughout the hearing, is that with regards to specific areas that are mentioned in the Act, those areas, the Public Broadcasting Act takes precedence. In other words, it's not the other way around. And I know somewhere there is a question of clarity, and I think we should just correct the clarity aspect that in areas that are prescribed in law, that law, that law is the most superior. In this case, the public broadcasting. I have, there are issues of, I think I've already spoken to this matter during the board on the MOI, and I wouldn't want to repeat myself. I think, yes,
10 minutes starting from scratch on everything.
My view was that the MOI, the board allowed it itself, and that's why my view was that it does not belong. Whilst the minister may have recommended it, but it is the board that decided to allow its responsibilities to be changed, and they could have stood their ground, and they have failed. That's why my view is that it actually doesn't belong here. Now, there's an issue of the shareholder role in the appointment. I think from where I am, in all these things that I hear, I would locate those things in the board. If the board took its position, I mean, you wouldn't be having a problem as much as if a committee allows to be manipulated by anybody, that committee should be taking the responsibility. I'm not going to get into funding corporate governance issues. I will not. I think I've already spoken when I spoke to the board. The other matters, I think, are in fine accountability. I've already spoken to the journalistic matter, and I place it in the board. I will submit my crafted document, and you can decide whether you want to put it here or you put it in the board, because I took these things and I put them in the board. All the failures, I put them in the board. There's an issue I'd like to raise, Chair, and it's not included on the Peace Parliamentary Committee. It's an additional, I've crafted it, I'll make it also available, that the Portfolio Committee, in selecting candidates to serve in the SABC, failed to carry out its judicious role in appointing those individuals. They appointed individuals, some of them who did not understand their responsibility even after, towards the end of their tenure. And I think the evidence that was given here by Maguve that he did not know most of those things that he's supposed to be knowing. I don't know how we went through the selection process and the what you call, and I will come with recommendations on the same matter. Now, there's an issue of political interference. I guess earlier on we dealt with the matter when we dealt with the first subject in the day, and a few things that I would like to raise. I've raised the issue of appointment, the issues of increase of salaries, the corating, non-corating. Well, I guess there is a matter that I don't know where to locate it, whether it is in the board. You know, you have a person, for instance, in the name of the secretary of the board, who gets appointed to the position of, she's now a corporate director for risk management and something, and no procedures are followed. So those things, perhaps when it comes to questions of HR, corporate governance actually. There's a lot of things that have gone wrong in corporate governance. The issue of, from the evidence that was given by one of the ladies was that in order for people to get into corporate governance, I mean, to enter into SABC, you don't need any qualification. Actually, you can get there with a very low qualifications, unlike other industries. But those people then migrate into the core business and then find their way out. I think failure to have those measures that says you don't belong to the core business and therefore stay in that space either as an artist or as a presenter, but not into the core business of the what you call of the SABC. There are issues of failure to adhere to the HR dictates, where people have to apply, where adverts, shortlisting, interviews, and the competency tests that has not happened. I think I would wish that we bring those things very clearly here in our documentation on governance issues. And for the appropriate subcommittee, well, I did speak to it when I spoke to the board, appropriate subcommittee to make recommendations to the board and for the board to take the decisions. I guess, Chair, I must end up my, I must end my input because my preoccupation was indeed matters of the board, and I think I'm comfortable with the rest of the other things. Thank you. I will submit my inputs that I've done here.
We've tried to capture it, and we will find a way of putting all these things together. But if there are submissions, as we did yesterday, please submit them to us before you leave. Can we then move on to Honorable Khoza? Any comments you want to make on matters that we have termed observations?
Chair, I'm going to surprise you because I'm going to be very quick. On the role of the shareholder, Chair, I would like 13.2.1 to be firmed up a bit and by indicating that the minister, there appears to be the testimony that was indicates that the minister attempted to take over the powers of parliament in the process, the powers of parliament in as far as the appointment and removal of members of the board. And I think that we needed to put something that speaks to the issues of separation of powers. Chair, I'm also concerned, and I think it should come out under observations, because there is a bill underway that is deleting the powers of parliament and replacing those with that of the minister. And I do think that at this stage, that should be reflected as observations and concerns of this particular committee. And Chair, the second one, that one, I think it will have to be firmed up. I do think that the matters are covered pretty well, but I also do think that the matter 13.2.2 around the allegations of the minister's involvement in the appointment of the COO, I do think that we do need to look at the terminology that we use there, because there was undue influence as opposed to, the direct involvement. But that's a matter of semantics, and I think we need to firm that up. Maybe our legal guys will have to help us around that issue. The issues of legal status and governance, Chair, I wanted to zoom into 13.3.5. Chair, I'm not sure how are we going to put this, but it's a matter that I must be honest, I'm feeling particularly strong about. I really do think that there was, those of you that might have worked in an environment of structured and project finance, you always find a way of doing a deal that will achieve the objective, but without necessarily saying it overtly, you know? And my concern is around the issue of the multi-choice deal, that, this lease, or whatever you call it, to me, it looks like some kind of, selling the public asset without necessarily saying, I am selling this public asset. And I do think something will have to be crafted along those lines, because it's not an outright sale, but it's the contract that is speaking, when you look at the terms that are there in that contract, because I read it, I think it's tantamount to the outright sale, but it's not saying we are selling. And maybe the legal guys will have to help us around that one. Chair, I think the corporate governance, I do think that maybe we may have to, probably as part of our observations, to pull out a few key corporate governance principles that the SABC board or that institution seem to have violated. Because in this thing here, we don't seem to have, we are making assumptions that everybody understand what those corporate governance principles are. And I think it's going to be important that we put them in. Thank you, Chair. I'm done.
Now, Lama corporate governance issues as well. Please just give us one or two of them, as you see them, and we'll incorporate them, even if you give us an example of one or two. Honorable Kwankwa, we're just talking broadly around.
No, I understand, Chair. May I make a request that I go, excuse me, I go last if you don't mind?
That's fine.
Primarily because I'm still trying to find my feet. I must apologize on record that I was also held up by staff issues after my apology. Thank you so much, Chair.
All right, we'll come back to you last. It makes sense. Then can we then move to Swartz? Your time starts now, sir.
Thank you, Chairperson. Okay, on 13.2, the role of the shareholder representative. Dr. Khoza has referred to the issue relating to the perceived conflict between the Companies Act and the Broadcasting Act, which there is a document as well. So 13.2.1, where we say evidence provided during testimony indicated that the minister had direct interaction with certain board members in an attempt to have them resign or removed as board members. I don't think it was without any involvement with Parliament, because remember, the Portfolio Committee actually endorsed that firing of those 3 board members. But I want to add there, full stop, this was on her understanding that the Companies Act, read with the amended Memorandum of Incorporation, gave her the power to remove board members, full stop. I will also give this in writing to you because I have written it here. This approach was endorsed by the then Portfolio Committee on the 23rd of June 2015. The then Portfolio Committee on Communications in 2015. It's very important to add that. Then the next issue relates to the role of the ministry and certain board members, which is alluded to in 13.2.1, but the confusion of letters to Mr. Chris Schneider and Professor Bongani Kumalo in December, where they got letters urging them to resign. When they phoned the minister said, but it's not supposed to go to you. So that also is an observation that there is an evidence of misunderstanding in the direct approach to board members relating with requests to them to resign. Now, that is interesting that Mr. Krish Naidu then, as an observation, indicates that this was an illustration of a dysfunctional ministry. And that is on page 4, which we can consider to be an observation from our side. That incident of the minister or an official phoning him and then saying, no, I never intended you, you're an asset, you should not even contemplate resigning. He says this is a classic example of a dysfunctional ministry which compounded the problems of a dysfunctional SABC board. My suggestion is we consider inserting that as an observation. The next issue relates to, Dr. Khoza mentioned the tabling of the Broadcast Amendment Bill with the Portfolio Committee of Communications. This is very important. It must be observed, it must be noted, because that proposal then would remove the role of Parliament totally from the appointment or discharge of board members. Chairperson, that is on the role of the shareholder. Then, when we look at the corporate governance issues, there are a number of observations made by Professor Bongani Kumalo in his written submission, which I think would be very helpful for us to take on board. And I think that we need to consider those. And it's important, for example, the wording is in his written statement on page 3 and 4. For example, the general areas of concern, he says, is failure to observe the differentiation of functions and the management of boundaries between the board and executives. That alludes to corporate governance. 13.4.1, the role and responsibilities. Now this is, that 13.4.1 is between executives themselves, but there's a further element of corporate governance which Professor Bongani Kumalo refers to. The board should oversee and supervise the organization, and the executive should implement the board's mandate. That is an important observation. The wording is contained there. The next bullet that is dealt with by the professor is inexperience, inadequate training, indiscipline, familiarity, misdirected or bad corporate politics, internal power contests, poor and diminished business ethics are among the causes of governance failures at the SABC. That, again, is an observation that is, there's testimony before us, we can make that observation as well. Chairperson, there is also here in his recommendation And this could possibly, could possibly come under the previous one relating to the shareholder, the role of the shareholder representative, where he says the board is appointed by the shareholder and is accountable and derives its mandate from the shareholder, to whom it is answerable. The SABC experience has demonstrated that shareholders or shareholder representatives need orientation and training to the greatest extent to understand their role. This could be an observation that we can make. And this again is on page 5 of his document. The SABC board was not adequately empowered by the shareholder representative. The point is to underline that the primary and ultimate responsibility of the board is to the SABC, and the shareholder is ultimately responsible for the same. So there's a question of training, corporate governance, and observation there that is evidence before us. Chairperson, I think then when one goes on to just look at one or two of the further issues that I've made some short notes on. 13.4.5, we make use of the word in a deal, obviously must be multi-choice agreement, to a private monopoly. And I'm not sure if the word monopoly is right there, whether one should use company or monopoly, but again, do we indicate, one presumes that is multi-choice there. The accountability, the next page, we've already dealt with that, the walkout, showing disrespect for Parliament and the Constitution. Chairperson, I want to take to the 13.6 and to the end of that, where we deal with the presence of the State Security Agency within the working environment. I would presume that that statement, there would be recommendations that must be investigated further. But I mentioned the issue of the flighting of a 7-minute praise song to the COO on current affairs programs, whether one should make an observation about that. I put that question to Dr. Ngubane whilst he answered it about local content, but whether it is, and that is an observation we should make as well, the cost involved in that and whether it is appropriate. I initially understood it was in a news program, but in a current affairs program. The 13.7, parliamentary oversight. 13.7.1 is a very strong statement that is made. The Portfolio Committee on Communications lacked the urgency in addressing the removal of 3 board members without the involvement of Parliament, contributed towards the dysfunction act, which one presumes. But that statement needs discussion. It's not a question of urgency. It was very clear that that Portfolio Committee was, for use of a better word, pressurized by the minister to accept the fact that the Companies Act trumped the Broadcasting Act at that time. And that Portfolio Committee accepted the firing of the 3 board members by the board and not by Parliament, and that is a resolution in Parliament. So that, we need to look at that clause very carefully. And if one considers the reporting about that exact meeting that took place on the 23rd of June 2015, and I apologize for not putting this to the minister in my limited time, but it is there. The minister said it's not the issue of Parliament to decide whether the Companies Act or the Broadcasting Act is determining. Obviously, we passed the laws. It is for us to say which trumps. And she says it's for the courts to say. No, the courts say what is the intention of Parliament. So, Chair, that is my brief comment on those. Thank you very much.
Starts now, Honourable Mokoena. Yes, sir.
Okay, so I'm going to go back, Chair, to the
Yes.
board. I think there wasn't adequate training of the board. There were two chairpersons here, in particular Maguve and Ngubani, who seemed to clearly not understand their responsibility. They seemed clearly not to know what was happening at the SABC. So I think the issue of training the board is of utmost importance. The shareholder, the role of the shareholder. I think it must be noted, Chair, that the shareholder was actively trying to centralize power in her office and removing it, one, from the president, two, from parliament, from everybody else, and to put it in her office. And I think that is a gross flouting of one, her duties in her office, but I think also crossing lines of separation of powers. And she also failed to rein in the SABC board. They were running amok. They were doing literally what they liked. They could go to the public and tell them that they don't recognize parliament, and the minister was just quiet. She ran an SABC that got weakened to a point where there was literally one member, and nothing happened. She failed completely in her duty to exercise her oversight role as a shareholder. And then I think the chapter on parliamentary oversight should then follow directly after the shareholder, because I think they then failed to hold her accountable. I think where it is, it's kind of it's divorced from. Whereas I think it's directly involved in or directly following on the role of the shareholder. And under the parliamentary oversight, they failed on many issues. It's not just the issue of the dismissal of it. They failed to understand the changes of the MOI. They failed to, sorry? We failed. Yeah, we failed. No, we. No, we failed to, we failed dismally to understand the documents that run the SABC. And it was our role to make sure that those changes don't happen. The fact that we're sitting with a broadcasting act that the minister wants to change as well, I think, that must be noted in the strongest of terms. It seems the portfolio committee is not paying attention. I think is something that must be, And then, under legal status, page 26, legal status and governance. It must be noted that the Broadcast Act is now in front of Parliament and that the minister is trying to shift or to centralize power with that document. As an observation, I think it's a and then corporate governance. There's a lot of confusion now about responsibilities, who does what, and so on and so forth. The other thing that I forgot, I apologize. Under the shareholder, in the Broadcast Act, Chapter 8. Chapter 8 says that the minister must establish a South African Broadcast Production Advisory Body to advise him or her on how the development, production, and display of local television and radio content can be supported. It then outlines the role of this advisory body. Now, the role of the lack of such a body was manifest in the confusion that we saw in issues of local content, of what should be aired, and so on and so forth. And I think her lack of instituting that body was a serious oversight. And it's something that must be looked at. And that's part of how she, she did not adhere to the Broadcasting Act. She must read the Broadcasting Act and then establish the advisory body. Because that advisory body will then help with, okay, I'll come to that. Under corporate governance, there's serious confusion about the roles of everybody there, who does what and so on and so forth. The fact that local content, the issues of policy, journalistic policy, lies within the COO's office is, and we've been getting information through submissions that roles have been changed, so and so was taken from this to that, and we don't know what she does there, and so on and so forth. We must look at, there must be an entire, or maybe that's a recommendation, but the roles are confused. In the entire SABC, not just centrally, but also in the regional offices there. Accountability, we must be very strong on that. The board is extremely rebellious. And then the issue of journalistic matters and related matters, because then the advisory body, if the minister had established one, it would then assist in local content policy and all sorts of other things that, and it's well within their scope. That's what they're supposed to deal with. But the lack of such a body has then brought up all these issues about 30, 70, 90, 10, local content issues, policy on fairness, and so on and so forth. And also participation of the public. These are all issues that should have been looked at, and they never happened. And this is the reason why the SABC is in the state that it's in, because there's no one advising anybody, and there's no framework that is being followed. Testimony, we looked at that. Yeah, that's me.
10 minutes to tea. Somebody's going to make sure that the tea is ready at 10 o'clock or 11 o'clock. So, Honorable Kubisa, you've got exactly 10 minutes, and after that we'll break for tea and come and deal with the second session. Please put your mic off, sir.
Thank you very much, Chairperson. I want to begin where I started. Number one, that when you look at 1313 on the issues that were brought by the AG and they were disregarded, I want to repeat that there seemed to be some history that was there before of total disregard of duty. I want to say the board acts within the constitutional and legislative mandate, in as much as we all do, that there is a constitution first, there is a legislation that governs how we work, there is a Companies Act, and all of this legislation, you just disregard everything. That says to me the lull and lackluster attitude emanates from some history that has been going on. And that brings in the issue of the portfolio committee failing to do its task. Because when you've got the Auditor General's report, before you as the portfolio committee, that raises, or it rings some alarm bells. What do you do? Why are you not constantly moving nearer to the board, to SABC, to say when they come to report, this must be corrected as a matter of urgency? Now, that says we, from the side of Parliament, lacked that kind of gravitas on the issues, dealing with the issues promptly as they came. So this thing would go on and on and on because they would come. It doesn't mean that the board didn't come to Parliament. It kept on coming to before the portfolio committee. Yet there were these issues that have been there for quite some time. And the new board, therefore, found it easy to get away with it. So I'm bringing in here the history that is engraved. I'm bringing here the failure by the board, failure by the portfolio committee to act on the AG's report. Because the AG's report should have galvanized the portfolio committee to take action and to alert the honorable members that there are serious corporate governance deficiencies in the SABC. So now, as we sit here, we need to re-evaluate the pieces oversight approach. But we may say it's embedded within the Constitution. It's embedded within the Constitution and also within our rules. So something very drastic has got to be done by the portfolio committee. Devise a new strategy to strengthen it and maximize its oversight function within the parameters of the law. So that to me is important. Then when it comes to interference, political interference by the minister, that is very serious, Chairperson. I think it's a point that has to be taken into cognizance because it seems there was an intent to centralize power. Centralize power to the extent that everything must rest with the minister. And it's surprising because there is legislation governing executive powers of the minister. But the way things have been happening, the interference with the board and also administrative matters, the encroachment, which was unwarranted, that's an observation that we need to tackle as the ad hoc committee. And also, Chairperson, I want to talk on this issue of corporate responsibility. That I have a feeling that we need to piece this corporate veil. What do I mean by that? The piecing of the corporate veil. A need to hold individuals personally accountable for their actions. Because it's easy for the individual who acts wrongly, acts within his own interest, and then it will be used under the guise of the collective. There must be no place for individual to hide behind the powers of their office to escape liability for decisions that they have made, which were not motivated by the best interest of the SABC, making individuals to account, rather than hiding under the guise of the collective. Also, Chairperson, it is noted that time was not of essence from the side of the board, from the side of the portfolio committee, and from the side of the management. That if issues were raised by the AG, to have them corrected immediately, they were not corrected. They will go on unabatedly, and no one would care about it. And in the meantime, wrong decisions were taken. And this then comes to what I alluded earlier on, skills-based, skills-driven kind of board. how is the board appointed? Of course, there is law. There's a role of the portfolio committee, role of the public, role of the president, role of everyone. But one has a fervent feeling that from now on, perhaps we must come with suggestions that the board must be nominated in a transparent way. Let me say, come with proposals to the legislation that the appointment of the board should be done transparently, like it was done with the public protector, so that we know who's getting in there, who's getting onto the board. So these issues, chairpersons, I want to put forward to you, and I'll comment on other issues later on. Thank you very much.
Thank you. I will break for tea. Just before we break for tea, I know that as we get talking, we somehow conflate recommendations and observations. The last one, Honorable Kubisi, you will have to, Bob, the last statement you made, you'll have to return to when we do recommendations, because it was not an observation, it's a recommendation, I think. But we'll note it, and we'll continue to refine it going tomorrow. All right, honorable members, we come back at 15:15, and Kwanko, will you be ready at that time? But we can come back to you at the end. No, 15:45, 15 minutes, 15:45, I beg your pardon. So call an hour, and then after you, because we had given you half an hour, you get a sense of what's happening, then after him it'll come to sing and we'll come down this way. And hopefully by then we'll be done by 12 o'clock. Certainly we must be done with this by lunchtime, because we need to get into the meat of recommendations. All right, you back at 15:45? Thank you very much, honourable members. All right, we'll push for the next hour, see how far we are, but I think the general consensus is that at least if we've done with the broad deliberations by 1 o'clock on this topic, that we can then get into the meat after lunch in terms of the recommendations, because that's going to take much longer and it'll have much more it'll have much more personal considerations. That's going to take a bit longer. So lunch, I'm informed, will be at 1 o'clock, so we've got just over 60 minutes to do that. So if members can bear that in mind, and then our target is to have done with the broad deliberations at lunch, and then we'll get on to the other one. And towards the end, please remind me, towards the end we'll make a suggestion as to how you guys assist us in terms of the deliberations of today, without deviating from what we're doing now. But we will put a proposal on the table in terms of ensuring that we have a document that will afford us productive discussion on Tuesday. But we'll make that proposal later on. As we close, I think Honourable Kwankwa was the next, and then after Kwankwa we will go to Singh and come down this row and end up with Honourable Killian. Hopefully Honourable Killian will be the last before lunch, and then we'll move from there. We will go that way, come down, and we'll end that way with you, Killian. It's this way, and then we'll end with you. Honourable Kwankwa, the floor is yours. Your 10 minutes starts now, sir.
Well, thank you very much, Chairperson. The first issue that we'd like to highlight is what I think under issues of the board and its governance issues. It has to do with, we think it was an observation on our part, or I think we can put it forward as an observation that the board or the various boards that were at SABC seem to lack understanding of their fiduciary duties, as well as the understanding of the relationship that needed to exist between the administration and the board itself, and the board and the shareholder representative. I think that came out strongly in the testimony of Professor Maguva, even though he didn't state it like that, but his testimony demonstrated that there was a lack of understanding of that relationship. And I think maybe, Chairperson, since our mandate is to look into the fitness of the board to hold office, it could be elevated together with one of the points, paragraph 13.1.5, which speaks also something similar. They could be elevated more to the top of the observations, because I think they do speak to the mandate, to the mandate of the portfolio committee to some extent. I know it's not a finding or a recommendation, it's an observation. I was just saying. The other issue, Chairperson, is a matter whether, I wouldn't know, you'd guide me here, whether it would fall under recommendations or observations. During the testimony, remember, people mentioned or talked about the fact that the Guptas at some point attempted to rebrand the morning news show at SABC. Would we then not say that there was an observation that maybe there were attempts to capture this, the state or the broadcaster, the national broadcaster, you'll guide me, Chair, how you want to use it. I think the other issue, Chairperson, which is also very pertinent while we're talking under board-related matters, would be not only were we able to pick up and talk about issues that had to do with fruitless, wasteful, and irregular expenditure, but what we also picked up is that there were no consequences. You know, there were no consequences for those people who have spent money irregularly and wasted it. It should also maybe be captured as an observation, because it points directly to the failure of the board to play its role. Chairperson, if you then go to the role in particular of the shareholder, I remember that Dr. Koza mentioned, she said something about 13.2.2, where it says there were allegations that the minister was actively involved. She proposed that we put undue influence. I remember Kalidas, is it Kalidas or Kadilas or something? Kalidas raised. In her testimony, she used the word undue influence and being placed under duress. No, I'm just saying in terms of the right terminology to use in that sentence, Chairperson. We also have, if you look at Chairperson, there was an issue that we spoke about, the role of the minister in what happened at SABC, and to say that the minister herself, apart from her alleged or interference at SABC, she herself seemed to be not very clear about the bounds within which she needed to operate. That goes back to the testimony and the written submission that was made by Professor Kumalo, who said that shareholder representatives themselves seem to lack training, experience, and understanding of their role. I think, Chairperson, sorry to go back to the board again, I think that point is valid for board members as well, because as an observation, it seems that all of them lack experience, not all of them, rather, but some of them lack experience and understanding of what is expected of them. I think then, Chairperson, there's the issue where we're saying the mismanagement, the issue around state security. You'll bear with me, Chairperson, if this matter was discussed extensively in the sessions before I joined the committee, but we are citing it here as 13.4.7, for an example, as an observation. We're saying SABC employees were subjected to security agency interference. Was that an observation, or was it something that we just had? Were we ever able to test that or to look into that before we call it an observation? I'm just asking you as a question. Maybe what we might have to do is to find a way of rephrasing it so that it speaks to what was discussed and what we understood to be said by the people, because we might have to be able to make a recommendation on it. The failure, for an example, the failure by the minister to understand her limits would to some extent be what has caused her to communicate. I'm not making any excuses, but I'm saying that we could link that to 13.2.1. Going back and forth, Chairperson, there also seems on the part of the boards that have played an oversight role over the SABC to be a lack of understanding of the Broadcasting Act. And that also goes, for instance, for the executive, if you like. Where am I drawing this? Because if you look at the point which talks about the walkout of the management and the utterances that were made later on, there was a clear lack of understanding, first, of the mandate of the SABC, right? What it needed to do and what the Broadcasting Act says insofar as the commercial aspect of that mandate and what needed to happen. So I think it's something that we should also add, that both the boards, the board members, and the executive members, remember, because some of them are executive members of the board, they demonstrated a complete lack of understanding of the Broadcasting Act, and therefore one could say that including their mandate and what was expected of them, which then affected or made it impossible for those who were in the board to assess the effectiveness of the management. Remember, if they don't know what is their mandate and what is expected of them, it would not be easy to know whether they are going astray or doing what is expected of them. That lack of understanding, one could also argue, that is what contributed to the mayhem, where some of the managers thought that they were board members. They could act on behalf of the board and do as they pleased, and so on. That is all for now, Chairperson. Thank you very much.
Thank you very much. Honourable members, because we are deliberating, even if it's a point that was made by a speaker previous to you, you shouldn't feel restricted because it just shows the emphasis of the point that we are making. We will find a way of collating it, so no holy cows, both in what is in this document and what you want to put. The only request I would make, honourable members, is that when you introduce a brand new concept that might not be here, it helps us just to say, in reading this, this one is a new one, so that we are clear that it's a new concept that you are, or if you are arguing that we remove one totally, because it's not only about additions. Some of them that are here currently, you might feel are just inappropriate. You should be then saying remove it totally or add that one totally. But there are no holy cows. We'll argue them strongly on Tuesday. Honourable Singh.
Thank you, Chairperson. Chairperson, my understanding is that observations and findings would automatically lead to recommendations. So there may be some issues which I will raise here, which have already contained in the document, but I believe that they require emphasizing as observations for us to be able to make recommendations, that if the committee agrees. I want to start off where Honourable Kwankwa left about the evidence that was submitted by that Mr. Phil Molifa had discussions with TNA to establish a news channel. I think that's an observation that we need to note, so that, you know, if we make a recommendation to future boards, we know how they should handle these kind of discussions. So I'm just supporting what he said in that regard. I just want to go to the 13.2, the shareholder, and agree with Honourable Koza and Kwankwa that we need to, I believe, bring in a few more elements in what we observe there. For example, there was conflicting testimony by the executive authority and certain members of the board. And if you look at 12.3, the repeated 12.2, you will see what I'm talking about, where we got 12.2, where the minister denied she interfered in editorial policy, but then Ms. Khalida said something else, and the minister denied that she had signed the MOI. So I think we need to observe these things, so as we make recommendations, we can refer to that testimony earlier on. So that's something that I think we need, because there was no corroboration between what the minister said and some of the evidence what the witnesses had said. So I thought we should bring that in. Then, if we look at, I just noticed that 13.42 and 13.44 are repeated as 13.54 and 13.56 exactly, word for word. 13.42 and 13.44 are repeated as 13.54 and 13.56. Right? Then on the walkout, 13.52, I see we've got here that the board, the walkout by the SABC board on 7 December had shown total disregard and disrespect. It was not only the board. I think it was also acting executive managers and other officials, although we're not going to worry about the legal teams, but it was not only, I believe, the board, it was others that also walked out and showed disrespect for Parliament and the Constitution. Then on the issues that ICASA had raised. Now, ICASA had referred to the Charter, and then evidence that we've received, you've received, I have received, would suggest that there were unilateral decisions taken on programming content by certain individuals that might be ultra vires. And then we need to observe that so that it can be corrected moving forward. Further to that, ICASA had also given certain directives to the board, which they didn't adhere to. Because in their presentation, they say to us here that, I think it's a 20th May 2016 issue, where those issues were never attended to, but yet there were directives or injunctions from ICASA. So might just have to look at what ICASA had said to the board and how we deal with it as observations moving forward. So that's that. And then, of course, I've touched with the issue about establishing a news channel, because I think that's important for us to observe. Thank you, Chair.
Honourable Oliver.
Thanks, Chair. Chair, my first bite is on 13.5.3. I just want, oh, sorry. My first bite is on 13.5.3, Chair. I want to appeal to the team that is cleaning the document that instead of citing it as a reluctance by SABC to give out some documents, remember there are documents we never received. So it's not reluctance, it's refusal to give us those documents. Then in 13.5.6, over and above what is cited there, include in the same bullet or in the same note the issue of the payment of legal fees of Magove. Remember when we asked him, he said up to the 7th December, he understood the SABC to be responsible for that, though it was never something that he was bold enough to stand for it. My last bite, Chair, is on 13.8.2. I did, in the testimony that was given, I did not pick this thing of political interference coming sharply with every witness. It was in the case of Ms. Chabalala that she indicated that there was interference. And we are still having a question mark on that as it is already cited here. So how correct are we when we are promoting it to say it's gross political interference? My view was, let us not elevate it that much. Let's mention it without elevating it, because we base everything we argue on testimony given. Thank you, Chair.
Honourable Waters.
Thank you, Chair. Just on the fitness of the board, I think generally, as an observation, we've got, from myself, is that we've got to get people that are fit for purpose. And quite clearly, people have been appointed to the board on several occasions or several terms that are not fit for purpose. They're either there to do the batting of a political agenda, or they're there just to, close their eyes and go along with the abuse of the system. And so I think it's very important that as MPs we cite that as a finding, as observation, and in order to do a recommendation that the Portfolio Committee on Communications really jacks up the process of appointing, how they go about interviewing and appointing the board. Having said that, if I could move to 13.31, Chair, where it says there's urgent need for clarity on legislation that takes precedence in relation to the appointment of the dismissal of board members. The fact is we have a principled act, which is the Broadcasting Act. Where the Broadcasting Act is silent, obviously then people fall back on the Companies Act or the PFMA, whichever legislation is appropriate. But to say that there's need for clarity, there is clarity. People who claim that there's no clarity are using that excuse to drive their political agenda and to create confusion. There's clarity, the law's there. So I think we need to reword that section and tighten that up. Section 13.3.3, I think here we should just say this is in violation of section 96.2 of the Constitution as well as the Executive Ethics Code. I can get you the right section there. I should have actually had it right. It's 2.3D. Use their position or any information entrusted to them to enrich themselves or improperly benefit any other person. So there, and as far as 13.34 is concerned, we say here that the current funding model is unsuitable. I think we should change that to would appear to be unsuitable. If we go on to 13.41 about corporate governance, where it says the role and responsibilities of the GCO and the COO, etc., was not always clear, but it should be clear. They're supposed to have contracts, even if they are temporary. And in those employment contracts, the roles should be clearly stipulated. And if they adhered to the contracts, there would be no confusion. And people wouldn't be stepping on each other's toes and encroaching.
Hold on. I think we're losing you, but we get the point.
Am I
of view.
talking too fast?
Yeah.
I'm trying to say, okay.
After 13.3.4, you referred to the role clarifications.
Yes.
Okay?
And there, the employment contracts should clearly stipulate what their roles are. 13.4.2. Yeah, okay. That's a recommendation. Where am I? Yeah, I suppose it would be, but yes. I'm just then 13.4.5. Here we should say that the PFMA was violated here in contravention to the PFMA. I think we need to strengthen our case. Every time a particular act or the Constitution is violated, we need to state it, just so it strengthens our case when we come to recommendations later on. No. In 13.4.5, the PFMA was violated, or transgressed, if you want a more, what's the word? No, that's a weaker word. Having violation is stronger. 13.4.6, where it says certain executive members of the SABC changed the reporting lines. I think we should name those people. Do we have those names? When we say certain, I mean, did we ever get those names? Because it's important. If we did, we need to, I think it's important to say that, who it was. With regards to the, let me open my computer. The State Security Agency, we must put in 13.4.7, Chair, we must please add state in state security and the interference that occurred. Honourable Kwankwa asked, did we ever get evidence to this regard? If I can just read this paragraph, please, from Right to Know, is that in January 2014, the SABC chairperson, Mrs. Shabalala, reportedly told staff in an editorial meeting that their communications may be intercepted by intelligence services, apparently in relation to perceived information leaks. This incident was made public by the representatives of the Broadcasting, Electronics, Media and Allied Workers Union, and at the time was reported to the committee by Mrs., and I hope I pronounce the following name correctly, Hubile. Is it right? No, it's not. Anyway, submission. According to accounts at the time, so we got the submission here, so we've got the information. According to the account at the time, Mrs. Shabalala incorrectly cited the SABC's office status as a national key point to justify possible what's the word I'm looking for? Possible interference of communications. Right. So we do have evidence in that regard. And I would say in 13.4.7, we do tighten it up. It says here the SABC employees were subjected to state security interference, whilst the more important task of vetting of employees was neglected. So what this gives the impression is that it's okay to interfere with officials at the SABC, but they should have actually just focused on the more important task of vetting. And I think that needs to be tightened up. Do you get what I'm saying? So we need to look at that. Okay, as far as 13.6.3 is concerned, again with the State Security Agency, I think that is, I've written notes here, but I think that's a recommendation about who gave the order, etc., and why were they there, so that we can talk about later. This 13.7.1, Chair, the Portfolio Committee on Communications lacked the urgency in addressing the removal of the 3 board members. They didn't lack the urgency, they were derelict in their duty as a committee. They didn't lack any urgency. They turned a blind eye, quite frankly, and allowed the minister to continue to abuse the system. And I think we need to say that there. They were derelict in their duty. Yeah. Okay, and that's all I've got to say, Chair. Thank you.
Honourable Van Dam.
Thanks, Chair. I'd firstly like to agree with Honourable Khoza in that we include a recommendation, include an observation about the Broadcasting Amendment Bill. And that is something that we can discuss further then in recommendations. And then I'd also like to include under section 13.6, a section on the 90% local content and 70% local content on TV news, how we received evidence that the SABC board was not consulted on this decision and that it was a unilateral decision by the COO of the SABC. And then on the role of the shareholder, 13.2. As I usually do, I would like to include what sections of law the role of the shareholder in this whole saga, what laws that violated. Now, it's common cause that the Minister of Communications is not allowed to interfere in the affairs of the SABC. Her role in communications is drafting and publishing communications policy. That doesn't mean that she has her role with the SABC and her entities is hands-off. She has control in the form of oversight. So the fact that she interfered in the affairs of the SABC by encouraging them to appoint this Mr. Motsoneng as COO is a violation of section 92(3) of the Constitution, which requires her to provide Parliament with full and regular reports concerning matters under her control. So she's violated the Constitution there. By interfering in the SABC, she also violates the Executive Ethics Code, particularly section 2.2D, which says that she may not use her position or any information entrusted to her to enrich themselves or improperly benefit any other person. By influencing, 2.3D, by influencing the SABC board to appoint Mr. Motsoneng, she used her position as the minister to unfairly influence the SABC board and unfairly benefit Mr. Motsoneng. So she's therefore also in violation of the Executive Ethics Code. She's furthermore in violation of the Powers and Privileges and Immunities Act, particularly section 2E. And she violated that section by refusing to give Parliament full disclosure on what happened at the SABC. She claimed not to know anything, she wasn't involved, when evidence presented to us was very clear that she interfered in the appointment of Mr. Motsoneng. She told board members to report to her directly about whether or not they should continue to be employed at the SABC. So she interfered. And by doing so and not being honest with Parliament, she's violated the Powers and Privileges and Immunities Act, and I'd like that included in our observations, and I'm happy to type that out for you.
All right, just as a general rule, members, there where you refer specifically to whatever legislation or whatever, if you could assist us with it, that, or everybody, PFMA section 38(1)C or powers and privileges, just assist us when you when you supply that to us, and we will try and fit it in at the proper place. Honourable Chauke.
Thank you very much, Chair. I'll start with 13.51, Chair. That deals with the accountability. In the first line there, Chair, we identify a administration leadership. I want to propose that we, as the accounting authority, we put it as a board rather than just putting a general administration leadership, which is the first line there. But just to emphasize on this paragraph, Chair, if you will recall from evidence that day, especially what the Chairperson Maguve said, that they were reluctant to appear because they derive their funding from public, not from public, from advertising and all of that. Therefore, only 3% of the funding comes from government. I think it's an area that need to be re-emphasized, to the fact that even whatever that they raise outside still belongs to, it's still public money. So therefore the issues of accountability becomes very critical. Now, Chair, in our engagement, you'll remember what led to Ngubane to come in. The mandate was to deal with the current board, but we end up having to go back to the previous boards. And I think maybe it will be a new area that we'll have to look at, in a sense that problems started from the Ngubane board, because that's where you begin to see breakdown of the law. There was an SIU report. Obviously, we have not gone into the detail of that SIU report that led, in fact, to the collapse of that board. But it's important that we sort of reflect of this systematic mismanagement and how a number of boards, in fact, have collapsed throughout the process. Then you look at the next board that followed, the Ngubane board becomes the Chabalala board, interim board, and you look at its activities, Chair. I'm not going to be specific to any of the points here, but I said these are new areas that we'll have to look at. The entering of the multi-choice contract from the interim board and the contestation, therefore, since from that end, I think it's an area that we'll have to look at, Chair, meaning that in the incoming interim board, because definitely we'll have to recommend something. We must be very clear as to what is it that, when you go to recommendations now, what is it that we'll want to recommend the interim board to look at specifically coming out of this particular engagement? Because I'll believe that, Chair, if we don't do that, we may have failed, in fact, to instruct and to give direction in the process, and will not be able to dig deeper into these systematic problems that have picked up, politically and administrative, meaning that you look at the minister, starting with Diana Pule, the minister, what happened and what led her to be removed as a minister there, and then you can cite them throughout. Till today, this level of interference between the issue of accountability, separation of power, that understanding will have to be clearly sort of defined as we move to the recommendations. Now, the process of appointment of the board chair, it's an open process. Members of the public participate. Maybe we want to emphasize a point so that it's not a closed thing, but it's a well-open thing in the process that members of the public now know, like we have done with the public protector. But the issue that I want to bring in here, Chair, is that through evidence before us, the role of state security has been misplaced here. The state security has been playing a role of dealing with issues of human resource. You know, interviewing, harassing, engaging at the lowest level without dealing with their core mandate, which was firstly to deal with issues of a clearance. You know, so in the new process, what we'll expect, maybe it's a new insertion that we'll do, maybe it will come again to the recommendation, Chair, will be to really identify at what point does state security comes in and what role will the state security play in the process of the nomination, so that by the time you finish with the nomination of members of the board, state security will have cleared them by that time. So it's an area that will deal with it when we move to the issue of the establishment of the new board. So those are just my few points for now. Thank you very much.
Honourable Kelly.
Thank you, Chairperson. Chairperson, first of all, I believe that paragraph 13.3.3 should actually be relocated under shareholder because it refers to the level of ministerial involvement. So that's just a suggestion. And Chairperson, I think I would like to advocate that we reconsider the headings. I have mentioned it a little earlier, but obviously I'm not hard and fast on it. We can look at that again on Tuesday. Maybe we can collapse everything because as it happens now, we've seen there are duplicates under specific headings. Maybe we can actually just list our sort of observations. But let's look at that on Tuesday. Chair, I would like to suggest that we also look, if we maintain the headings, if we can perhaps reconsider the 13.3 heading. And I'm not 100% sure. We make reference to governance under 13.4 as well as under 13.3. On the one side, we're saying legal status and governance. On the other side, we're saying corporate governance. My suggestion would be that we actually relook that and perhaps talk about legislative frame or non-compliance with legislation or something like, and on the heading of 13.3. I would like to also suggest that 13.3.1, that we take line, sentence 1, and actually relocate that to recommendations. Because we have found under observation that there is an interchangeable use of the two acts. And then from there it moves on to the MOI and its amendment, etc. I agree with would appear to be unsustainable at what Honourable Mike Waters has said as far as the funding model of the SABC is concerned. I'm, however, concerned because we should make reference to appear because we did not really have anybody who provided adequate evidence that this is the financial position, you know, etc. So I think we should rather steer away from just making such a pronouncement. We can make reference to appears to be. Chair, then I would like to go to 13.4.1. I would suggest that we use there the role and the reporting lines, role, responsibilities, and reporting lines of the group chief executive, or we can just make reference to the executive committee. Was unclear. Was not clearly delineated, and performance management contracts appear not to have been in place. There was a policy, but evidence before us was that there were no performance contracts and performance bonuses were just paid willy-nilly without, evaluating the performance of the individual. Also, Chair, I would suggest that we capture the heading under corporate governance. This is more a management matter. And if I look at that, it is contained in the Act where the role and responsibility of non-executive and executive members are also clearly indicated. And I think we should have a separate paragraph in addition to the group chief executive, the chief financial officer, chief operating officer. We should have a paragraph which referred to the role and responsibilities between executive and non-executive board members was diffused. Reason being that Section 14 describes that the executive committee is accountable to the board. And that did not happen. There were different people that led evidence to that effect. And it goes further, Section 14, stating that the executive committee must perform such functions as may be determined by the board. Now, because of the roles, the confusion of the roles or the diffusion of the roles, that did not happen. So the board did not hold the executive committee accountable. And that actually contributed to their own failures. Then there was general non-compliance with existing legislation by the executive. Yes, the board is the accounting authority, But clearly, the permanently appointed executives are responsible to follow the PFMA, to follow Treasury regulations, to follow the Act, for instance, revision of policies. They have no authority to revise policies. It must be presented to the board in terms of the Act. So there was clear non-compliance with the Broadcasting Act and with the PFMA. Then I also wanted to bring in, and I don't know exactly if it falls there under legal, but we should just pin in the ground our concerns about possible risks for the SABC with regards to board meetings where there was either lack of a quorum or where no decision of the board was taken to implement or to contract on behalf of the SABC. The flouting of supply chain management has dire consequences, and we will have to pin it down so that we can take the matter forward to the interim board to review board decisions and to take corrective steps so as not to expose that authority. Chair, as far as accountability is concerned, I think we can say in 13.5.1, the SABC, and we should rather have board and executive committee instead of administration, did not understand, I would like to insert, understand the public mandate in terms of the Charter and the Act, and did not feel the need to account to Parliament owing to the fact that the funding from the National Fiscus was minuscule, owing to the fact that in their view, the funding from the National Fiscus was minuscule. Now, remember, it is not about how big the funding is from the National Assembly. The public mandate lies in the Act and in the PFMA, and they must account to Parliament. And there was some other lack of understanding. I would like to add that line under 3.5.1 to say, this demonstrates a total misunderstanding and disregard for the Broadcasting Act, the PFMA, and Parliament. Maybe we could say the Constitution, I don't know. Then, lastly, Chair, I agree that we should move parliamentary oversight. But then when we move to, to under the shareholder, and then it's just as far as testimony is concerned, I would like to suggest that and actually we should have it throughout. I would prefer us using the term, when we speak about the board, not interchange it with terminology such as accounting authority, because then sometimes we can confuse matters. Because the PFMA makes the board the accounting authority, we can perhaps emphasize the board as the accounting authority, but we should never use the accounting authority. We should instead use the board. And yeah, so that is as far as that is concerned. Thank you, Chairperson. I'm prepared to make some of my proposals, I'm prepared to submit it to the administration so that it's easier to understand where what fits in.
Thank you, honourable members. The threat of spending the long weekend in Cape Town has lots of magical effects on members. All of a sudden we did everything. But honourable members, thank you very much. I can tell you that that we've got probably 4 pages of this hardcover with the points that have been made. Of course, some of them might have been duplicated. We will try and collate it. I'll come to you, sir. But just where members have referred to specific sections, if you could send that to us so that we don't have that problem. And also where members want to introduce a new subject, as much as we've tried to capture it, if you could just put it in. I'm saying if it's a brand new one, if you could put it in, we'll put it there, and even if we mark it as new, so that you've got it. There weren't too many of them, but if there were, You all have our email addresses. If you put it in there, it makes our life easier because it's brand new. Your wording would be more understandable to everybody else. So if just generally, and this will go across to even the next section. So where they are brand new, if you could actually try and type in the wording. The rest, I think we will attempt to put together as best as possible, and I'm informed that it's doable, on condition that you give us specific reference to the sections of legislation that you have alluded to or you have raised here. Honorable Mokoena.
No, Chair. Yeah, it's just something I spoke to you about earlier on, but I think I need to make a public note of it. It seems that the advisory board to the minister was established recently, and I think we need to correct that. But then the recommendation would then be that they must be more active in their work. Yeah, we don't even know who they are, so maybe that process needs to be investigated as to what happened there. But they need to be more active so that they can assist the minister in her thing. Can I add one more thing? Yes, you may. Given the evidence that we received from various witnesses around the issue of TNA, New Age Media, the rebranding of the SABC News channel, and so on and so forth, it is my submission that we should recommend, that the committee has observed a possible state capture. Was it there? Thank you very much. Thank you, Chair.
All right. I'm not going to add anything except just to, it's a thin line between grammar and maybe content, but it's more content. If members go to 1314, in our document, Cindy, we have fruitless and wasteful expenditure incurred, 5.1 billion. That's actually not correct. Fruitless and wasteful is about 92 million. That 5.1 billion is irregular expenditure. There's a major difference between fruitless and reckless, and fruitless and wasteful and irregular. So if we could correct that, irregular is 5.1 billion, fruitless is, I think it's 92.3 million or something like that. So I'm saying the rest, I'll leave to your wisdom. We will capture your one. Honourable members, you've had a sense of what is coming out. We've got 25 minutes before lunch. Now, I don't know if there were things that you suppressed because you were trying to measure your time, although many people, without being suppressed, were well within their time. We can use these 25 minutes to try and narrow some areas where they are clearing whatever, so that it helps us. Otherwise, if somebody's got a brainwave of something else that you want to put in, you've got 25 minutes. But if you're going to go the brainwave route, then everybody's going to have just one bite. But if you're going to go the route of trying to reach some sorts of committee position, especially where there are very clearing ones, then we can open it up for general debate. So I'm not sure if this is a brand new thing or you want to go to try and narrow some of these things down. Choker.
No, maybe mine is a small point, Chair, under 1371, on the issue of the role of Parliament. Through the witness presentation, in particular the former Chairperson Chabalala, you remember there was clear that there was already a stalemate between the board and the committee, which in fact again led to that issue of her qualification, which was reported. I'm not sure how do we locate it, Chair, that the stalemate between the board and the committee, because it's not purely that the portfolio committee failed to do. Yes, I know that and link it up again, Chair, with this failure to recognize or to accept accountability because therefore we are not funded, we are not using state resource. Can we maybe try and break something out of that? Chair? If not, then I'm still fine, but I wanted to bring in this issue of stalemate between the board and the Committee of Parliament. Because it's not just purely that the committee did not want to do its work or did not do its work, but there was already an attitude towards the board that failed, in fact, to comply and working with the committee with all the issues that were raised by the witness, Chabalala. I'm not sure if we were to deal with that or we can just note it maybe somewhere it can fit, I'm not sure.
I thought somewhere a member raised the, and whatever word you've used, whether it was, I don't know what word you used, Honorable, I think it was you, Watchers. Somebody said they were not effective, and then you used the word of, I think, derelict or something like that. Would it not fit in there? Because surely there can't be an argument about the board unaccountable to Parliament. Surely it can't be an argument. I mean, just now everybody was saying, where there's no argument for instance, which law takes precedence. We shouldn't even put it here as if we have doubt. Now, I don't think there's a doubt between, there can't be a stalemate. It just cannot be a stalemate between the board. And if there is a stalemate, I'm sure we've said the committee, us, not that committee, Parliament, needs to understand its role. I'm sure it'll be covered there. I'm hoping that it'll be covered there. If it's covered there, it's fine. All right. Are there any areas that members would want to attempt where maybe where we are too far apart or maybe where we're very close together where we can just kill? I mean, there's this one about dysfunctional and non-existent. We can take a decision and then the legal people will come back and say the correct word is so and so. But as things stand now, we're going to put in our report the board was dysfunctional stroke non-existent. I'm sure we can put one thing and the legal people will give us the correct word. So it helps us in our going forward. I'm saying that is just one of them. So I'm saying there are very many where we are very close together or there are those that we might be further apart. I can tell you now that I don't think there's confusion that all over we'll take away the impression that this committee doesn't know which is the supreme law. We can put there and say there was a observation that others didn't understand it. But we can never ever say there that Parliament didn't understand which took precedent. Is there agreement on that one? Is there agreement on that one? I'm saying where it refers to Parliament, we are very clear that it's the Public Broadcasting Act, and we can't then say that for them. So if there's that clarity, we can tick it off here where it refers to Parliament, but we will leave it where there was clear differences. You want to talk? You wanted to say something? Somebody? Oh, sorry, Mr. Singh.
Thank you, Chair. Not related to observations, but it's an observation that right at the beginning, when the committee was constituted by Parliament, we started sitting, and there were some challenges with the court and things like that. Now, we haven't made any reference to it in the beginning as part of the story for parliamentarians to know that we did sit, but we adjourned and we did whatever. I don't know if we should include that as part of the narrative of the history of this committee from the time it started. We just go into the history from the time we called witnesses, etc., etc., etc.
Okay. Remember, if you look to our document, there's something called introduction that we've left blank. So when we populate the introduction, we will fill in some of these things, but we deliberately left it blank until the very last minute. So we will couch it under there, that type of thing. Any generic views, and maybe let's just deal with the generics now. To our colleagues in the gallery, this is the ad hoc committee that is looking at the fitness of the Board of Parliament. I'm sure you're aware of it. And if you're not, I beg your pardon. Not the fitness of Parliament. That is the role of the Constitutional Court and you as citizens, but it's in relation to the fitness of the board. And we're busy deliberating. So you're more than welcome. And thank you for showing some sort of interest there. You are welcome. Dealing generic issues or Or just allow you guys to exhale. You've got 15 minutes to exhale. Please remember your numbers. Okay. Mkwena, man, you're bullying me, Baba. Mkwena, and then Swartz, and then Kubis, and then Chauke.
No, Chair, I think at the hearings of the Portfolio Committee, when two members of the board resigned, that committee became non-existent. I mean, the board. I think it was non-existent even before. So I think, at the commencement of this committee, there was no board. So I think that must be made clear, that it's non-existent. And that is the observation of this inquiry since its establishment.
Wherever we have dysfunctional, we'll say non-existent. When we refer to the board post October the 5th, that's what you are suggesting. All right, I will do that. Mr. Swartz.
Chair, there is an issue which has been alluded to, but maybe one can capture the whole issue of how the board has failed to look after its staff. Now, there are three elements to that, and one has been related to, and that is the purging of staff members, as is pointed out in the Public Protector's report, but it's a continuing, and that is indicated in some of the documentation we received from SOS. So subsequent to the Public Protector's report, that is continuing. So one could say something, that's the first point, the way that the SABC 8 were dealt with from a labor relations perspective. And then thirdly, the whole issue of the status of the independent contractor agreements, where we received that lengthy document from a large number of staff members from the SABC that have indicated that they were promised that the independent contractor agreements would be converted to employment contracts, and that has not yet happened. Some of them have got up to 30 years experience. So those are three elements that we can make as observations. Obviously, the last issue of the independent contractors is important. It has financial implications. That is important. So I'm just putting it to you as a general, I don't know if it's sufficiently covered already, but I don't think anyone has alluded to the undertakings that were given by the board to convert those independent contractor agreements to full-time employment. And there's a reference in the Auditor General's report where they are paying increased tax of 25% as opposed to the 18% they would be paying if they were fully employed. So it's an issue that goes across the board for SABC staff, and I think it's important for us to make that observation. And that having, and again, Chair, there's been a lot of criticism of the SABC, but we need to remember there are a lot of very loyal and hardworking people on the SABC.
Agreed, Chair.
And that is an element, we need to highlight that as well. I mean, we watch sport, we watch a lot of SABC programs, and it's commendable that notwithstanding what's going on at the top level of the SABC, there are still some incredibly hardworking people, and we need to acknowledge and commend that as well.
Chair. Thank you, Chair.
No, I haven't recognized you. And I'm trying to think about what Mr. Swartz is saying, and I don't have a problem with the sentiment. I just don't want this committee to be dragged into, let's say, labor relations issues and so on. And I'm not saying you're dragging us into that, but we must not become a whinging session on the one hand, and we must also not become a session where there's labor relations. But we'll take your point, and again, we'll argue it when we sit on Thursday, because remember, ours is a very specific role, but you've noted them, have you? We've noted them. So I'm saying as people speak, because you've got 10 minutes, let's try and stick to what it is that we were intending to do when we were started. After Swartz was Kubisi, Chauke, Killian, and then Van Dam. Kubisi.
Thank you very much, Chair. Just wanted to say it's very important that as a committee we make ourselves as clear as possible. For instance, when I read 13.41, it says the role and the responsibilities of the Group Chief Executive Officer the chief financial officer and the chief operating officer was not always clear or adhered to. Now, somebody reads this, will ask, we have this individual working within an entity, SABC as a legal persona. Now, what do you mean? Do you mean lines of communication? Do you mean lines of control, administrative lines? What do you mean by this? So, I'm saying, therefore, we need to be as crystal clear as possible. What is it that is meant? Because the CEO, Group CEO, is an individual in an institution with particular responsibility, and the Chief Financial Officer, COO. Does it mean that the lines of communications or control lines were blurred, or it was the usurping of the lines of communication by the other party? So I'm just taking note of that, Chairperson.
Yeah, now all of you must be chairpersons, then you'll understand that you need to listen carefully and maybe pick it up. I think it was Killian who said, let's clarify it and say lines, reporting lines. So I'm hoping that covers you. It was exactly on that point. He said, let's make it reporting lines. So it has been captured, but we concur. You're basically emphasizing what Honorable Killian has raised. Honorable Chauke.
Thank you very much, Chair. On the issue of the public protector, Chair, I know that the colleagues have already dealt with this part, but we may have to find expression of maybe from the recent judgment by the Constitutional Court, especially the expression around the constitutional democracy can only be truly strengthened when there is zero tolerance to culture of impunity, the prospect of good governance are duly adhered by enforcing accountability, the observance of the rule of law, and respect for every aspect of our Constitution as the supreme law of the country. Maybe as we close that whole exercise, Chair, we'll have fulfilled this particular mandate as instructed, in fact, as advanced by the Concord, meaning that the role of Parliament here has taken that particular position. I'm just throwing it, it's an issue that I think it makes a lot of sense for us with the work that we have done so far, that we have met this requirement and we are making sure that there's adherence to the rule of law.
We're not going to even attempt to do it. You'll add that we don't have a problem with it as a committee. Also understand, members, that at some point I'm sure some of you are going to participate in a debate in this thing, so don't take your debating material and put it in here, but it's fine. We will remind you. That's a nice closing for your debate, or opening for your debate, but we're not going to put it in our report now, but if you feel strongly about it, we'll find a way of that being an underlying or overriding lesson. Honorable Killian. You've got 2 minutes, and because after you, Van Dam will also have 2 minutes, otherwise you,
Fine.
at 1 o'clock, say, 2 minutes maximum.
Chairperson, no, the matter actually just resides about the role of Parliament, parliamentary oversight, and obviously it actually belongs more in the recommendation section, but I just thought let's just reflect on that a little bit. Typically, members are appointed to a portfolio committee, and the problem with that is that they are not always properly inducted with the sort of legislative framework within which they have to operate. Now, Honourable Swartz has referred to shareholder induction, but I think we should also take the matter forward to parliamentary support and members' induction. So I just wanted to park that issue. Second issue that I wanted to bring in is under the shareholders paragraph, the responsibility to can I say, conduct oversight over the entities without interfering. That thin line. It would be interesting to see what comes out in our next draft, but I think we should make the comment there that in all three role players, be it the board, the executive, and the shareholder, there was a confusion of roles and responsibilities. So perhaps we should just add that additional matter as to confusion of roles and responsibilities, because that also contributed to the failure of the board as well as previous boards.
Yeah, we can add that, but once again, I think there was somewhere we spoke about separation of powers and responsibilities. Somebody mentioned it earlier on, but you're just emphasizing what somebody said. You'll be the absolute last, Ms. Van Dam, and you promised me you only had 1 minute, isn't it?
1 minute. As my usual obsession with the law, we said we were going to be quite firm with people that misled us as a committee. So under 13.81, can we just say that in instances where information was contradictory, resulting in possible perjury, perjury would be in violation of the Powers and Privileges Act, and I will include the relevant section in my notes.
All right. No, just from, no. See, now there's brainwaves. We said she'll be the absolute last. Just from an education, because they keep on asking us this question, and you'll assist all of us, because all of us are going to ask this question. You know, somebody has always said to me, Smith, you guys keep on saying that where there's guilty of perjury, what happens? You are saying to me the powers and privileges would apply even to non-parliamentarians. Is that what you're saying? Yeah, no, I'm just saying, just from an educational point of view, because I think it's interesting. We can't say we'll throw the book at you, and when somebody says, how does that book look like? It's a common law project. Okay. So I'm saying the point that Van Dam is making of powers and privileges. I'm just asking that question because if it's already catered for in common law, then it's fine. Or if you're saying the powers and privileges just strengthens the common law, then it's also okay. So you agree that it's...
I mean, the Criminal Procedure Act deals with perjury in general, but powers and privileges deal specifically with Parliament. And it doesn't only apply to members of Parliament. The section I refer to, for example, is 17(2), which says that any person who, whether or not during examination, willfully furnishes a house or committee with information or makes a statement before it which is false or misleading, commits an offence and is liable to a fine or imprisonment for a period not exceeding 2 years, or both fine and imprisonment. So it applies to any person, not just members of Parliament.
So you'll just give us that you've got it, the section in the powers and privileges, and we'll say it's covered both in powers and privileges and in common law. That's fine. Yes, ma'am.
Sorry, Chairperson, I just want to correct something. The common law actually is normally applicable to courts, so the Powers and Privileges Act gives that additional power to Parliament. But in terms of the Constitution, those would be ordinary witnesses. Members of Parliament have the normal privilege in terms of the Constitution.
No, that's fine. We'll add it there. And I mean, these people that are cleverer than me and most people except Swartz will tighten it up even before it goes anywhere else.
Chair? On the point of
Baba.
someone's...
Wait, hold on, I'll allow you, but we thought Van Dam, no, it's fine. All right, Baba, you'll be... All right, so you see, that's why when I take a decision and then people mess us up, then I open myself up. But it'll be you, and then Chauke, you'll be the absolute last one.
Chair, one of the witnesses that came and gave evidence about 100 million rand improper expenditure, when the minister came and said that witness will now be charged in terms of the Corruption Act, and that obviously we need to make sure that we emphasize that witnesses cannot be charged for what they said in this House because they are protected. And that's the whole reason why, and I just wanted to allude to that. That is an important point as well. because that
Okay.
witness gave evidence here, and that witness is protected.
All right. That's important because it's not only about, Parliament is not an end in itself. This is also public education to the people who are watching us now that, in fact, there is protection if you hear, so you can't threaten somebody who said something in here, especially under oath somewhere else. There's another one for public consumption that, in fact, perjury is implementable, or the guilt of perjury is implementable, as per the education we received from Van Dam and our legal team. Thank you very much, and you, Honorable Chauke, will be the very last.
Now, Chair, the individual cannot be protected once we have issued summons. I think throughout our deliberations, observation, Chair, it's clear that certain documents that we have requested, they have not been forthcoming. And therefore, I think it's something that before we finalize the process, especially on the company secretary that we have mandated through summons, we'll have to deal with that part, Chair. That will be the first action that we must take, failure to comply with summons. So I think the legal team will have to look at that so that we begin to enforce that particular area of compliance. Complying with Parliament and its work. Thank you.
All right. We're going to go for lunch until 1:30, 25 to 2 at the absolute latest. To the legal team, and nobody mentioned it here, maybe you implied, but you didn't mention it as honorable members. From where I was sitting, there was consistent bad advice given to the chairperson of the board or to the secretary of the board. If you take this last point, they didn't come and say they don't want it. On a letterhead of an attorney, it said these are sensitive documents. Now, none of you raised it. I need the legal team to look at it. At least in three, I forget the name of those. I think it's Sekiso or somebody, I don't remember. I need you guys to come back before or by the time we meet on Tuesday, to be able to say to this committee, what is it that we can do legally to a law firm who, on their letterhead, made statements that these are commercially sensitive documents. The minister comes and says, in fact, they're not. In other words, it can't be just bad legal advice. Was it complicit? And those type of things. And specifically that lawyer, because I think we have evidence of 3 letters on the lawyer's letterhead where they were obstructionists. So I'd need you to come and give us some advice on it, because I made an undertaking that I think my words at the time was, they owe Parliament big time. It's payback time. We'll break for lunch and we'll come back at the absolute latest at 25 to 2, and we'll get straight into our recommendations. I did mention to all members, if you've made travel arrangements for anything before 6 o'clock, use these 45 minutes to change that, because it's not going to happen. Before you leave? Yeah. All right, no, I was just getting education. We are back here at 25 to 2. All right. I think there's the normal arrangement. Yeah, thanks. Here? Yes, you may. Honorable members, can we continue? Yes, silence means yes. We're done with deliberations. We're done with deliberations of the observations. And those will be captured as best as we can. We also did earlier on, and maybe if we didn't, we would request now that because we're all online and computer literate, you'd assist if the points that you made and you feel strongly about, if you could also just send us those little bits electronically, because it'll help us to try and edit and coordinate, besides the non-negotiables, which are the section-specific references. But as you've made your inputs, if you give it to us, it also assists us. Cindy, I think, is trying to edit as best she can, online or real-time. But there were some that if you could reduce them into some sort of electronic version, it also assists us in our own preparations or compiling of the documents. If that can be done, I mean, those that have them electronically, you can start sending them right away if you do, and we will try and put them together. Honourable members, we then must move to, I'm trying to find the page number. Again, I think what we would do, and I have it, so I'll find it now. I'm not sure, we did indicate that we're going to, in this round, with as much speed but without compromising the quality, because this section is the section that all of us will have to defend once it's adopted. I think it needs far more attention, far more patience, and far more clarity. Once again, just to reiterate that, of course, members will argue their positions, whatever the position might be, on recommendation 1 up to recommendation, whatever it is. We'll listen to them, we'll try and do what we did yesterday, get clarity. If we are very far apart, we will then park them and, of course, finalize them tomorrow. But with those that we can conclude today in terms of coming together, all the better. So that is it, honourable members, and also for those that are observing proceedings, whatever is said today is not the position of the committee. I think it'll be various positions, even if we have reached consensus, because it only becomes the position of the committee once we adopt it, and hopefully we will do so on the 24th, after 2 o'clock. Van Dam, your time is still 2 o'clock, is it? Yeah. For the sake of logistics, we will try and book out from 2 o'clock until 6 o'clock for us to process on Tuesday. Cindy, if we could do that. But you will get the normal notifications, but it will be probably from 2 until 6. So please don't feel restricted in any way. In terms of the points that you want to make, we will convince each other, and where we can't reach consensus today, we'll have another bite at it tomorrow on Tuesday. But whatever comes out today, we of course will capture and try and reflect in the reports that you will get. Our own practice, and I suspect we will continue it, is that members will get a copy from ourselves by 5 o'clock on Monday. By 5 o'clock on Monday, we will give you draft 2 which members will then have to go and workshop wherever you workshop it, because on Wednesday, I beg your pardon, on Tuesday, we'll have to hammer out a position one way or the other. So we will attempt to get them out to you by 5 o'clock on Monday, and on Tuesday we will consider them after 2 o'clock, and hopefully by Wednesday we will be able to, if all things go well, by Wednesday we'll be able to release them for comment to those that would wish to comment. Give those that wish to comment between Tuesday and the 9th of February, by which time we will close any submissions for comment, because we would need that time to then at least reduce those comments into writing for yourselves. Send that out to you as well, and you then look at our report plus the comments, and we'll argue on the 14th whether we want to take those comments and assimilate them into our report, or whether we don't think it is necessary because we've covered it, or we don't agree with it, because at the end of the day it is our report as MPs, but opportunity is forwarded to those that want to comment. So that's going to be the process very optimistically. We know that things change and are dynamic, but we're hoping to be done by the 15th, I beg your pardon, by the end of business on Tuesday, and those that would want to comment will then be able to comment. Exactly how we will make the document available, I'm hoping the legal team will give us some advice so that we are not accused of making it available yet it's not available. And exactly whose comments are we going to accept? Because I suspect the whole of South Africa will want to comment on it, but the question is whose comments do we consider? But all that will be clarified as we release the report on the 24th. So having said that, honourable members, page 32 is the recommendations. Oh, I beg your pardon, let's take Mr. Singh.
Yeah, Chair, thank you very much. Just on the dates, I was just looking at the tablings for Cindy. They've got Tuesday's meeting from 10 o'clock to 1 o'clock. So maybe you have to get that corrected in the things they send us. And then on the 14th, I think one of the dates we had planned was 14th and 15th. 14th might be a bit of a challenge, well, for myself, because that's when all parties and party leaders are responding to the president. Yeah, morning's fine. Yeah, but not the afternoon, if we had thought about the afternoon. Even 15th, the responses will continue. So it has to be the morning. Thanks.
Right. No, thanks, that's very helpful. So on those 2 days, the 14th and the 15th, we'll schedule morning sessions from 9 until 1 o'clock. So if you are participating in the debate later on, there is no excuse that I can't make it because I'm in the debate. We will need a quorum when we adopt the report. So if you're going to prepare for that afternoon, please be prepared prior to the meeting so that we do not deplete the numbers in terms of having a quorum, especially on the 15th. Especially on the 15th when we are hoping to adopt a committee position, ad hoc committee position. Having said that, honourable members, let's... I wanted to check, and I know we took a decision that we're going to go as comprehensively as possible. So in other words, my understanding is if you went to page 32, for instance, we'll ask the question, is there any changes to point number 1, point number 2, point number 3? When I say number 3, I'm saying 14.13, 14.14, 14.15. We will talk to that. We'll then ask for additions, if there are any additions, or deletions, if there are any deletions. Is that how we all understand the process, or do you want to do the entire 14 line by line, clause by clause? And then when we do clause by clause, we will just recognize those that want to speak to that clause. It's not going to be automatic that everybody wants to speak to it. So we'll do clause 1, and then clause 2, then clause 3, clause 4, clause 5, up to clause 10, or whatever, yeah, clause 10, as it stands. Then we will make additions on the basis of maybe input that we've got now, or whatever the case might be. That's our understanding. Swartz, you seem not, you happy? All right. And again, once again, I mean, if things don't work out as we go on, we will be flexible as we go along, because this is uncharted grounds in that we don't have the additions before us. Let's go to page 32, honorable members, and everybody on 32 should have the heading 14, recommendations 14.1 board meeting. That's the one we have, isn't it? All right. As is, in other words, without any of the amendments there, 14.1, does anybody want to comment on it? Singh, Van Dam, Swartz, and then Killian, in that order. And can we also, oh, everybody wants to speak, but because we're all speaking on it, can we agree on a time that we speak per clause? 1 minute? 1 minute per clause. Is that okay? Okay, all right. Can I just, sorry, did you note the hands? Yeah. All right. We had noted Singh, followed by Van Dam, followed by Swartz, followed by Killian. Anybody else on clause 1? Just clause 1. And then Mukwena.
Thank you very much, Chair.
No, are you raising your hand? Yes. Okay. Okay. Honorable Swartz.
I'm in blue.
See how you blue today.
I made sure it were.
Honorable Singh, close 14.11.
Yeah, Chairperson. Yeah, I just want to know here, I mean, is there a board? I'm asking a question. There is no board, so what are we there to dissolve? So that's the point. And it's linked to 14.15 as well.
14.11 is removed totally. Agreed? And Mr. Singh is proposing that 14.15. 14.15. 14.15. He's suggesting that we treat it the same way as we treated 14.11. No, if not, it's fine. That will be Swartz's position. He's withdrawing. So 14.11 we remove. Agreed? All right. Anybody wants to talk to 14.12?
Chair, 14.11 still.
Oh, I thought we said we all agreed on 14.11. Let's remove.
It's an addition, because surely at this stage you've got to recommend the urgent appointment of the interim board.
No,
No, but this is what.
no, but hold on.
You are now speaking.
Hold on, honorable members.
So I was going to suggest the addition of that.
No, hold on. I thought we agreed we'll go to them as they are. And if in removing it you think that it must be replaced by something new, you'll add that something new. Is that what isn't that how we're going to do it? Or are we saying, or otherwise let's recognize anybody, okay, we'll take it in the same order. And if you're covered by what the previous speaker said, you'll just say I'm covered. Let's start again with Singh, 14.11.
Chair, thank you very much. Yeah, firstly, I'm saying that we should delete that because there is no board, but we should have, the 14.11 should start with the interim board. The appointment of the interim board must be expedited, what have you, and then 2 will follow what the board must do, whatever. First, we have to have the board appointed. Recommend that the board must be appointed through due process, whatever that due process is.
So the suggestion from Mr. Singh is that we replace 14.11 with saying that an interim board must be appointed urgently, following due process, whatever the case might be. So that is the suggestion from Mr. Singh. I had, after Mr. Singh noted Van Dam on 14.11. Covered. Thank you so much. Swartz on 14.11, covered. Killian on 14.11. Mukwena on 14.11.
No, Chair, I would just add that we must recommend that there must be a time frame within which that interim board must operate, because this thing of having a perpetual interim board is also problematic. That's my only addition. Thanks.
As we go along, I see people raising hands because you oppose or whatever, but we'll give you another chance to comment on that one. All that Mokoena is suggesting is that we're going to say an interim board must be established, and he's suggesting we put a time frame. And what is your time frame, sir?
No, I'm not saying that we must put a time frame. I'm saying the committee must set a time frame. The portfolio committee must set a.
No, it's fine. Let him say what he wants to say. If you guys want to fine-tune it, you'll fine-tune it.
Yeah.
Mokoena is saying it's not good enough just to put the fact that we think there must be an interim board. We should try and factor in a time frame. And as members speak, if you think this is who must do it or this is how it must be done, you'll add to it. After Mokoena was Honorable Khoza, followed by Honorable Kubisa on 1411.
Chair, I agree that we move that interim board to as the first one. But I also wanted to say we need to qualify it. I agree with Mokoena that we need the time frames, but we also need to qualify the kind of individuals that we need, notwithstanding what is contained in the Act. But I do believe that it's going to be absolutely critical to mention that the people who should serve in this particular board, over and above the skills that they possess, they must be of high moral standing.
All right, let's institute we're recommending the establishment of a board with time frames and with high moral standings is where we stand right now. We'll come back to you. After Khoza was Kubisa.
Chair, I'm covered. I wanted to say it must be expunged from the list.
Okay. As things stand now, board time frames, and they must be of high moral standards. Comments on those? I had noted comments just on that. Everybody wants to comment on it. Oh, why don't we leave it as it is, and when we get the report on Tuesday, you'll add to it. Otherwise, it will be, is that okay? Because I'm saying in principle we agree with it. You'll just want to put emphasis on different points. I beg your pardon?
I hear what Dr. Khoza says about high moral standards, but I think here we need to also emphasize the fact that they shouldn't have political affiliations. It's very important. So you can have a high moral standard, but you could also be influenced politically. Do you know what I'm saying? So it's and yeah, yes.
No,
And
honourable
it comes-
members,
and
before we
maybe-
even continue.
Yeah.
And I'll allow you, but I just
Okay.
want to set the principle. Honourable members, can we agree that even if I disagree with what anybody is saying, I'll raise my hand and I'll have an opportunity, because remember, this is the first bite. We'll have another bite. I'm just saying let's not degenerate to a point where we start fighting amongst each other. I can disagree with you and we'll have a bite to do it. So I had, Kubiso was finished, we'll start with you. You're saying high moral standards, non-political affiliated.
And then I wanted to use the quote, fit for purpose. We in section, under observations 13.1, we have fitness of the board. And so I think we should be saying fit for purpose. People who would, well, I have to justify, but people who would make sure that the law is adhered to and would not be influenced by a political agenda at the SABC.
No. I'm trying to note hands. So it'll be followed by Loliwe, it'll be followed by Van Dam, it'll be followed, sure, allemaal wil praat. Swarts, Van Dam, Swarts. Everybody now wants to talk twice. No, I know. No, I'm just making notes for myself. Let's start again. Because when we started, we said everybody will have 1 bite, 1 minute. That's what we said when we started. And it's this inconsistency that causes problems for us. So we'll allow, because we've stabilized everything and you were disadvantaged, sir. No, it was, let's just go through the rounds as we had them earlier on. It was initially Singh, and who followed Singh? It was Singh, it was Van Dam. Remember, it's 1 bite, 1 minute maximum. Swart, Killian, Mukwena, Khoza. Everybody wants to speak. Kubisa? After Kubisa, does anybody else want to have a bite on 411? No, I was reading, so you want to get in there, all right? Chauke. No, do you want to speak, yes or no? No, on this one? Yes. Yeah, it's fine. Chauke and then Mahlangu. And Loliwe was going to be the next. Then Loliwe, is that fine? I'm sorry about that. Loliwe, what we are saying, honorable members, is one bite, maximum 1 minute, because remember we're going to revisit this thing again on Monday. Is that okay? All right. Starting with Singh. Your minute starts now, sir.
Thank you, Chairperson. My bite relates to the comments on the qualifying criteria. I don't have the act in front of me, and I don't know what process is followed when one appoints an interim board, but maybe if we can be furnished with that information by some colleagues. I don't think it's necessary for us to state particular qualities and things like that. That will be in the act, and it's not for us to do that. That's my view, but I'll listen to the others about that. Thank you.
Okay. Van Dam?
Thanks, Chair. The appointments, the qualities that a person who serves on the SABC board, that person must have, those people must have, is in the Broadcasting Act. But if we decide we want to add things over and above that, I mean, high moral standing is a good idea, but I mean, morality is different for different people. There isn't like one gold standard of what morality is. People have different standards of what's moral and what isn't. I'd like to bolster Mr. Honourable Waters' point about no political affiliation. Let's call a spade a spade. A lot of the problems that have happened here is because people went into the SABC board driving their own and political agendas. We agreed as a committee that there was indeed people on the board driving political agendas. The former chairperson of the board, Honourable Chabalala, Mrs. Chabalala, said she received her nomination from Luthuli House. She didn't even want to serve, she didn't nominate herself, but it came from the office of a political party. So if we say no political affiliation, no one with political affiliation from the ANC, from the DA, from any party, no one who's had membership of any political party in recent history.
All right. No, we've noted you, Khoza. We've noted you. It is Swartz, Killian, Mukwena, Khoza, Kubisa, Chauke, Mahlangu, and Loliwe. In that order, you've got 1 minute, Honourable Swartz.
Chair, I like the issue of high moral standing. I also understand the issue of political affiliation, but it might limit the number of qualified members we can appoint. The issue is set out in section 13, where it sets out the legislative qualifications. I'm not sure to what degree we can add to those legislative. We can say it's desirable, and that would be a question when those interviews are conducted of high moral standing, political affiliation, but at the moment it's not contained in the Act, which determines the members of the board. But it sets out there the virtue of qualifications, expertise, experience, broadcasting regulation, and that should have been applied when we appointed the previous board. Now, it wasn't. So that is the challenge. To what degree can we add in this to new qualifications? We've got to make sure that we comply, that the Communications Portfolio Committee complies with the existing legislation when they apply for the interim board and, of course, the final board. Thank you, Chair.
All right, no, we're not even going to entertain any other discussion, otherwise we're rewriting the law. What we will say is that the board must be appointed urgently, timeframes, and the minimum qualification is the act. Because anything else we do beyond that is we're changing the law. Is that all right? Because we are all members of parliament, and we'll all have a chance to reject it in the House if we need to. I don't think we should be rewriting the laws here. So I think the point we were making is, no, I note, but let me finish speaking first. I am saying, honourable members, that if we say the board must be appointed, it must be appointed according to the law. We will then, in our shortlisting and so on, go and look for minimum requirements, the law, and anything else. But I don't think we can be saying here the person must be, I don't know, green or blue or morally high or whatever. That should be the role of Parliament. Let us not be the super committee. Because we can't prescribe to those that are the appointing authority what to do. Can we settle for that for now? Let's do it according to the law. I see that Khoza and Mr. Waters want to speak. I'll just allow the two of them to speak.
Chair, I am prepared to compromise high moral standing. However, I think for the record, political affiliation must not be confused with, having no high morals. And secondly, Chair, if we are going to be putting things such as, being excluded on the grounds of your political affiliation or whatever, that is exclusionary and that is inconsistent with the Constitution of the Republic. And I do believe that out of the 11 million people that vote for the ANC, there are so many good men and women who are proudly ANC, but they will stand for the right thing. Thank you.
That is why I'm going to only allow Waters. I'm not going to open it up after that, because I thought the mature thing to do is to say there's a law, comply with the law.
Chair,
No, that's why I'm saying you will be the last one and we'll take the decision. Mr. Waters, yes, sir.
Chair, firstly, I want to agree with Dr. Khoza that the fact is if you have a political affiliation doesn't mean we don't, like all of us here, don't have high morals, right? So I just want to make that point. I never suggested that. But what I do want to emphasize is that we're not rewriting the law. I think we have to emphasize a particular aspect, because what has happened over years and years of the appointment of the SABC board is cadre deployment. People have been sent there, and you can say what you like, anybody, but people have been sent there to fulfill a particular agenda, which has over time done so much internal damage to the SABC. That's why we're sitting here today, because it's facing a crisis because of political appointments to the board. And I think that point needs to be stressed.
The minister even said in the House, if you want to join the SABC board, you must sit on the ANC board.
Now, honourable members, don't shout. Don't shout. Don't shout, honourable members. We'll vote on every bullet point if we operate in this fashion, and that's my fear. We will begin to divide each other around political lines, and we could do that, but I think that will discredit everything we've done so far. And let me explain what I'm saying, and I'm not disagreeing with Khoza or anybody else. Surely ours should be that the minimum standards must apply. We are all MPs. We all are responsible for the shortlisting, all of us. Maybe not Mr. Swartz in his personal capacity, but as we've said, every member can come and contribute here. Can we not be comfortable by saying it must be credible, which is what we expect from honourable members? Apply by the law, it must be credible. I don't think that there's any South African out there that hasn't learned the lesson of the shortcomings of the SABC because in some way Parliament didn't do what it was supposed to do. I think we've learned it as we're sitting here and others have learned it. I just don't want this committee to be the super committee that becomes the moral conscience of everybody. I don't want it to be that. So can we say new board, ASAP? No, I'm saying, yeah, when I say interim board, whatever the case is, we'll put interim board, ASAP, comply with existing legislation. Because existing legislation covers all these things we're talking about. Be it the Constitution, be it everything else. It says it must be somebody that is credible. So when you pick one law, you would be excluding the other law. If we say with existing laws, surely the Constitution says, apply your mind, it must be somebody credible. I'm saying this one shouldn't be a debating matter. Let's appoint people consistent with the law. Is that okay? Thank you. So we will then put in 1.1 that it must be done. We haven't put time frames. We said in terms of time frames, somebody will put the time frames. I thought that was what we said. So we're saying the interim board must be established as expeditiously and compliance with the law. Fine. That's the point that I'm making here. Yes, that's fine. In adherence with the law, and I'm sure those that are tasked with doing the work will be honorable and do whatever is being done. 4.11. All right, if you still want to carry on, I thought I was trying to close it, then okay, it's fine. Swartz, you still want to say, because Swartz was the next one. After I've summarized it, to add, sir. Swartz. I beg your pardon, 14.11. I thought I'd summarize what we were saying, but do you want to add to it? No. Killian, do you want to add to what I've said?
Chairperson, yes, the board can only function for 6 months, but I think we could stipulate within 90 days because the process has already started, and I think we should, if the National Assembly wants to amend it for some other reason, we could do that. But I think we should indicate the urgency. There is no provision in the Act for how soon after the dissolution of the board. So I think we should just add that.
All right. So what are you saying? 90 days from adoption of the report. You see, Honourable Member, at the outermost, because remember, this report of ours is not formal or binding until it goes in the House. And that is why I'm saying, let us not usurp the responsibilities of the House. I think Singh's point of expeditiously is understood by everybody. When we start qualifying, I just think that we're going to become a super body and we're going to usurp the responsibilities of the National Assembly, and it's dangerous to do that. So let me repeat. An interim board must be established expeditiously, and it must be done in compliance of existing laws. Acceptable? Right?
In compliance with the Broadcasting Act.
Well, existing legislation, and it's all legislation, because the Constitution comes into place, Broadcasting Act, all those things coming into place. It's all encompassing. You don't want that.
It's fine, Chairperson, but I think we should emphasize the fact that there is a specific law that deals with it and that makes provision for the establishment of an interim board.
Chair, sorry, on a question of law, Chair, I think we're making a mistake.
All right.
The provision in section 13 applies to the final board with all those qualifications. So the interim board has got, you can appoint any person to the interim board. So we should say it should be guided by section 13 of the board, which sets out the qualifications.
Is that acceptable to members?
That's all, straightforward.
Interim board, time frames, guided by section 13.
13 and other applicable laws. So then you cover everything, but that's the main one, is section 13 that applies to the final board. I'll give you the wording.
No, it's fine. No, we're not going to get the wording. We'll point them in the direction, because we're not going to do the pointing.
Okay.
Agreed? Right. 14.12. Any takers? Mokwena, I'll just note you, it's Mokoena, it is Waters, it is Kubisa, it is Singh, it is Van Dam, it is Swartz, and then it is Chauke. Maximum 1 minute, 1 bite. Mokoena.
No, Chair, I just thought following directly after the appointment of the interim board, I think we must also stress the issue of the training of the board so that they understand the legislative environment, that they understand their responsibilities and duties and so on and so forth. So I'm suggesting that that should be 4.1.2, right? And then on the issue of instituting an...
No, let's just stick there. You're adding another one that says the board must be adequately trained.
Yes.
Anybody got an objection with that? Adequately trained, we can't have an objection with that.
Chair, I think that aspect is covered. It is a given that every board that gets appointed must be inducted. And induction is training, and it's something that must happen continuously. I think the Companies Act and the King 3 dictates those arrangements.
No, Chair, then I think this, because it hasn't been instituted the problem, the reason why we're sitting here is because this board was not trained. They didn't understand what they were supposed to do. So what we should be suggesting is that, you know, we must train them.
I think the way we're going to manage this thing is there's a proposal that says add another, I don't know what we call these things, clauses or whatever, which indicates, which in paragraph or whatever it's called, which emphasizes adequate training. That's the proposal on the table. I'm only going to take those that oppose it, because those that support it don't have to re-emphasize it. Is there anybody that opposes adding a paragraph, a line that says the interim board must be inducted? Mokoena, would you stick by trained? That's the proposal on the table, trained.
No, as long as they know what they're doing.
Yes, okay. All right. The new proposal on the table is that the board must be inducted or... Properly inducted. Yeah. That is the proposal on the table. Any opposition to that proposal? Opposition. Not emphasis, because you'll have an opportunity to emphasize it when you've got the document. Any opposing view to adding that line? Ma'am Khoza.
I just wanted to check from fellow members. Do we realize that the interim board will be going into a very abnormal environment? And I would imagine that we need to pronounce ourselves in terms of getting in there and just bring about some kind of normalcy to that environment. I'm not sure if we actually understand that this is not going to be a normal environment that they are going to be walking into, and there has to be something that, as this committee, are saying to that effect. I don't know, I'm just...
What we're going to do is we're going to put that paragraph in. We have 4 or 5 days to think about it after, not 4 or 5 days, after Monday we'll think about it, on Tuesday you'll get it on Monday, on Tuesday you'll finalize it. Because I'm saying these are the views that are both legitimate, we might not agree with them. We will have a board, there will be a second paragraph that says they must be adequately, or they must be inducted. When we meet on Tuesday, those that don't want the inducted part in it will express their views. Is that okay? Thank you. Okay, so then we go to 412 as it stands now, because remember we didn't go to 412. Does anybody want to talk to 412? On 412, yeah, we've got the list for 412. Yeah, we're going to with an addition, come with it afterwards, because it's more on 412 as it is.
I think because we don't speak of a forensic audit, a general forensic audit. No, because I think we're too specific on. So I think it must go in there as well, that they must institute a forensic investigation and yeah, disciplinary whatever measures or legal action.
So the only thing we need to add is the word forensic before audit, because we talk about appropriate steps further down towards the end of that sentence. We'll just add, may institute a forensic investigation into all those things we're talking about, and it covers. Waters, you are the next one to speak, sir, on 412 as it stands.
Thank you, Chair. To do with the forensic audit, we're stipulating here, well, first of all, it should be a forensic audit, an independent forensic audit, first of all. That's very important. By, a reputable company, not some fly-by-night company as well. I don't know how we put that in there, but it's, a reputable company. That's good. Right, now, we're saying here, irregular, fruitless, and wasteful expenditure, but would a forensic audit, by the nature of the term, include everything, or is it just limited to fruitless, wasteful, and irregular expenditure? Because if it is limited, then we've got to include all financial transactions. We have to. We have to open it up simply because there's such a deep rot at the SABC. We've got to root it out, and we've got to get to the bottom of it. So if we're going to do something, we may as well do it properly. We've got to look at all the tender procurements, appointments and dismissals. So when I'm talking about a forensic audit, an independent forensic audit, it's got to cover everything. And I know it's a mammoth task, it's a massive institution, but it's got to be done. So that's the first thing. Then where it says in the third line, well, let me carry on reading. And on conclusion of such investigation, appropriate steps must be taken against employees. But what about ex-employees that are found guilty, that have been involved in corruption? So that must be included there. And then it says who incurred or permitted irregular, fruitless, or wasteful expenditure. Then we must just, whatever we do at the beginning of the paragraph must then be repeated at the back. But if you didn't incur any fruitless expenditure, or you didn't permit it to happen, but you influence people to do it, should we not be saying, or influence people? Because I think a lot of it was cloak and dagger stuff that was going on at the SABC, where certain people protected themselves by using other people to commit corruption at the SABC. So I would, and maybe the legal people can come in here, because I'm certainly not an auditor, but I would like to see who incurred, permitted, or influenced, any forms of corruption at the SABC. Thank you, Chair.
All right. We'll allow other members. Let me just remind members that, first of all, our recommendations must be something that will gain credence in the National Assembly ultimately, because that's where it's going to be adopted. And I'm not saying it's not going to be adopted, what we're saying, but secondly, it must be achievable. We might want to have a very solid intention, but it's not achievable. Those cleverer than us in the National Assembly will say, that's very good, but to do a forensic, and I'm not saying it's you, I'm just using it as an example, to do a forensic audit of all these things within 6 months is just not practical. That's why I'm saying let us just be practical, but I'm not saying it's wrong. We'll have a bite on Tuesday and we'll have a bite at the National Assembly. All I'm saying is let us just put stuff that is achievable from our own side. So we'll add what Mr. Waters has suggested, independent by a reputable company, and employees must be all encompassing, or all incumbent, and it must be expanded more than just fruitless, wasteful, and irregular, but it must include HR and other finances. I think that's what you were saying. Kubisi?
I wanted to say, you know, this clause pertains to employees, but it doesn't cover members of the board who may advertently or inadvertently have had influenced employees to engage in irregular and fruitless or wasteful expenditure. Now, we need to take that into cognizance as well, because there may be previous members of the board who are implicated in the whole thing. And I want to also concur with you that we must also take into consideration the issue of time. We are talking about a 6 months, so to say, interim board. Yet the job that they're going to do might be a mammoth one. So recommending time may not be, I mean, they can't do all these things. So those are the issues we must take into cognizance. But I wanted to bring in the issue of the ex-board members who might have had an influence or might have also been implicated in the whole thing.
Honorable Singh, your minute starts now.
Yeah, thank you, Chair. Chair, I think we must make some reference to the powers of the board, this interim board. They will derive from the Act, but maybe in the first sentence where we say a board should be appointed expeditiously, such powers to derive from the Act, because the board has to have powers. Then I think the whole idea of this here is for this interim board to initiate processes of forensic audit, etc. Processes related to the PP's findings, ICASA, and the AG. And that's what we need to list in some kind of order, because we haven't put anything about the PP here, the PP findings. So that's how I think we should be approaching this, this particular section. But I'll come to the next point later.
So we're saying that interim board, it's about institute, not about finalizing. Auditor General, Public Protector, and ICASA. Right. Honorable Van Dam.
Thanks, Chair. I'm largely covered. I just want to emphasize the point of it being a reputable company, because I heard some murmurings in the committee about us insisting that it be a reputable company. I think the SABC has a history of hiring companies that are less than quality, companies that have given them bad legal advice. We just spoke about that. So it's important that it's a reputable company whose findings will not be subject to question. Findings that we can trust because we know it's a reputable company. We know that they've done work before. It's been good work. So it's very important that it's a reputable company.
I have noted Mr. Swartz, and then followed by Chauke, followed by No, you're only indicating now Chauke, then it will be Koza, then it would be Mathangu, and then the last hand that I've noted is that one of Killian. And we're going to move on to the next one. Swartz, your minute.
Chair, I think Mr. Singh has covered the issues. There's a lot in the Auditor General's report. There are already pending investigations. So in addition to this, the pending investigations must be finished. The interim board must ensure that they are complied with, one of which relates to the financial sustainability of the SABC. Now, surely before you go in after irregular expenditure, you've got to determine your financial sustainability of the entity at that time. So maybe later one can add in, but I'm satisfied with the clause there, but I do want us to put in something about the interim board looking urgently into the financial sustainability, the solvency of the SABC as a going entity. Thank you, Chair.
Chauke?
No, thank you very much, Chair. This process of a forensic investigation, Chair, we need to divide it. That we need to identify what is agent, and then deal with what you call your normal a public finance management processes which deals with your fruitless, wasteful expenditure. Now, I'm going to propose, Chair, that what we must then do, and this had to be linked with the Public Protector's report, that we look at agent issues, especially that we can focus ourselves in, Chair, will be the issue of bonuses that came out very strong during the hearing. Secondly, is the issue of is bonuses and increments that they give themselves and all of that. And you then link that together with contracts. You remember that Shushu, the fact that there were certain contracts that were fraudulently not even processed via a supply chain. That report is very critical. The management report that Honorable Swart spoke about, it falls under your normal, which we can therefore, Chair, call the Auditor General, because Auditor General can do forensic too. You can invite Auditor General, invite National Treasury to focus on your fruitless, wasteful expenditure, and then have your private company that can do
Your time
the
is
following
up, sir.
areas. Thank you very much, Chair.
All right, we'll try and summarize later. We're making notes and see. And then after that, it was Koza.
Thank you, Chair. I just wanted to to enhance the point that was made by Honorable Waters. I wanted to qualify a reputable company in sync with national priorities and policies, because we cannot have reputable which will be exclusionary. Thank you.
Mahlangu?
Chair, thank you. I'll support the sentiments of the Dr. Koza that has been just indicated, but also indicate that what Honorable Chauke raised is important. Look, Treasury has been conducting audits in these institutions. They have presented reports. Those reports have not been implemented. Now, bringing a person from outside in a new board from outside is a mammoth task. My view, and that's what I had recommended, that the SAP board should ask Treasury and the AG to institute the investigation. AG is reputable. I mean, they do all our monies in the country and they participate, including in the UN. Because I find, without belaboring the matter, that was my recommendation, that Treasury and the AG should actually institute the investigation.
Honorable Killian?
Chairperson, actually, I'm covered by Honorable Mahlangu, but I just wanted to say that I believe we should differentiate and allow the interim board to focus on limiting further risks and financial losses. That would include illegal contracts. It would include, board decisions that were irregular, resulting in potential future risks, etc. I think we should just differentiate between immediately intervening to stabilize, and thereafter, obviously the rest of the weaknesses that we've identified should be taken forward by the final board. But there's a period of 6 months. They must find their feet, they must just hit the ground running, and therefore they must just limit further risks and potential loss for the corporation. I would like to suggest that we focus on that. And then obviously the investigation, but I'm concerned, as it stands at present, Chair, we focus on the investigation without focusing on what Honorable Koza has said, that stabilization, the environment. So I would like to suggest that we rather start with that point, and I'm prepared to write a little line on that, specifically on clause 14.12.
Thank you. I think there's consensus in principle that there must be an audit of some sort. It must be done by a reputable company, which includes AG, Treasury. A reputable company, it's a reputable. If these are reputable, they are reputable, including AG. Mahlangu is saying, let's not say independent, reputable. He's saying, let's be specific to AG and Treasury. The one says let's be specific in terms of bonuses and contract management so that it's short-term interventionist. The other says the investigation must be into HR, PP, and AG. Those are the two views. Can we put both of them there and we consider them afterwards? Because I'm saying those are the two views. In other words, the scope of the investigation is the only thing that is uncontested here. But I mean, the quality of the investigator, I think is acceptable, that we're saying it must be reputable, independent, because AG is independent. AG will fit all those things you're talking about, by the way. So maybe not Treasury, but certainly AG would fit all those things. So we say, on one hand, we'll say independent, reputable, blah, blah, blah. Other one we'll say specific to the two, and we'll think about it over the weekend and come to a conclusion on Monday. Is that okay? Happiness? Yeah. All right. Steps must be taken to recover. I don't even think we must debate that. That's the law as it stands. That's the PFMA. So we move on that one. Yes? 413 is just complying with the PFMA because it's exactly from the PFMA. 413. 14, I keep on saying 4. 1413, anybody wants to talk to 1413? Let's note hands. 1413. Chauke, Van Dam, and Swartz, and Singh, and Mukwena. 1413. No new ones, just 1413. Does it stay? Do we enhance it? Do we remove it? Chauke.
In fact, 1413, I'm not sure that if we were to deal with your regular fruitless and wasteful expenditure, as I've said earlier, that it's a normal process informed by PFMA. Therefore, it requires recovery because that's one of the 3 steps that you deal with when you deal with PFMA. It's investigation, and then it's your recovery, which is informed by PFMA. The 3rd one, obviously, is action that you take. So all of this, in fact, form part of 2. 1412 is the same as, because they're not separate. If you are to implement PFMA to the latter, it deals with the 3 areas of intervention. So if we stick with that, you can, in fact, leave 1413 out, because 1412, in fact, speaks detail around a fruitless and wasteful expenditure.
All right, Fanda.
Thanks, Chair. Now, those sections I was yammering on about come into action now. Section 83 of the PFMA reads as follows. The accounting authority for a public entity commits an act of financial misconduct if that accounting authority willfully or negligently fails to comply with the requirements of Section 50, 51, 52, 53, or 55. Section 51 of the PFMA says, under general responsibilities of an accounting authority, the accounting authority must take effective and appropriate steps to prevent irregular expenditure, fruitless and wasteful expenditure, losses resulting from criminal conduct, etc. So if we look at the wasteful expenditure that has happened at the SABC over a long number of years, the accounting authorities failed to discharge of their duties in terms of Section 51 to prevent wasteful expenditure and therefore committed financial misconduct. Furthermore, the Act says,
You've got 30 seconds, man.
Okay, offenses and penalties for financial misconduct is criminal charges. So we should say there that anyone found guilty of allowing fruitless, wasteful expenditure must have criminal charges laid against them.
I'm trying to help us there. I think what we are saying, Van Dam, in different language, but if you want to emphasize it, you can emphasize it. If we said in terms of these things, the PFMA must be complied with, it'll answer all our questions, because the PFMA states what it is that must be done. I'm not arguing with you. I'm just saying, because what you are saying is no different to the PFMA, quite frankly. The PFMA says recover, do all those things, and also the accounting authority is liable if you go to section 55 or something, in terms of, so I'm saying it's stipulated in the Act. So if we said, implement the PFMA with relation to these three things that we said there, it should be sufficient. And what we can do later is to say there must be monitoring by SCOPA and the public and the portfolio committee or anything else. That's all I'm saying, because when we become prescriptive here and it's adopted, people might turn around and say, you only said I must do A, B, C, D, which might not be all inclusive, or it might be in contravention of another law. Unless we are very clear what those laws are saying. So I'm just saying, let us be practical about it. PFMA is the supreme law in terms of oversight, and if we said implement the PFMA to the letter, I think it should cover your concerns. It doesn't dilute what you're saying, but it's as far as we can go as this committee to say implement the PFMA when it comes to these matters. That's all that I'm saying, but Van Dam, I mean, I'm not arguing. We'll put your point in. We'll put your point in and we'll argue them. I'm just trying to guide us when we get to Tuesday's meeting. I beg your pardon? No, oh, that's what I'm saying. I'm looking at Madam Van Dam because I don't want to get into a dialogue. I'm just trying to guide us for the first one so that you take it forward. Van Dam, do you want to say something very briefly and then we're going to go to Swartz?
I'm happy if we say the prescripts of the PFMA, because we've been specific about sections before. Can we then be specific about which sections apply to accounting authorities, specifically of public entities? Because earlier on, we're very, very specific. Let's be specific in the recommendations too. Thanks, Chair.
Absolutely. You'll assist us in saying application of the PFMA with specific reference to section 38, 1C and 38, or read together with section 65, something or the other. I'm not sure what that is. Swart?
Chair, I'm in agreement with your sentiments, but when you refer to the PFMA Act in saying the interim board must comply with those, I would like us to emphasize the fact of the possible institution of criminal action for breaches of the PFMA Act, the Companies Act, and any other applicable legislation. It's not saying they must do it, but you can comply with the PFMA Act without instituting criminal action if necessary. We need to say, and we do say to a certain degree by taking appropriate steps, but appropriate steps can be disciplinary action. You just institute, but there's clear breaches of fiduciary duties in terms of the Companies Act as well. So it's a very brief, I agree with you what you said, your William, but just to add, PFMA Act, Companies Act, and any other law, with a word about criminal action if necessary. So you're not tying it to it, but you're just broadening it as far as possible.
No, that's fine. Remember, honorable members, what we said earlier on. We are not going to adjudicate what you are saying, but as you do this, please submit in writing, because if necessary, we will put, this is the view, this is the view. If there are 5 views, we'll put them, and members will do. We're not going to adjudicate, but we take your point, we'll add that. Please assist us unless Cindy hasn't got it. If she's got it, it's fine. If she hasn't got it, she'll nudge me, and I'll ask you to assist if you want to do that. Mokwena?
No, see, I'm covered by Honorable Swart.
Kubis?
I'm happy with what Honorable Swart has given, because I wanted to say where the sentence says where necessary, I was going to say in line with the law. So that is encompassing, because Honorable Fadam gave PFMA, but there are other pieces of legislation that must be factored into this.
All right. On the same point. Yes, sir? And then you'll be the last one, Singh.
Chair, Honourable Swart raises a good point about the fact that emphasising criminal action. And just to read out 86.2 of the PFMA states the following. An accounting authority is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 5 years if that accounting authority willfully or in a grossly negligent way failed to comply with the provisions of section 50, 51 or 55. So I think emphasising that, as according to Honourable Swart, would, I think, strengthen our case.
That's fair enough. No, it'll be in line with provisions of existing legislation. I'm saying that's fine. So it's not. I'm saying we might when we argue on Tuesday, we might not want to be explicit as that, or we will be explicit, but we will put them all in there, because we also must not be, what do you call those things when you, tautology, or what is that? Yeah. That's the point that I'm making. Yes, sir.
That's
16.
what I was going to say. 1413 is tautology. I agree with Honorable Chowke. But then I don't know how we dealt with the issue of employees, because it shouldn't be anyone.
No, we did. We fixed up that one in the
You
front.
fixed that up,
Yes.
okay. And then, all right, because we talk about accounting authority and we talk about interim board. So we just have to, like in the next one, we got the accounting authority.
Yeah,
like it's a
we
different-
remember earlier on we said that we will have something that says accounting authority equals to board in our glossary. So wherever we've got accounting authority, I will be specific, we'll say the SABC board. And we'll also say when we say SABC board, it means this is the board, because there have been 1,000 boards in the interim. So we'll try and fix that up so that people are clear that when we say SABC board, which period are we looking at specifically? So we will fix that up. Does that deal with 1413? Yes? 1414, filling up of vacancies, specifically in finance and in HR. And that is taken directly from yeah, okay, let me not say anything, but we're recommending that the new authority must urgently fill vacancies in critical management posts, specifically related to finance and HR, and it doesn't exclude everything else. Don't come and say to me, but put anything else in, please, because we are saying these are steps that must be taken tomorrow. Let's take Kubisi. Please remember the order. It's Kubisi, it is Waters, it is Singh, Mukwena, Chowke, and Van Dam, in that order.
Yeah, thanks, Chair. I have a feeling that before we come to this point, there is a very important point of the accounting authority ensuring that the lines of reporting are clear. Because to me, that one comes first, even before you deal with this issue of positions or vacancies. So there is a point on the lines of communication. It has been a feature within the SABC that you wouldn't know who the group COO is and who is doing what. For me, that comes first. I don't know how we can put it in here.
There's a suggestion that we put in a line that emphasizes the reporting lines, if I'm trying to understand what Kobisi is saying. I thought the argument earlier on, I don't know, somebody here said, but there's an HR policy and all. I thought those would clarify it. It was not that there was no legislation. It was that legislation and or policies were not applied with, was not complied with. I thought that was the argument we made earlier on. Because if we're saying that the lines must be clarified, we're almost assuming that there were no lines. I think there were reporting lines, they just were fudged. There were, isn't it?
I understand, Chair, they were deliberately ignored. Now, the point that I want to bring in, how does the board assist us in ensure that they are not ignored? But I'm with you there that, I mean, that is covered within the legislation, but it was deliberately ignored.
Okay, so altering it slightly, you're just saying that the board must ensure that HR policies must be complied with. That's what you're saying. Can we live with that? I mean, of course, somebody else is going to then turn around. Let's just say that, yeah, okay, on this point is specific. The board must ensure that HR policies are complied with. Maybe you'll come and say supply chain management policies, somebody else's. That is why I'm just saying that let's not micromanage these people, man. These are professionals. Why do we want to micromanage them? Why do we? I'm saying, you see, and I'm saying, I'm saying let's not run the danger of trying to be over-prescriptive as if, look, honorable members, first of all, somebody said the board must be inducted. Induction will include all those things. Why do we then want to say, after being inducted, I'm just appealing that let us not overstretch ourselves. Let us just not, if they are inducted, I'm assuming that a proper induction includes their responsibilities, it includes all these type of things. That's what I'm appealing for, but if members want us to zoom into detail, let's do that. And I'm sure the National Assembly will apply their mind. Let me go back. Kubisi is saying he's suggesting we put an extra recommendation that says the incoming board, interim, and the permanent board must ensure that HR policies are complied with. That's what Kubisi is putting on the table. Do we have a problem if we add that? A problem, not support, a problem. No, I'm just asking for those that have a different view so that we can get a sense. Just these three hands here in front, we'll go this way.
Thanks, Chair. I'm a little bit wary of saying HR policies because we know that these policies at the SABC were changed and made to favor certain people. So I'm a little bit wary of saying SABC HR policies. Can we not then say that's in line with national labor legislation?
Yeah, on that point, because they were tampered with, I would say that HR policies be re-looked at, I don't know what the word is, restructured, whatever. Yeah, I think so. But also, just in conjunction with what Dr. Kozo was talking about earlier on, I think, Chair, we do need a preamble, a problem statement that states the gravity of the situation.
There is a problem statement that we agreed upon last week. Yeah. Last night we agreed on it.
No, I mean, no. No. There's a problem statement at the beginning of the document that says what the issues are. But here, I think to then, after our observations, to state...
Protect.
But can people not say no, before I...
Go back.
No, to speak about the gravity of the problem. Because we state that there are issues about this and that and that and that. But we don't state the fact, so that when we go to, for instance, the HR issue, it's a complete overhaul. And there's a difference between just looking at HR policies and completely overhauling. And I think that's the preamble that I think should go before these recommendations.
Kubisa, I think you were next, eh? Waters, Singh. No, Waters didn't speak, it's Kubisi, Waters.
Yeah.
Masangu, Chauke, and Van Dam will be the last one in that order. Oh, you want to speak as well? You want to speak as well, Oliwe? I'm always ignoring it.
No, Chair.
That's why I kept on asking, does anybody want to speak? But if we continue raising after somebody has spoken, we're not going to finish this thing. And I have no problem, honorable members. I really don't have a problem if we stay here the whole weekend. And that's why I asked who wants to speak. Again, let me reiterate, you're going to have a second bite at the cherry on Tuesday. So after Van Dam will be Swartz, and then it will be Loliwe, and then it will be Killian. We are on the point that
I put on the table.
the point that says that we must have. Are we done with the HR? We're done with the HR, right?
Yeah, I think, Chair, we are done because Honorable Van Dam had to come with an addition, and we accepted it. And yeah, I think we're covered on that one.
No. Okay, that deals with 1414. That's what we're saying. Are we happy with 1414? Does anybody else want to talk on 1414? You want to? 1414. No, I want to get clarity. Are we talking on 1414? All right. because we are now very confused, all of us, let's start at the back for, oh no. Oh, it's fine. We're talking on 1414. We'll start here. In other words, Van Dam, Waters, go that way, come down this way, go that way, end up with Mahlangu. Again, we're spending 1 minute. And if somebody has said it, please say I'm covered. You don't have to read it. 1414.
I don't recall whether we agreed on 1412 to include irregular labor appointments. If not, can we include that there? And the reason I'm saying this is because we keep getting reports from members of the public, and people at the SABC that Mr. Motswaneng continues to run the SABC from the grave because he has a group of people, his friends and enforcers that he's appointed to positions. So can we say, and also with appointing people to vacant positions, can they also investigate all irregular appointments if it's not part of the forensic investigation?
Chair, I thought so too. All the appointments and dismissals. I've talked about that. Yes. Yes.
No?
Yeah.
Okay. And
I'm covered.
you covered too. Loliwe?
Chair, I thought we were at the tail end of 1414 because Honorable Van Damme said, let's rather than talking to human resource policies, talk to national labor legislation. I agree with that. And also I want to caution us, let us not try and determine roles and responsibilities for the coming board because there are pieces of legislation that guide that. When with us, we want to put everything in the basket as if we are starting law afresh. There are pieces of legislation. Thanks, Chair.
Thanks for having my back. That's why I was saying, let's not be a super committee and assume that other people wouldn't think like we're thinking. So let us just give them kombandlela, and there's oversight bodies that will do the necessary oversight. All right, let's not be prescriptive. Singh.
Thank you, Chair. On HR, but it can be a new point if you think. On HR here, we're looking at these positions that need to be filled, management. But what about an investigation into irregular appointments and dismissal of people? Because evidence emerged that there were people appointed just willy-nilly and people were dismissed because they didn't like A, B, and C. I think this board needs to initiate a process to look into that aspect and see how it's corrected under HR. Thanks.
Yep. I think that was covered under Waters' suggestion on 4.12. Remember we said PP, HR, and AG. The forensic would assume that it'll do irregular and everything else. I thought, but the point is taken. The point is taken. We had then decided we'll come down from your side, ma'am, Killian, on 1414 and Madoda. Where I come from, they say, even if you haven't spoken, you are still a man. Don't be forced to speak if you don't want to speak. No? Or a woman, by the way, yeah. Even if you haven't spoken, you're still a human being. Don't speak for speaking's sake. Killian, I apologize for being sexist, sorry.
No.
I apologize.
Chairperson, I just wanted to back you on this matter that we are going into extreme detail. I mean, the basic point of departure of the interim board is to stabilize and regularize, and including taking the necessary steps in terms of existing legislation. The minute that we start going into the detail, what about this, what about that, what about that? So I really want to caution members, the poor interim board is going to come in, and they will stay there for 6 months only. They may not stay there for any longer. What is achievable? I mean, the previous interim board of Irene Charnley, she virtually slept there, and she brought about a fantastic plan, which was not implemented. But the point that I'm just making is, let us rather refrain from adding and adding and adding further to just limit their responsibility to stabilizing and regularizing, and then, taking the necessary steps, including conduct investigations and follow through on criminal conduct is evident. Can we do something like that?
Thank you very much, Chair. My approach of as Chair on 1414, it's informed by our own assessment, the fact that the accounting authority has collapsed, executive authority has collapsed. Therefore, priority becomes your key appointments. And your key appointments in that regard, Chair, your CEO, your CFO, your COO, which are critical positions for you to be able to implement. You can talk all your policies and what, but these are the drivers who must make sure that systems are put in place, there's adherence to the policies and all of that. Without them currently acting positions, therefore, my proposal is that we put this as a key priority, that the board, the interim board, moving into that space, focus on this particular appointment of the people. Then you will then have a balance in the process. By the time you appoint the board, the permanent board, by that time you now have your CEO, your CFO, and your COO in place, and that must be the mandate that we give to the interim board to start that process.
No, Swartz. No. Yeah, but I'm saying to you, please don't shout at us. You were after Kubisi, and people will raise it. I'm just trying to put us in the right direction. We will find the way. All I'm saying is, are you saying we must take this and put that out? If you say yes, Swartz will come tomorrow and say, but it is there or something like that. But I don't want somebody to co-chair with me. Is that all right? Nobody's going to co-chair with me. Can we have Kubisi? No, it's Kubisi, Waters, and then Singh, and then who was him? Mokoena. Beg your pardon. Yes, we were just going around. Yes, Singh was done. It'll be you, and we'll come down that way. I'm sorry. Yes.
So, the Chairperson.
Doesn't matter. Start Kubisi and then you'll come in Mokoena.
Okay, Chairperson, I think for me, 14.14 must be left as it is because it speaks to what we want to happen within the SABC, what the board should do, because we cannot speak on all minute details. I think this point covers what we want the board to do. And there's a point that was raised from the beginning by many members here that begins to say we have to be objective and as constructive as possible, because it doesn't mean there was not even work within the SABC. There has been work. It's only that these critical positions, as Honorable Chauga is alluding to, have got to be filled. So I would go with the idea that 14.14 be left as it is.
Yeah, no, Chair, please bear with me. I think I agree with Honorable Killen that we must condense the entire 14.1.1 up until 14.1.4 into one, so that it reads something like an ad hoc committee, an interim SABC board must be instituted and so on and so forth for the purpose of stabilizing and regularizing, right? Also taking legal action and so on and so forth under the specific things, human resources, financial management, irregular, whatever, all of that. So that becomes one thing that doesn't become too prescriptive, right? So if we condense all of that into one, and we collapse it, and then the next point becomes the appointment and removal of the SABC board and its members must be in compliance, and then we move on to the next thing.
There's another proposal, and Mr. Swartz, followed by Mahlangu, and we'll end up with Honorable Koza. Mr. Swartz.
Chair, 14.4.3 reads, the appointment of permanent staff to all senior management posts, including that of the GCEO, COO.
Sorry,
and
Peggy, that's
company
14 point?
4.3. I suggest that clause, as Mr. Chaka says, comes into 14.1.4, which will assist. We need to read those two together because it's a duplication. Chair, I didn't mean any disrespect to you, but it would have been helpful, you understand, because we spent 20 minutes discussing something, and so we need to help one another. I mean no disrespect to you, but maybe how does one interrupt you then when there's a valid point without being disrespectful to you? That's the only point I want to make. So, Chair, but I have got a problem with us, a principal problem with us telling an interim board they must finalize this within 6 months. You see, that's another major problem. We will hear that was the whole problem with the appointment of the CEO when the minister came and said, Parliament is saying, put pressure on us, and the wrong people were applied. So we need to put a caveat in to say where possible. Otherwise, then it can go over to the new board. So we've got to be very careful. I agree with Ms. Killian that says this poor interim board, how are they going to do all these permanent appointments? Yes, it's necessary. But we're only focusing then on financial management and human resource management. What about procurement? That's the key point, is procurement. So it's a challenge, Chair. The other issue, Chair, is the process, and you correctly pointed out this process we're engaging with now. We're going to go on till 2-3 days as we are going now. We learn as we're going along. Should we not each prepare, or maybe we should have, but each prepare a written document on what we say it should be? Because as we're now going through each point, we're spending half an hour on each single point. Normally, one would come with a position and say, here's my document, this is my suggestions, I'm happy, here's my addition, discuss it, finished. But we've chosen another route, and it's useful to debate it, but each issue, you think and you raise more and more issues, and that's why we're taking so much time, as I have taken now. Thank you, Chair.
Rahul?
Chair, thank you. I think colleagues have already spoken to the things. All these things that we are trying to infuse here are better crafted, well thought out in existing documentation. So we're trying to rehash something, and we're actually not even meeting 50% of what is crafted. Actually, at one stage, I felt we must switch off go offline so that we can talk to ourselves, because in the manner in which we're trying to do is really trying to over-micromanage a matter. Look, these people are not full-time in office. The interim board, they can only meet perhaps how many times during their tenure of 6 months? Perhaps 2 times. All these things that we expect them to do are close to impossible. So let's reflect on the matters, and I can't agree more with those colleagues who said, make submissions. I have crafted my submissions, and I think, I'm not sure whether Cindy has received it, because in that way, we will give them substance that they can work on and bring it back to us as a worked out document. We can then thresh it out. Remember, we are still working from a source document. The things that we've been discussing yesterday, quite important observations. I mean, whatever we were doing, not observations, but the work that has not been fused into what we're doing. So there's a lot of work that we've done. Let's craft documentation, submit it to our Cindy, let them look at what we are having, synthesize it, put it at wherever they deem it necessary, because now there are things that are appearing on 4.4, which are supposed to be on 4.1, others are on 4.1, personnel would run them at 4.4. But if you present a report that has been, where we've made submissions and they are feeding us back, we can actually find our footing even better to engage. But I'm saying the things that we're trying to put here, they are nicely crafted. The things that we're talking, political things, inductions, training, all those things that we're saying are nicely crafted in documentation, nicely printed. But I guess, yeah, that's where we are. But we can do better, Chair.
Chair, thank you very much. Just to pick on what Honorable Swart and Honorable Mahlangu were saying. Chair, I thought that when we come to recommendations, we would be crafting them such that they speak to the observations that we had made. Having said that, Chair, specifically on 14.1.4, I wanted to appeal to the committee so that we align our own observations with our recommendations. I wanted to propose a sub clause under that specific clause under 14.1.4. And that clause is that the interim board should, amongst other critical assignments, seek to stabilize and regularize the historical and current HR environment. And the reason why I'm talking about stabilizing and regularizing the HR environment, historical and the current, at SABC, you actually have a lot of challenges with the staff that are extremely demotivated. Some of them are really hurt. And we heard what the witnesses were saying before us here. Some of the people are actually sitting at home. They were working in procurement and they were purged. And as a result, they are not employable, because if you've been working in the procurement section, they want your previous employer's reference. And when you have that situation, the chances of you being employable again are not going to be there. But we don't want to be prescriptive to the interim board, but they must, within their own creativity and what have you, seek to stabilize and regularize the HR environment so that it is consistent with a growing organization, a highly competitive organization, a profitable organization, and so forth and so forth. And that would be my recommendation under 14.14. Thank you, Chair.
All right, let's try and understand where we're at, honorable members. I think there's consensus that on the 24th, we want to be in a position to have a draft document. I think there's understanding. So if we work back from the 24th, this document we had given to members on the 15th, and we thought that members would have gone to apply their mind, come with almost perfected positions. That was the intention, I thought. What Honorable Swartz and Honorable Mahlangu and Honorable Khoza is now saying to us is that, and we just assumed this is what members were going to be doing when we said go and consult. You come with your positions. If we went that route, and I have no problem, are you suggesting to us, and I'm looking at Honorable Mahlangu because you guys must give us direction, are you saying to us that we must release you, you will give us submissions so that we are in a position to give you back a paper with all the submissions so that you are ready to discuss them on Tuesday? And I'm just putting these scenarios to the table because people are almost saying, let us make submissions, and I have no problem. But understand, honorable members, that this thing has one, logistical and also credibility. We could do that and say, everybody give us a submission, or parties or Rose, or whoever you are, give us those submissions. We will consolidate those submissions, give it to you, and then we debate them, because that seems to be the suggestion that's coming out on the one hand. Going this route, honorable members are saying, is going to take forever, and we can learn. All I'm saying is, whichever route we take, understand it has implications both on how we prepare the document for you, how well prepared you are to engage on Tuesday, and the timeframes, because we do not have the liberty of changing the timeframes, honorable members. We don't have the liberty of changing the timeframes. And we've worked it out in such a fashion that there is absolutely no space anymore We don't have any space. In other words, we don't have fat for 2 weeks or something like that. Unfortunately, this is where we're at. So when you make proposals going forward, bear in mind the 28th is our deadline. Bear in mind we've got a 2-week period to give people for comment. Bear in mind we're going to need at least 2 days to deliberate on the final product. And bear in mind that we're going to have to deliberate on this one before we send it out. So I'm saying those are the milestones. I want a view from this House. Where to from here? And we will start, everybody must discuss this one because it's our responsibility. Everybody must discuss this one. Yeah, we'll start by you, it's fine. All I'm asking you is answer those questions, honorable members. 15th, 2 weeks, 28th. And today is Friday. Between Friday and Tuesday, somebody must put all these things together. So take all those things into consideration. The question is how. We're going to start with Mokwena, we'll go up to Kubise, we'll go to, at the back to Khoza, come this way, then we'll start with you, Waters, and we'll end with you. The question just is how. That's all the question that we're asking. Let's start with you, sir. And everybody's got 1 minute.
No, Chair, look, I think I agree that the process we're engaging in now is going to be too long. So what I'm suggesting is that, but I do think that it's important that we all hear what the collective is saying, right? So my suggestion is that we go back to the process that we embarked on in this morning, in the morning session, that we give each and every member 5 minutes to make all their recommendations, right? So that we all hear what each one of us is saying. You will then look at all our recommendations and compile them as per your headings. And then that is the document that we will then look at on the 24th. But we would have heard each and every one of our views and developed an attitude towards it.
Chair, from my side, I would say we continue as we're continuing, clause by clause, because we're together here. And if there is any submission you want to make, it's fine, but let us not deprive ourselves of the opportunity of speaking to one another. And yeah, I think that will assist us, that we continue with the time that we have until we close late at night.
Chair, I concur with Honorable Mokwena. I honestly think that given the fact that we are coming from different perspectives, ideological orientation, interpretation, different interpretation of the evidence that came before us, I think it would be wise if we are each given a stipulated amount of time, say 5 minutes or something like that, and we comment on these recommendations, or maybe if we have new recommendations that we are putting forward, we then put them forward. That way we will be saving time, but at the same time, nobody will leave here feeling excluded or feeling that their own views or concerns were not taken into account, because they would have had an opportunity to comment on the recommendations as a whole. That would be, therefore, I align myself with Honorable Mokwena.
Chair, thank you. I agree that the proposal by colleague Mokwena is actually the best under the circumstances. That we have time, well, whether it's 5 minutes or 10 minutes or whatever time, but give members sufficient time to reflect on a range of matters that they would want to. And I've already made my submissions, and out of that, they can look. Remember, the staff that must work these things, they are not machines. For them to listen to us, it's abuse. Not in the negative way, but I mean, we really clog in their system, and they still have to rework these things. They are not supposed to be employed for night duties and over the weekend. Yeah, but I guess I'm supporting Umkwena in what he was saying, and we are ready to take it, Chair.
Okay, let's start by seeing what proposals are you putting. We'll come down, Loliwe will come this way and we'll end with you.
Thank you, Chair. I'm putting proposals to the entire recommendations, 4 broad proposals in principle.
Before you put the proposals, we're saying
Oh,
what
you're
work
still talking
method.
about- No, I agree that we proceed.
Line by line or paragraph, chapter by chapter?
No,
The
we
10-minute one,
Yeah,
the 10-minute one, whatever the time is, but we're saying the 10-minute one. That's fine. Loliwe, what is your proposal, ma'am?
Chair, I'm worried because we adopt an approach and in the middle we want to change the approach. Where I'm seated, if we say we give each other 10 minutes, it's gonna bog down to what we are doing now. Because we would want to reflect on what somebody else has said on a particular clause. Remember, this is the crucial part of the work that we are doing. And there should be no instance where we said, on Monday, I never knew that this is captured in this particular fashion. For me, let us be business-like as we make our inputs. But to me, this clause by clause thing is making our work authentic. Because if we take an umbrella, it means we'll take the whole day. But Chair, what you said initially, that you only speak when you want to. It's not a matter of for every clause you say everybody have a bite, everybody have a bite. There may be people who don't want to speak in other clauses. So let's create that space. Thanks, Chair.
Thanks, Chair. I agree with Honorable Loliwe. The work we're doing here is work of national importance. It's about fixing a multi-million state-owned company that is steeped in deep rot. The most important bit of our work is the recommendations. We cannot absolutely rush them. We need to sit down, we need to be considered, we need to go through it clause by clause, we need to debate every recommendation in public like we have done for the rest of the inquiry. If these recommendations are weak, if these recommendations are not carefully considered, our entire work will mean nothing. This is part of the reason why we said yesterday, let's work through the night, because we knew that every single clause will take a lot of debate. So my suggestion, clause by clause, if we have to sit over the weekend, so be it. We are public servants and we're not only paid to work during the week, also on weekends.
Chair, I don't understand the logic. We've spent days here going through clause by clause and other chapters, but when it comes to the crux of the matter, the most important chapter, the recommendations, we now want to, combine everything, consolidate, and not brush over, but not give it its due deserves that it does deserve. And this document's credibility is going to rest on the recommendations and how we interrogate those recommendations. And so, we've known from people, when we go back to our constituencies, the amount of interest that is in this particular issue. We know that. I think we're all actually taken aback that so many people are watching us on TV. And the fact is, given, smile, given that importance, we owe it to the public to interrogate each one of these recommendations one by one. Thank you.
Thank you, Chair. I don't know what informs the point that the colleagues are now saying, I'll shame to the interim board, shame poor people. Shame, I don't know what informs that. The fact is that this process, Chair, we have started it very well. And I don't know why we have to divert from what we have started. No. The fact is that if it's a question of time, I think we need just to agree that if a colleague feels that maybe 5 o'clock or 6 o'clock must be finished, but agree on a process that if we have not completed this recommendation, what must happen? Either colleagues can be given an opportunity to communicate their views, in fact, if they want to make further inputs. As they stand for now, there's nothing wrong with this recommendation so far. What we're already doing, we're beginning to identify what is short-term and what is long-term. Short-term, we're saying that these are meant for the interim board to go and implement as a matter of agent. And that process was moving very well. Then from there, we can then identify what is long-term. We can do, it's on Tuesday, Chair. The model that we must take is that let's continue until we get tired and said, now we are tired, therefore the process that will then have to unfold is the following, which will be to give what you call inputs there. Then because we have capacity, Chair, because you are able to produce this work, we can never underestimate your capacity that you have produced this work. We can even task you again to further go and reinforce these recommendations as they stand here. There's nothing wrong with that.
Chairperson, thank you. I find it very interesting that we have differing of opinions just about the process, because this is what it is. I think we all are committed to concluding the work and responsibility with absolute commitment and with seriousness. So I think it's more about the process. How will we achieve the best outcome and have recommendations that are practical and implementable and in line with our mandate? So I would be very circumspect to criticize anybody who has a different idea. I think we started this morning in the observations, and we realized we're going nowhere. And then we came back and we looked at the different aspects, and we came up with very valuable contributions. I believe we can do the same with the recommendations. If we categorize the recommendations, and we actually base these recommendations on our observations, we could do the same. The board, the interim board, ultimately the final board. You see, the problem that I see is that we wanted to tell the interim board all the details of what policies must be reviewed, etc., and that doesn't fly. We must say to the interim board must have an immediate interventionist approach and must stabilize. And thereafter, the rest, there's a new board, and the interim board has 6 months to operate. I pity them because I know how hard the previous interim board worked. So that is why I'm not, I'm not saying that they will not be good enough to do it. I'm just saying, don't overload and don't expect too much. My suggestion would be that we actually look at the heading the board, that we see what is it that we think the interim board must do, and then ultimately the other board that must be appointed, and then look at the role of the shareholder. What can we recommend for a strengthening and improvement there? Look at the legal status and governance aspect. Look at the corporate governance issues. And so my suggestion is that we don't go into the semantics of every sub-phrase, but that we look, does it capture, and is it implementable? Otherwise, Parliament is used to taking unimplementable resolutions. And what happens? Nothing. How many times have committees not recommended to Parliament? So I'm suggesting that we are going to be serious if we do it in this way. Thank you, Chair.
Is T now? All right, no, it's T now. No, we were, yeah, because I think maybe we need a, whatever the case might be. Honourable members, I mean, what is not negotiable is that we can never skirt what we do. We can't skirt what we're doing, and we won't allow it. What is also not negotiable is that the 28th is the deadline, and therefore we work backwards. And if we want to meet on the 15th, it means that sometime between, not the 15th, the 24th, sometime between now and the 24th, you guys are going to have to give us reasonable time to compare this document. You need to understand that you're going to give us reasonable time to compile this document. So you take a day away from it. You need a day to prepare. So we have no option but to finish this thing in the next 24 hours. We have no option but to finish this thing in the next 24 hours. Aslal namhlanje. Aklalwa. All right. No, it's fine. We will work, because otherwise don't expect a product that is going to be defendable, credible, and whatever the case might be. People will leave tomorrow morning if they must leave tomorrow morning. That's fine. We will come back after tea. We will come back after tea, having refreshed ourselves, preparing. I'm sure you'll prepare supper. I'm just so sorry because remember, we're putting unnecessary pressure on people that don't have to be working after hours. But they will bear with us. We will have tea. We will come back. We will go back to the board. 14.1. We will try and deal with 14.1. Everybody, again, if there's, and again we're saying, if this thing satisfies you 99%, honorable members, then let's agree that it satisfies us 99%, but who, why, and those type of things, it's not our responsibility. That's the board's responsibility. There are 4 or 5 that we can say on these ones, this one point is the key point. For instance, the appointment of the board or something, but we were almost trying to work out the job description of these people. That's not our responsibility. So I'm just saying, as we go and have lunch, tea, let's just think of what we want to do. But we're going to go back to close one, or I mean the board. We'll go to stakeholder, we'll go to all those other ones and try and do as best a job possible, but we're going to complete it tonight. We're going to complete it tonight. That's fine. We will resume at 4 o'clock. Tea, isn't it? Is tea ready? Yeah, tea is normally 15 minutes. I'm giving you 20 minutes for tea. You'll come back and we're going to, and again, we can learn as we go along. There's no problem with us learning as we go along. But the end product must be credible. We will come back, close one, and you will talk on the board. And then you'll talk on the shareholder, and then you'll talk on everything else. No, it's fine. No, it's fine. So, Siabuya go 4. Sharp.
That's nice. Aye, long night. You staying tonight?
Yes. These things are disorganized.
Aye, true, very bad. I don't know why I'm on it. I don't know why I'm on it. Very accepted one another.
Started early. I mean, we're here early this year. Oh, this is going to be a long.
Next week, we again.
Yes. Uchoba. Oh, uchoba benifana buyanga prof. We said we'll stick together till the end. Siyafika prof. But ke ngoku ndiyamunlayita. Yes. Badinga ubotshwa nangoku. Yile nto sivele singamasela.
You can create a situation for your book. Avela amaphoyisa abambona endleleni.
Asabophe wena.
Aye, one night less at all. Tuesday we're starting at 2 o'clock.
No, I got my kids. I was going to bring them here. They said they really don't want to go to Parliament.
Aye, like my wife. Never want to.
I wanted them to sit there. I had to look for someone to
Look after.
look after them while I'm here. Fridays are my days with them before I go home. Or sometimes I go to the Eastern Cape with them. But now they are moving.
I know. My wife said she's not going to come again. Tomorrow we have plans.
All right. This is called negotiations. Honorable members, can I make a proposal and get some sort of discussion going on the proposal? And the proposal is as follows. The proposal is as follows, that first of all, the principle is that we're not going to compromise on the good work we've done so far. That's where we're moving from. And therefore, being unrealistic and dogmatic about us adopting a draft report on the 24th is going to have to be reconsidered, and this is the reconsideration that I'm making. That we still are going to meet our deadline of the 28th of February to present. So we are suggesting, honorable members, that we will, today is the 20th. We all have agreed that we will get together on the 24th in the afternoon anyway. That is Tuesday. So if we worked from the 24th towards concluding the report on the 27th, I mean this process that we are doing, which is the 27th of February, or in other words, the draft report. January, I beg your pardon. So it gives us next week, in other words, to continue what we're doing now. Tuesday, Wednesday, Thursday, Friday, right? By Friday we're done. So by Friday is the 27th. On the 27th, which is next week Friday, I'm saying at the outer date, we adopt our draft report, okay? Which then means that the 14 days that members, or no, that affected parties have to consider will then run from the 31st until the 16th of February. Those will be the 14 days to consider. They will consider, they will give us their responses back. The Tuesday thereafter will be something like the 22nd, 21st. Then we use the 21st to consolidate the feedback we've received from members. To either factor, not from members, from affected parties, to factor them in. On the 22nd, we finally adopt a report that goes to Parliament, which would be the 28th. In other words, we'll push everything back by a week. That's the essence. Because we would have done it on the 15th, we'll now have to do it on the 22nd. Because remember, our deadline is the 28th of February. Is that agreed to? Let me say to you slowly. Tuesday next week, up until Friday, or up until Thursday, we try and conclude what we were doing in a comprehensive fashion. Thursday will be round about the 27th of January. 20? Thursday is the 22nd. 26, that's what I'm saying. Yeah, we're working towards the 26th to adopt our draft report. Members are with us? At the latest, yes. If we do it before that, it's fine. Then the 31st plus 14 days takes us to the 16th of February, where people will consider the report. The 21st, we will consider the responses to try and assimilate them. The 22nd, we will then be hopefully in a position to adopt the report with the assimilations. We would have still met our date of the 28th. That's the broad principle we're talking about in terms of time frames. If that's agreed upon, honorable members, what that means is that we don't have to today quibble about, do we go clause by clause, do we go paragraph by paragraph? We do the right thing. We do the right thing, which is do a solid job. It's unfortunate that we might have destabilized some people today or tomorrow, but my proposal then would be, can we work until 6 o'clock tonight? Yes. Wherever we get to at 6 o'clock tonight. We will then come back on Tuesday after 2, continue from there, Wednesday, Thursday, and Friday. I'm saying the outer date would be Friday to conclude this matter. Tuesday afternoon, because Tuesday morning people have got other engagements in their committees. That was a suggestion that was on the table last week. I thought we'd agree to it. No, it's fine. You'll talk to all these positions. I'm just saying to you that's the broad outline that I'm giving, and whether it's morning or afternoon, we can debate about it. The principle is, let's do the correct thing and add an extra 4 days to complete this work that we are doing today. And all I'm saying is that it would mean, instead of us working until midnight and doing it just for compliance sake, we'll finish at 6 tonight and we'll reconvene on Tuesday. Now, whether it's Tuesday at morning or Tuesday in the evening, at 2, we can argue about that later on. But let's agree on the broad principle that we will reconvene on Tuesday, which will give us then from Tuesday until about Friday to conclude whatever we're doing now, give it out to the affected parties, and then around about the 21st, 22nd, we tighten up our report. So that's the broad principle, that it's Tuesday, Wednesday, Thursday, Friday next week for us to complete this. The question is, do we start Tuesday at 2 o'clock? Do we start Tuesday at 9 o'clock or 10 o'clock? No, I agree with you. I'm saying that's the only area that seems to be an area that we must iron out, if we agree on the broad principle. So let's agree on the broad principle first. Because if we've got this whole day, even if we decided to do it, somebody's mic is on at the back. We do, there at the back there's a mic on. see who's got what engagement on Tuesday. The principle was that on Tuesday, and I'm not even sure that we'll have to listen to the people's apologies on Tuesday, because I thought this was priority for all of us anyway at the beginning. Many people had cancelled, others would have got important matters, but I'm saying let's discuss that. But the broad principle, instead of rushing this, we agree that we will continue until 6 tonight and then work next week and take it from there. Is the broad principle agreed upon? The broad principle is agreed upon. So we'll work until 6 o'clock tonight. The only thing that's outstanding then now is that earlier on we had all agreed that we were going to start at 2 o'clock on Tuesday. I thought that was the agreement that we had all along. But Honourable are saying, but why not Tuesday morning or why Tuesday evening? Can we have a little discussion just around that matter only? Because whatever you decide upon, we have to go and implement, both in terms of getting permission and getting venues and all those type of things. So it's not as if it's up to us. So we agreed on the broad principle. We'll work until 6 o'clock, and we're going to have this discussion for 5 minutes, otherwise we're wasting each other's time. 5 minutes. When do we start on Tuesday? 1, 2, 3. When I 4. I'm sorry to be pointing you, but Killian, Van Dam, Singh, and we'll end with Okoza, and then we'll... Oh, everybody wants to speak. Everybody? Not everybody. Okay, let's list it. Killian, Van Dam, Singh, Koza, Waters, and Matlangu. 6 people will speak on this matter and we'll take a decision. And we're only talking on one item, Tuesday. Killian.
Chairperson, I would like to recommend that we start at 10 o'clock to allow members to still fly in the morning. We understand that there are other portfolio committees meeting, but we have agreed last year that we will prioritize this committee. And therefore, I would like to suggest that we start so that we don't run with our backs against timelines again. Those members who, for some other reason, can't make it, they always have somebody to alternate on their behalf. Thank you, Chair.
Thanks, Chair. I mean, we had a planning meeting when we came back, and amongst the other decision that we agreed upon was not calling other witnesses. We agreed that we'd start on Tuesday after lunch. I don't know why we're going back on that now. We understand that there's other people who might have portfolio committee meetings. So can we start? Can I suggest then that we start at 2 p.m. On Tuesday and Wednesday and Thursday? Tuesday, Wednesday, and Thursday. Yeah, in case there's other people with other commitments too. But I don't think it's fair to go back on the agreement on Tuesday. We all agreed at that planning meeting.
Chair, yeah, I've diarised Tuesday. Whatever happens, I can only come in at 2 o'clock on Tuesday. But I think the reason that we considered 2 o'clock was we were informed that there was going to be a communications portfolio committee meeting to deal with the question of the interim board. I'm looking at what's on for committees next week. It doesn't feature here. I don't know if I say it doesn't feature here. There's a committee of telecommunication and postal service, which is something else, technology, home affairs, environmental affairs, mineral resources, etc. I think the concession was that if the communications portfolio committee was sitting, then we would rather them deal with the interim, and Honourable Van Dam was important in that committee. But I don't see it. But if they are sitting and there's official notification, then I don't see a train smash in us starting at 2. Not because it suits me, but I have to go to a funeral the day before, and there are no flights from, like Honourable Killian has. I mean, she doesn't have a flight. Like other people from Johannesburg and things, are advantage of having flights, 8 flights a day. Thank you.
Koza?
Chair, you know, when we started as this committee, and it's a real pity we now wanted to deviate and do other things, we had agreed that we shall dedicate our time to this work until we are done. Now, some of us, like for example, I for one, my committee, you can see from that, my finance committee is sitting and we have a very important issue that we're gonna be dealing with. I've actually been asked to perform some tasks for tomorrow to prepare for that meeting on Wednesday. And I was only going to step out for that few minutes during those public hearings and come back. Now, if we are going to be, to be accommodating on other members as if others are indispensable and others are dispensable, I don't think it's the correct way of conducting this business. And I honestly support Honorable Killian that let's start at 10 a.m. so that we are able to be thorough and do this job diligently as we are supposed to. Thank you, Chair.
Chair, I don't think people that want to attend the committee meetings aren't giving their full attention or energy to this committee. This committee's been going on for quite a while now, and it is unfortunate that ordinary committees, if I can use that word, are starting to meet. And all members have obligations on other committees. So I think we need to be a bit flexible here. We have found an extra week in the program, within the deadlines we have to meet, in order to deal with the recommendations. We had agreed as a committee, no one opposed, in fact everyone agreed here, that on Tuesday we would meet at 2 o'clock. And I actually don't know why people are reneging on that commitment. But I do believe, Chair, that if other members would like to go to their committees or need to go to their committees in the morning, we should be flexible. We should hear who else has other meetings to go to. But if we work at least Tuesday afternoon into the night like we're doing tonight, Wednesday, Thursday, and then Friday, where committees don't meet, we start early in the morning, I think we can get through this in time. Thank you.
Chair, I think with the experience that we've had, especially today, yesterday and today, our work has become it has been very difficult to make progress because we were trying to be as thorough as it's possible. The danger of us failing to use every opportunity that we have to do our work is that we may actually be faced with a problem that we end up with unfinished work. And therefore, I would support those that are saying let's start on Tuesday morning. Because at least as members of parliament, we do have alternates. All of us here, we've got alternates, and we've been alternating. That has been happening. My only problem is just, my only concern is the team, your Cindy and company, because they need time to do the work. And if it doesn't affect them, I would only budget for them, but not for ourselves, I think. So for now, unless if I get any other matter that is administrative, I would really say for us, let's sacrifice. We know we've got alternates, all of us have got alternates, we can do the work. Losing 2-4 hours, Nkwankwa has been in and out, and I think he catches up, and you could see that even when he came in, he was very relevant because he follows the things. We are all on course, and I think there's nothing new that we are bringing. All the things have been generated. I think we can do it, Chair.
All right. We've heard the views. Let's agree that we agree on the principle. Honourable members, I really am appealing to all of us. We all agree that this job is unfortunately the focus of everybody in terms of one, the thoroughness, and two, the urgency, and all those good things that we have. So we can't miss the 28th deadline. Having listened to everybody, and I think Honourable Nkwankwa will attest to the fact that even yesterday when he put his point on the table, as strong as it was, ultimately the decision of the majority prevailed at the time. And the majority view seems to be saying that we must work at 10 o'clock. we must start at 10 o'clock. Tuesday, if we've got Tuesday, Wednesday, and Thursday, I'm just appealing to all of us that even if Ma'am Van Damme and you, Ma'am Koza, and other people have got other business to do on Tuesday, is it not possible that we can, on Tuesday, unless they need a quorum wherever we're going to, that we can focus on this one, because we've 90% of the way now. We're 90% of the way now, because honestly, everybody, as Honorable Waters is saying, would have other, in fact, not would have, we all have other commitments, some of us 2 or 3 commitments. As unpopular as it's going to sound, but being the Democrat that we're all supposed to be, I think the ruling is going to be that we're going to start at 10 o'clock on Tuesday. And hopefully those that sacrifice Tuesday, because they had budgeted Tuesday afternoon anyway, they will miss at most 2 hours of what we are doing on Tuesday here, if they really cannot be here on Tuesday, and rejoin us at 2 o'clock in the afternoon. So we'll work on Tuesday from 10 until 5, Wednesday from 10 until 5, Thursday from 10 until 5, and Friday from whatever time. Hopefully we don't need to do Friday. So the reality is that you'd only miss out on Tuesday if I take Van Damme's case. I don't know other members why they would have agreed to go to the other committees when we all had dedicated this committee as our primary committee anyway. I thought we'd all blocked out this as our primary committee anyway. So we will meet at 10 o'clock on Tuesday. We'll work until 6 tonight. We'll meet at 10 o'clock on Tuesday, and we're appealing to everybody rather, well, not, we can't appeal to everybody rather to be here, but we're saying can as many people as possible be here, because we're going to continue with work that I think needs to be as thorough as possible. Is that acceptable to members? It might not acceptable to members, but I'm saying that's the decision that we're taking, that we'll start at 10 o'clock on Tuesday. Cindy, you will make the necessary arrangements from 2 o'clock to 10 o'clock in terms of venue, and we will take it from there. You want, oh, okay, I thought you were coming to share with me. All right, agreed. Thank you. We'll prepare dinner at 6 o'clock, and in other words, we'll work until 6 o'clock tonight, and then we will reconvene at 2 o'clock, at 10 o'clock on Tuesday. We had, and I'm sure Cindy would have captured it, we had reached 14.4.1, I think, by the time 14.1.4 was what we were discussing at the time. We're going to go paragraph by paragraph as we all agreed in principle. So can we continue from 14.1.4? We'll see how far we go until 6, and then we'll reconvene at 10 o'clock on Tuesday. Is there anybody else that wants to talk on 14.1.4 that has got something that they want to raise on 14.1.4? Otherwise, we'll get an indication on 14.1.5. 14.1.4 is done. Okay. Okay. 14.1.4, can we get an indication of who wants to still talk on 14.1.4? Is it only you? Killian? Yes.
Just want to make sure that, that we have I think there was an earlier mention of the need for performance management contracts. Now, on 14.1.4, we say that these positions must be filled, but that performance management contracts must be signed and properly maintained.
No, I think it's covered in the document, in 14.1.4, and I think we also agreed, according to Mr. Swartz, that 14.4.3 will also be brought to that 14.1.4 because they talk to the same thing, talks about COO, CFO, and everybody else. We'll merge the two. Okay. All right. 14.1.5. Anybody wants to talk on 14.1.5? We said we'll remove it. Have people, but no, there was a proposal to remove it. Those that still want to speak to it can speak to it. 1415. Mr. Singh, you indicating you want to talk? Anybody else? And Matlangu.
Just clarity to what you just said now. You said 14.4.
No, we said 1414 goes together with 1443.
14.4.3.
Which talks about the appointment of the CFO, COO, and GCO, which is what Honorable Chauke raised earlier on.
Oh, yeah, well, and we're saying that matter is closed now, Chair? Because I'd like to make an input on that one. Especially because we're taking 14.4.3 from the other side, we bring it this side.
That was what we agreed upon earlier on.
Okay, I would like to
1414.
14.4.3.
No, we're not talking to 1443. Or you're saying because we're bringing it over, you want to talk to it before it comes over?
Yes.
All right. Kwankwa, which one, do you want to talk to 1414 as well? Yes. Okay. When we say 1414, we're basically combining the two and you'll talk to them. All right. Matlangu and then Kwankwa.
Chair, 14.4.3 speaks to the appointment of the 3 people. Now, what I want to bring to the table is that over and above these people that must be appointed, we should remember that we've got 2 categories of people. People who were purged, a person that has been elevated from the position of company secretary to the general manager, which is obviously an unprocedural, and a host of other senior managers that replaced those that were removed. My view is that the process, the interim board should, in line with what we had spoken about at 14.14, also be assisted to consider whether those irregular appointments should not be annulled.
Chairperson, I think the issue about when it comes to the appointment, the filling of critical senior management positions, in general, there is a point I made yesterday, if you remember correctly, that there seems to be an abuse of the loophole around the acting period of 6 months. If you exceed 6 months period, that they allow you to act for more than 6 months before they appoint you into that position without following proper due process in terms of the recruitment. That's how they bypass it or circumvent it. Now, is there a way that we can make this 14.14 to speak to that as a recommendation, for an example, to the board? To say that, I'm not too sure how to put it though. I'm sure you understand what I'm trying to say. Because the problem in the past is that people would then be appointed without following due process or without the positions being advertised because they're acting, and then they're allowed to sit in that position for more than 6 months and then they're just confirmed, which is a problem. I think it's something that we need to address and nip in the bud in that recommendation. You can find nice English of how to put it. Thank you.
I think the point that you're making is saying that those posts must be filled by permanent employees, because it then takes away the acting part of it, as well as following the HR or complying with HR policies. I'm saying mixing those things up. That's the sentiment you're raising, Bob. Okay. All right. Got it. Anything else on 14.14? And remember, 14.43 will then fall away. Can we go to... No, you can't ask me. You must make a recommendation, ma'am.
Okay, Chairperson. Chairperson, we actually deleted 14.1.5, but in view of an earlier comment made with regards to differentiating between the interventionist, immediate, urgent measures that the interim board should institute, and then the appointment of a permanent board, is that clause not meant to refer to the new board? Because it's a good point to make that it must be done in terms of the Public Broadcasting Act. But I was just wondering if we shouldn't collapse 14.15 and then 14.16, so that we have a clear understanding that in the meantime, there's an interim board that will now be, appointed. In the meantime, proper processes should also be commenced with to ensure that a new board is appointed within the time period. So I was just wondering if 14.15 could not perhaps serve that purpose, so that we don't delete it, but we just reword it.
Let us tell you what the sentiment was when we put it there. Remember earlier on we were arguing that some board members are appointed or removed via the company and some are appointed or removed via the PBA. Earlier on we took a decision that the PBA is supreme. So I think this was basically trying to re-emphasize that one. That's what the intention was, I think, when we were putting it there, that there must be no ambiguity that anybody that's appointed as a board member, of course outside of the interim board maybe, must be appointed and removed via the Public Broadcasting Act. That was the intention. Now, whether we, and the point we are arguing here is, do we remove 1415, do we combine it with 1416, or what do we do with it? I think that's where we are now. Honourable Singh.
Yeah, Chair, that's what I wanted to speak to, 15 and 16, but Ms. Killian made a good point there. I think you've answered the appointment and removal, because I wanted to know why we're speaking about both appointment and removal. But I think here we should also recommend to the Portfolio Committee through Parliament that they put down a time frame on the processes to appoint the board. So they can say, we're going to start the process in 3 months or whatever it is. Even though there's an interim board, doesn't mean that we must just wait, you know. So they must give us a time frame of when are they going to start that process of the appointment of a permanent board for the SABC. But having said that, when we say transparent, we can combine it. What do we mean by transparent? Now, my understanding of transparent from some discussions we had early on, and I would like to propose, it must be as transparent as the way we appointed the public protector. It must be a public process. It's never been that way before and received that kind of prominence. It must be that kind of public process of people having an opportunity to come and speak, for or against certain board members. We had civil societies coming in with the PP, Honorable Khosa, came in and spoke, and I think here we've now realized the importance and the gravity of responsibility that the SABC board has to South Africa, and we must make sure that process is transparent in that manner. So 2 things on 14, 15 and 6, the timeframes and the transparency expansion.
Okay. I'll come to you, Van Damme, and you can help us answer this one. Remember, honourable members, it's Parliament that's going to adopt this report, so it can't be answering to us. So if, and I agree with what you point, maybe in our recommendations we should be saying Parliament, the mother body, must give the accounting authority or the appointing authority 2 months in which to begin, or something like that. Because remember, it will be adopted by Parliament and go down, as opposed to we say to them they must do it in 2 or 3 weeks. So the suggestion is that we combine it, that we say it must be transparent and open up that, or explain the transparency if we want to. Not if we want to, that's the proposal made by Singh, and timeframes. Van Damme, you want to talk to 1415, 1416? Do they stay? Do we combine them, or what do we do?
Okay, 2 things, Chair. Just to explain what's going on in the Communications Committee about the interim board. So on Tuesday, the committee will meet to decide the process of appointing the interim board. And then following that, then the appointment process will happen. So I don't think for the purposes of this report, we need to spend that much time talking about timelines. It's already happening. The appointment is going to happen. But on an entirely different point, I wanted to include a recommendation about us recommending to the Portfolio Committee on Public Enterprises to hold an inquiry into the fitness of the of Dr. Ben Gubane to chair the ESCOM board. Now, I don't know if this is a natural place to put it, but I thought it's something that might fit in nicely here, or we can add a clause somewhere else. But since we're talking about removal of board members, I don't know if it would fit there, or maybe we should put it in somewhere else.
Can we park it and put it in somewhere else? Because I thought we were talking about, because remember just now we said we were going to say, when we talk about board, be specific to SABC matters. But at that point, can we park it, and it's one matter that we can come back to and visit. Is that okay? Because that one is now something totally different to our mandate in terms of, although the individual might have been here, but it's a totally different matter. I just want us to limit ourselves to 1415 and 1416. Sir.
Yeah, Chairperson, just in response to Honourable Van Dam, the time frame I referred to is not for the interim board. We know there's a process, but the permanent board, it can't be unending. We've got to give them. Yeah. Yes, Wamanje. Wait. Yes.
Kubiso, you want to talk to 1415 and 1416?
Yes, Chair. I want to agree with the sentiments expressed by Honourable Singh, because remember when we're dealing with the observations, I touched on that point, and you said it seems like it's a recommendation. So I would wish that we do recommend to the portfolio committee that this process be as transparent as possible, like it is done with the public protector. So I'll go with the sentiments expressed by Honourable Singh. But of course, on the time frame, we might not be certain, because we're going to have an interim board anyway. It can't be 2 weeks. It can't be done 2 weeks. 2 3 months, then we can solicit some responses from the public.
No, I think the sentiment Singh is raising. So we're getting back into the, or we're falling back into the trap that we had earlier on when we want to be too prescriptive. I think what Singh is, no, hold on. What Singh is saying, there's an interim board that's taking its place. Parliament, when it accepts this recommendation, must be able to say to the new board, to the PC, when you embark on appointing a permanent board, be transparent, and we'll use those transparent things. In other words, do it as soon as is possible. You don't have to wait until the last minute before you do that one. I think that's what we're saying very broadly. Remember, we got bogged down just now by trying to be overly prescriptive, but I think the fact that this is what we mean by transparency is fair, because we've learned the lesson, and time, yes.
But we must also note that in the recommendation observations, this point is also there. I don't know where it is, but it's one of the things that are put on paper, you know.
No, all in agreement that it must be done as soon as possible. It mustn't wait and be, this is over and then that one is done. We'll try and factor it in so that it's done as timelessly as possible, and also as credible, transparent, and all those things we used. Do you really want to talk on this point, Honourable Baba? Yes?
No, it's an addition I've made earlier. I'm not sure if it's still carrying water till now on this point of the involvement of the state security in the process, so that we don't go at the end having done all those processes and they are not on board throughout. And then in the last hour, we then discover that the whole 5 years, there's never been vetting and all of that. I thought that those processes must just go concurrent. Because if you want to refer it to how the public protector process was done, if you recall that all CVs were subjected to a particular process of vetting. So you may want to do the same again with this process, if you had to link it up directly with what happened there. Which will make a lot of sense, by the way, Chair. It then addresses what we have identified as a weakness, by the way, that you end up with executives that are not vetted and all of that. And especially now that we have now prioritized the issue of the CFO, the CEO, and the COO, which currently SABC does not even have. The CEO is not in place except one person there. So in that process, as we advertise and appoint, you immediately ignite that process of a state security to come on board.
Right, we'll try and capture that. Although that one I would imagine goes to the one before, because now we're talking about the board. That was, I mean, and you're saying it applies to the board and to the executive. I think that's the point you're making. Because now we're talking about the board. You're saying both of them. Yes, that's fine. All right. Okay.
I'm prepared to submit a little clause on 1415, capturing what the members have said about transparency.
It's fine. That'll be 1415, 1416, and everything else that everybody's saying. It's fine. Yes, sir?
No, just to point, Chair, that the Broadcasting Act actually does speak to that transparency. I'm not sure if it's important for us to. It's in the Broadcast Act, 13(2)(b).
No,
I would strongly suggest that we leave it out.
I'm going back to the point that we made earlier on. If there's existing legislation, I think that legislation generally covers all. This is not about lack of legislation in the main. This is lack of implementation and compliance to it. So when we say a point according to the PBA, I'm sure the PBA will cover everything, and it must take cognizance of the Constitution, but the point is taken. So your point of, I think it was, somebody was saying that it must be like it was done in the Public Protector. Let's just say they must appoint according to the PBA, and of course lessons learned even from this one will automatically fit into people going forward. Is that okay, honorable members? Siyabonga. 1417. Anybody 1417?
Delete. What is the relevance of that, Chair? It doesn't make sense. If there's a court order, then you've got to comply with the court order. That's all it says. If there's a court order, the appointing authority must implement reasonable corrective action in terms of the court order.
Let's explain. Of course, you're right. All that we were saying, remember, there was a public protector order, and it was not complied with. I mean, it was in that. No, hold on. Yes, no, I'm saying people can argue. We'll try and explain why we put it here, and if what we put here is total nonsensical, we'll remove it. But we were putting it there in light of the experience that we had learned earlier on, that sometimes there are laws that are non-negotiable or enforceable, and they were not enforced. I'm saying from the experience here, that was it. But if it's now become a matter that we don't have to put in, I don't think it'll be a train smash. Remove? Remove, okay?
I think, Chair, just
hold on, everybody wants to speak. Okay, I'm saying the question that everybody must answer when you speak is remove or don't remove, because we gave you the motivation why. You'll be number 2, and Van Damme will be number 3, and you'll be number 4, and you'll be number 5. Remove, don't remove.
Chair, don't. And I would recommend that probably we recraft it so that it's a lot clearer why we are putting it there. Because it's coming with enforcement. Remember, we had a challenge of the current, of the former COO, who was, the court had ruled, and he was seen there again, and there was a problem with that. So that those that are coming in, whether it's the new board, whether it's new executives that are going to be coming at SABC, they needed to know that this matter has been elevated because it's been a serious concern. So one way or the other, let's find a way of crafting it differently, but it has to be there because it's an existing problem.
No, Chair, I think we must not be traumatized by what has happened in the current board. Remember, we said that when the new board is inserted, that we're going to induct them. When we induct them, it means that there's a new culture of compliance and all of those things. So, again, I think in that context, we're being too prescriptive here to say, we're micromanaging them. Then we might as well just tell them what happens if an employee goes to CCMA and all of those things.
Thanks, Chair. When I initially read this clause, I thought it was talking about something completely different because there's 3 board members currently challenging their removal from the SABC board. I think it's Kaladas, Lubisi, and I think the late Hope Zinde. So I thought that's what we were talking about in this recommendation. Oh, yes.
Let us withdraw, yes. Remember, and again, we could be wrong. Where we were sitting, I was under the impression at least one of them were challenging their dismissal, all 3 of them. Yeah, this was talking to that. That was saying if the court in fact said, whatever it said, then the matter must be resolved. Yes, we're talking about the board members, not employees, so I'm sorry if I misled you. There were 3 board members dismissed, they challenged their dismissal. We are saying here, once that court matter is done, the new board will have to do whatever needs to be done. And that's what we were trying to say. But we were talking specifically of those that were challenging it. Unless the court case has been, and I think, before you carry on, I think Mr. Swart's point is still correct. If the court said reinstate them, or the court said pay them, I don't know if this thing is necessary, but just to put it into context, we were talking about those 3 board members. If people want to comment on it, you can comment. I was sorry, I misled you. Let's again start 1. No, I agree. No, what I was saying, you can be the first one. What I'm saying is that I misled people because they were talking on employees. But now I was clarifying that we were talking on the board members. You can be the very first one to talk on the board members, Mr. Swart. You'll be number 2. You'll be number 3 on board members. Anybody else want to talk on board members? 4. Sir.
Chair, on conclusion, as it states there, by certain, then you'd obviously have to put in former board members challenging the legality. The appointing authority must implement all reasonable corrective action. Then, if you want it in, then you must say the court order. But the appointing authority could appeal it. They could appeal it. That's the big problem with the litigation. They appeal it and it's not implemented. And that's why these matters continue. But if you want to have a very specific issue on that, why are you highlighting that specific issue? What about the public protector? What about all the other court orders? Surely the generic provision should be that the appointing authority, if you want to have something, must speedily implement any court order. Is that not something? Court order or finding by an institution. Is that not the answer? But you don't really have to say it. But if you want to highlight it because of non-compliance in the past, then it's up to you. That's the option.
Okay, there's an argument for it being taken out. You still want to speak? It was Khoza, and then Van Dam, and then Killian, and you'll be the last one, sir.
Chair, the example you've given is bringing another complication to this matter. Remember earlier on, we had, when we considered 14.1.1, about when we said the ad hoc committee recommends that the dissolution of the SABC board be expedited and finalized urgently. We all did not see that being relevant anymore because we said there is no board. But probably, technically, you may actually still need that. So that you are starting on a new slate. So I'm saying, Chair, it probably might be bringing that complication, and I think maybe both clauses are relevant from what you've just said, but that other clause shouldn't be applicable only to this specific matter that you were referring to. Let's make it applicable to everything in that institution. Let's not make any exemption. In any case, we can't make exemptions when it comes to the implementation of court orders.
And other binding orders. I mean, it's the point that Honorable Swartz is making. But you are saying that 4.1.1 we must reconsider and reinstate it. Yeah. That's what you are saying. That's what I'm saying. Yes, it's fine. Killian, and then Oh, was it you? Sorry, it's you, Killian, and then, not you, Van Dam, Killian, and then Kwangwa.
Thank you, Chair. I think I agree with Honourable Swart. We do need to include a provision there about the SABC adhering to court orders. There was a problem of the SABC litigating all the time, pursuing cases that they couldn't win. So I do think we do need to include a general recommendation about litigation and court orders, but more specifically and more urgently, related to the COO, the Western Cape High Court said that a disciplinary inquiry needs to be held into his fitness to hold office. So I think that is something that's urgent, and that's something we need to be explicit about related to court orders. But otherwise, we can be general and say, you know, you must follow court orders, don't litigate unnecessarily.
Chairperson, yes. I would argue for just a redrafting. I would strongly argue for its retention. I would like to suggest that we don't speak of the appointing authority, because then we are, creating confusion. It must be the board must implement all reasonable corrective action. But I would like to suggest that we also make sure that this serves as an example, because remember, we have all along said that state-owned entities have become embroiled in all sorts of internal fighting, etc. Now, if the Company Act could be used by other entities to get rid of board members, it must serve as a deterrent for them, that those members who have in fact taken the decision in the board, and it is minuted, and if the court says that those who took such a resolution should be held responsible for the expenditure, the costs, which should be recovered from them, that would also act as a deterrent to get our boards in shape again. So I would strongly argue that this should be recrafted, that we retain the responsibility of all board members to exercise their fiduciary responsibilities in terms of the Public Finance Management Act and in terms of the Companies Act, and take appropriate the steps as prescribed by the Public Protector or any other Chapter 9 institution. If we recraft that, then I think, thank you, then it could be retained.
Chairperson, I'm covered by the last input, the input from the previous speaker. I think I agree entirely, because remember, we're trying to address a specific issue which came out during our cross-examination of witnesses here, which is why that point is there, which is understandable. But I think it should be complemented, as Honorable Killian said, with the point that was made by Honorable Swart earlier on, to say we are trying to address and nip in the bud this kind of conduct where they do not respect court orders, so that we prevent that from happening in future. So even if people do it in future, they would know exactly it's an issue that Parliament once addressed and recommended that it be attended to. Thank you.
Oh, you happy with it? Cindy seems to be happy, and we retain 411. Yes. Yes. But we'll leave it in there, and we can think about it and argue it, because 411, is there a board, is there no board? Our understanding at the time, that whilst there might not be a co-rate board, but strictly speaking, you've got, at the time of the adoption, you will still have those 3 members who are board members. The executive. They are board members, whether they're co-rate or not, and the only way, as we understood it, was to dissolve it, because the board is made up of non-exec and exec members. And the only route to go is to physically, Parliament must physically recommend. But I'm saying, just think about it. We'll put it in red, in fact, this one, so that people can look at, is it necessary, is it not necessary?
Okay, what happens if they are reinstated? But then it falls in compliance with the court order. Yeah.
All right. So what are we saying? Leave it out?
No, I'm agreeing.
You're agreeing that
it's fine, because we've couched it more widely. We'll look at the final wording. And it also covers the next, the 419, which we might, that's almost similar to 419, which
All right, we will try and capture it, and anyway, we'll work on it until we release a draft 2. 418. Again, I mean, the argument would be, before members even get involved, that is in legislation.
Yep.
Yeah. So
Sections.
why do we want to go and taking into account what Honorable Mkwena said, that ideally when people are inducted, they'll be told that if you are a board member, your board must have at least these subcommittees as per Act 123. So the question that we must ask ourselves, I mean, I think we put it in the observations. We don't have to recommend it because people will pick it up from the observations. It doesn't mean that every observation must have a recommendation. The intention of the observation is also to highlight to the people the problems that were there. The question that I'm asking is, if that is, if that is compulsory per the Companies Act, that you must have subcommittees of finance and of auditing and of whatever, why do we still want to say to them they must do it as if they won't be au fait with the Companies Act? I'm saying that's the debate that we're having. Let's start here and we'll go to you, Mr. Singh. Mr. Swart. We're talking specifically 418.
Chairperson, I just feel that we should include the reference to the Broadcasting Act because the Broadcasting Act is quite specific about what must be established as subcommittees and what additional other subcommittees may be established. I would like to include reference to the Broadcasting Act and obviously to Treasury regulations, you know, the PFMA, etc., because certain committees are, in terms of the Companies Act, etc., you know, audit and risk and all of that. But in particular, in this case, there must be a public service subcommittee and there must be a commercial services subcommittee as per the Act. So that's my only contribution. It is a specific body, the SABC.
Are you suggesting we put Companies Act plus the Public Broadcasting Act? Is that what you're suggesting? All right. Swart.
applicable legislation.
Applicable legislation.
Because it could be PFMA, it could be others,
Okay.
but the committees are set up in the Broadcasting Act and the Companies Act. But when they act, when they are doing their work, there might be PFMA issues as well. So you could say Broadcasting Act, Companies Act, and any other applicable legislation.
All right. Agreement? Thanks. 419?
Chair, that's captured in the earlier one, but you might want where we suggested, I suggested, or any binding finding of the public protector. Because that's a bit unclear there. What are we referring? What court judgment are we referring to in that regard?
Yeah, okay. Again, we'll give you our thinking, but it was finished there. Remember, there was a Public Protectors Act that was not implemented, and we were told that. And there was a
Not
court
the act, the findings.
No, there was a findings that we were told were not implemented, and then there was a court judgment that said there must be disciplinary hearings. What we were saying here to the board was just make sure it happens. Just reminding them. That was the intention, that make sure it happens, because we know from the immediate past that it didn't happen. But your point, if that point covers this one, nobody's going to...
Ms. Van Dam's point then is relevant there, where she specifically speaks about the disciplinary action. I think that would come in here, you know, or in a longer clause where you put in them all two. So it is covered, but her point is particular to what you've just said now about the disciplinary action, Chair.
So 419 goes out. So Mr.
We'll capture it all in the earlier one, yeah, as long as we
Yes,
capture it
sir.
in 418.
No, hold on. Can Chauke speak?
No, I was saying that it will then be captured on the other one before that. So I'm fine. But I think in principle, Chair, as a committee, we have agreed that there is no reviewal process of the public protector remedial action based on the, I mean, in the Kunu, no, there's no reviewal because the fact that that came before us, you remember Ngubani, I understand something at the High Court in Gauteng of the reviewal of the public protector. So I think we must be very clear when it come to issues of implementation of the public protector, so that it sort of flow from our understanding that as it stands now, there's no reviewal of those recommended or remedial action. So I thought that it must be noted so that we don't create something that contradicts if there is a process that is being started. If there's no process, therefore, we can then deal with issues of implementation of the public protector's what's called remedial action. But if there's a reviewal, therefore it means that we have to deal with the issues of reviewal. Again, the status of the reviewal, what is it? If the board has lapsed and all of that, there's no longer authority. And that's supposed to be a decision taken by that authority, therefore, to deal with the issues of reviewal. So let me say that let's take that into a point. Maybe on Tuesday when we meet, Chair, we must just be certain that there's no court currently that is reviewing public protectors' thing.
All right. I guess 4.10 again is the same thing. We were basically saying, and again we'll give you the, let's not talk, no, we were trying to conflate two things. We were saying the company secretary must be compelled to do her duties, and there we were referring to the Companies Act is very specific on the duties of the company secretary. And then we said, in addition, there must be total accountability to Parliament. So I don't know if we try to conflate it, but members can talk. You might want to clean it up, you might want to break it up into two more, but that was the spirit in which we were talking about it, that if the company secretary had done what she was supposed to, or he was supposed to do, many of these problems would not have arisen. So, members want to talk to 4.110. Waters, Kubisi, Swartz, Killian, and Chauke.
Chair, thank you. Chair, if you look at the observations that we made about the company secretary in 13.110, we state that she actively and deliberately acted in an obstructive manner which required, when required to provide documentation as requested. And we cited the Powers and Privileges Act there. Well, I raised it and we're going to include that. Now, if you look at what we're suggesting here, we're just saying that the company secretary must be compelled to fulfill all duties as stipulated. And I think that's a bit of a slap on the wrist. The fact of the matter is, Section 17.2e, particularly of the Powers and Privileges Act, says whether or not during examination under Section 15 willfully furnishes a House or committee, we were a committee, with information or makes a statement before it which is false or misleading, which he did, commits an offence and is liable to a fine or imprisonment for a period of not exceeding 2 years, or to both the fine and imprisonment. So I would like to see here, Chair, that we actually call for the laying of criminal charges under Section 17.2e of the Power and Privileges Act against the company secretary.
All right. No, I think your point is valid. Here we were talking about going forward a company secretary. We were not talking about that one. So your point is valid, but can we find a way? Remember, we've got something that we called other. Yeah, but this one we were talking about, this new board must take these things into consideration. And so we were talking about a company secretary, not a specific individual. But I think your point is valid. We can park it and put it somewhere, or you can note it and we can put it at the bottom and come back later. It was Kubisi, it was Swartz, it was Killian. Kubisi?
Chair, the duties of the company secretary are listed in the Act, Broadcasting Act. Companies Act, yeah, listed in the Companies Act. 13.1, 13.2, 13.3, 13.4, that's where they are listed. But then there's an element of sort of not giving the correct information. I was going to say, therefore, punitive measures be taken up against the company secretary who misled the committee. Something on the punitive measures.
Honourable members, what we are saying is correct. I'm saying the point we're making here was not to the company secretary who appeared here. That was going forward. We're going to package what Honorable Waters said and your point in another one. And also what you might have said, but we'll package it. This one was saying this new board must look at it that way, so let's not confuse the two. It was then Swartz and Killian will be the last. Swartz?
Chair, going forward, my thanks to you, Honourable Jabu Mshlangu, because in terms of the King 4 report, it indicates very clearly that what the company secretary should do, and we raised this earlier, induction, orientation, ongoing training and education of directors. That is the responsibility of the company secretary. Assessing their training needs, training, Mr. Mokoena, of directors in their fiduciary and other government responsibilities. So that must also, it would form, and so I support the wording here. I don't know if it must be compelled, but the company secretary must fulfill all duties as stipulated in the relevant legislation, and this is a corporate King Code on Governance, and it's particularly paragraphs 95 onwards, which is very helpful to us. And then in addition to being accountable to Parliament. They must be accountable to Parliament.
No, that's fine.
Thank you, Chair.
So we'll make reference to the legislation without necessarily us spelling it out. And then Killian, you'd be the last one if you still want to add something more to what is already on the table.
Thank you. Thank you, Chair. I believe that we should just, under observations, extend, because we've only captured her inability or unwillingness to provide documentation. We actually did not capture her failure to do her work in terms of legislation. So I think we should strengthen that paragraph 13.1.10. But then here, when we get to 14.1.10, the company secretary must be compelled to fulfill all duties as stipulated in the relevant legislation. And in addition, I would like to suggest delete the rest of that sentence and insert direct the board to account to Parliament in terms of all relevant legislation as well as the shareholders' compact. And what did Honourable Swartz quote from now again? From King 3. I think if we do that, then we also indicate what is the type of qualifications that you require for a company secretary. We've really seen very dismal failure in the recent couple of weeks. So we should take it forward. We should make sure that they comply and direct the members to understand accountability to Parliament, because this as a SOE is different from other companies.
Right. Can we make a general ruling, honourable members? You're correct. As we work here, if we then realize there's something that should be fixed up in the previous one, please give it to us in writing. Otherwise, it makes us here go backward and forward. So your point is valid, but just give it to us in writing. Otherwise, it means Cindy is jumping up and down just to make our work a bit easier. Okay, no, we'll take Chauke and then Singh will be the last one.
No, mine is just to add on the input that you'll make around observation, that we know that the incumbent is currently on acting basis, and therefore there's a need to urgently, because that becomes the engine of the organization, to urgently look at the process, and that will then fall under the interim board as it moves in, look at the process for the appointment of the permanent company secretary, because if that person, and especially issues of someone under what the Honourable Waters has just raised, we have to add with the issues of someone too, because that person must be arrested, and therefore on the observation, those points can then be listed. It will then link with the recommendation. But thank you very much, Chair.
Secretary, Cindy, you don't have to put it. If you read 14.4.3, we spoke specifically about company secretary. 14.4.3. 14, remember we've moved 14.4.3 to the front. Okay. All right. We've then dealt with what is in terms, oh no, I beg your pardon, Singh.
Yeah, Chair, I want to speak to 14.1.11 and 14.1.12, which are not there. They're not there, but I want to make a suggestion. Earlier on, you referred to other. And I see two items on page Yeah, two items on page 36. 1481 and 1482. And I want to suggest they be brought under this heading here of the board. Otherwise, they will get lost there. 81 and 1482, which relate to the TNA breakfast shows and the appointments and the publicists and things like that. And then they must leave the feasibility of the business case of entering into agreements. That the board must do that. And we shouldn't put it under other. That's my suggestion. Thanks.
Okay, so what Honorable Singh is saying, let's take 1418 and 1412 and put it to where we've been talking now, the board's responsibility. Any problem with that? No? So don't talk to them again when we get there. So Cindy will move them. So we'll delete them here. Cindy will understand. We've dealt, honorable members, with what is currently on the table. Is there any additions that we'd want to put in terms of board?
If we're going to do that, can we also then include the issue about the vision view?
Where is it current? Is it? I don't think.
If we're adding 14.81
Yes.
and 14.2,
Yes.
isn't that part of it, I think?
No, we'll come back. Oh, yeah.
Yeah, so they're all part of the thing then,
Yeah. Wouldn't it be covered under the forensic audit?
all of them.
In the first, yeah. Do we,
Yeah, so
Because it's contract management that we're saying will be covered under forensic anyway. But if you want to re-emphasize it, you can do it. But in essence, Honorable Waters is correct. Remember, under the forensic audit that we were asking for, not necessarily completed, but instituted.
I apologize.
Yeah.
Yeah, no, you're right.
All right. Honorable Kamasango.
Chair, I will need some guidance here, but I don't know whether we have dealt with the question that the board should actually, the interim board should annul the decisions taken by the board that did not correct. Whilst it may not be valid, but we may lying there at the SABC as decisions of the board, and they would be irregular. So in order to regularize, the board will need to annul those irregular decisions because we know that they get implemented.
Again, I'm saying, I hear what you're saying, you're correct. But could we say that they must, I mean something like they must address the risk, because somebody raised it as a risk earlier on. Now, when we say annul, it's almost like we are prescribing what they must do. But we must, I think if we say to them, they must be aware that there's this risk and address the risk. Is that okay? Your happiness? Yeah? Okay. The next one would be shareholder, that is 14.4.2. Again, we'll go through what we have here, and we will go through new measures, not new measures, I beg your pardon. We'll go through new introductions if you want to have new introductions. Page 32, 14.4, 14.2.1. Are there speakers? Let's take Van Dam, 14.2.1, and then let's take Singh. And then, hold on. It's Van Dam, it's Singh, it's Masangu, and it is Mokwena, it is Chauke, it will be Kilion. Remember, you're all going to speak for 1 minute because everybody's speaking. It is, no, 1 minute per person, not 1 minute for all of you. Kuvisa, Waters, and Swartz. The only one that doesn't seem to have raised a hand is Honorable Koza. Is that correct? You're not speaking on this point. Thank you very much. Honorable Van, we're dealing with 421. Honorable Van Dam.
Thanks, Chair. To be quick, now, I don't know who this is directed to, but if it's to the current minister, I find it a very wishy-washy. I think she should have known what the legislation says about her role as minister. As we talked about in the observations, we said she interfered, she claimed to have not signed an MOI, and then we had an MOI that was signed. I spoke about the legislation that infringed upon, and I spoke about section 96(2) of the Constitution, which says that a minister, a member of cabinet, may not use their position or any information entrusted to them to enrich themselves or improperly benefit any other person. We know she...
I'll allow you to speak, just so that, I don't know, very much like Honorable Singh, not Singh, I beg your pardon, your colleague next to you, remember we parked the specifics to deal with later. I'm just worried that here we're talking about the board, the shareholder that's coming in. I'm saying that was the intention. Do we, no, we were talking about, remember we were saying the role of the shareholder. Remember there was, what we were saying, there doesn't seem to be clarity. So what we were trying, I'll come to you, you'll be the first one. And if it's not necessary, you can say it. I think what we were saying here, going forward, there must be this clarity of roles. That's what was intended here. It was not for the current shareholder, so if we want to, not the current shareholder representative. If we want to talk about the current shareholder representative, then we can talk about it, but we must just decide if we put it under the role of the shareholder or some other topic. That's basically what I'm saying. Let's distinguish between the two, like we did with the top
Chair,
one.
I think it needs to be under here. The current shareholder should know all of this. It shouldn't have to be explained to her. So that's why I'm saying we need to talk about her role specifically in causing this mess. So by interfering in the appointment of the COO, she violated section 96.2 of the Constitution, which says that a member of cabinet may not use a position to improperly benefit any other person. And also by doing so, I'll write it, yeah, I'll give it to you. By violating section 96.2 of the Constitution, she also violates the Executive Ethics Code, which requires her to fulfill all the obligations imposed by her by the Constitution and law. By also not being fully honest with Parliament, by claiming she did not sign an MOI, and then there was an MOI that she did sign, she violates also again the Powers and Privileges and Immunities Act by not being honest with Parliament, which requires the sanction thereof is criminal charges. For infringing the Executive Ethics Code, we have two recourses available to us. It's either a public protector investigation or an investigation by the Ethics Committee of Parliament. And those are the recommendations we'd like to put forward about the shareholder.
All right, so because Honorable Van Dam has set the scene, and that's why I was cautioning about it. There is the principle that the shareholder was not honoring separation of power. I'm talking about the principle generally. And then there was the stuff that you're talking about. Here we were talking about the principle that, look guys, going forward the shareholder shouldn't do this, but the point that Van Dam made is a point that honorable members can talk to as well if you want to. All we're saying is it makes life easier for us because this, remember, is supposed to be, as we said earlier on, a combat level for the incoming, as opposed to what we think must be corrected for now. All I was asking is that we distinguish between the two when we deal with it. So when you talk on this matter, please say, I want to put it in the combat level area, which means a template for going forward, or to put it as what must happen because of what transpired. And I think what Honorable Van Dam was saying now falls in the recommendation of what must happen in terms of what has come out. So that's correct, that's how we put it. Thanks. Please then just identify. So you understand what I'm saying, Cindy? Thank you very much. Mr. Singh?
Chair Zobagamuva, because I think that's what Honorable Van Dam did. She looked back. Because we have to look back to recommend what we should, the future shareholders representative should not do wrong. And this is what we're saying, they should do 1, 2, 3, 4. Because my view is that the role of the current shareholder representative leaves a lot to be desired. And for the reasons that Honorable Van Dam gave us. And I would go as far as saying that we need to recommend to the appointing authority, which is the president, that he should reconsider the continued appointment or holding of office by the incumbent in this portfolio. That's what I would like to recommend. Thank you.
That fits into the same category where wherever we put Van Dams on, whether it's 14.2 or 14 last, it doesn't matter, but it will fit in that category. That's what we're saying, isn't it? You've captured that? All right, there are firm recommendations. Mahlangu?
Yeah, thank you. We will obviously await the formal suggestion that colleagues have spoken about. Well, I guess I have a different view. And I'm going to make a suggestion. Yes, I'm going to make a suggestion that, Professor Kumalo makes a very important contribution that when people are appointed to be shareholder representatives, they do not undergo the same induction like board members. And I guess I would recommend that any person that gets appointed as a shareholder must undergo the induction that board members undergo, that the amendment to the MOI, I think that one has been dealt with by 1324. The one that I was raising actually is something that is not here. I would recommend, yes, I request that it comes in as 1325. Oh, apologies. 14, my apologies, Chair. 1425 is the one that I spoke about now. It's a new one. Yes, because the current one is up to 1424. So the one that I'm recommending. Yeah, I'm adding another one. And the other recommendation, obviously, I think we've dealt with one of the proposed bill that it must be withdrawn, or the Parliament can obviously consider also stopping it. And yeah, no, I think I'm fine. I'm fine with the time limit.
No, thank you, Chair. 14, yes,
About that.
14.1.
I thought we were dealing, because we decided line by line.
Okay.
Now you guys are doing everything that we're supposed to be doing. No?
Yes. Huh?
Yeah, and I thought we had agreed doing line by line, but it's fine. No, sorry. Before Chauke, I'm sorry, it's supposed to be Mokwena and then Chauke, I'm sorry. Mokwena. We're dealing, because we all agreed we're going paragraph by paragraph. So don't go all over the show. 14.2.1, have you got a problem with it?
No, Chair, I think because there's no resolution here that the current minister is outgoing. So the role of the shareholder is the role of the current shareholder. So I think, given the fact that she failed to rein in the board, to run the SABC proficiently, given the fact that the SABC deteriorated under her watch, given the discrepancies that we picked up in her evidence here, I think it's clear that she's not fit to hold the office of shareholder. So I think the concrete, cogent recommendation that we must make is to the president that she must be fired. And that is the position that we must take, because if we don't take that position, we are then perpetuating a continuing deterioration of the SABC. Remember that the SABC is under her charge. We already know that she's not fit for that position, and that's our yeah. That's the first one. Then the second thing is that the documents that she presented to Parliament, the MOI, that document must be reversed. Yeah. Yeah. No, that's fine. I'm not going all over the show. I'm proper. Yeah. The MOI must be reversed, and the Broadcast Act amendments that she wants to make must also be looked at, investigated, and reversed.
Nice one. Very nice one.
No, but it's her role.
No, Chair, the 14.2.1, that's where we are, Chair.
We're supposed to be doing 14.2.1, yes, sir.
No, that's correct, Chair. I just want to make a small addition, Chair, around the issue that we have been dealing with throughout, the issue of separation of power, but I think we need to cite a legislation rather than just leaving it general with regard to clarification of duties. Look at the law, which is your Broadcasting Act. How far does it go? So we have to cite those clauses that deals with the separation of power or separation of duties, so that there's no encroachment. On the other issue raised by colleagues around the findings, not only the findings, the issue of the shareholder, we need to go further detail, Chair. There are two things that happen in this chamber here that Mrs. Gelden Hayes, in her submission, made mention of a MOI submitted to the board, and the board having to agree with the MOI. Now, if the board agree with the MOI to give their powers away to the minister, I'm not sure, Chair, that you'll want to go to the extent that you immediately call for the removal rather than maybe we deal with that content first. Be clear, park, this thing is a very serious point. In fact, the issues that the colleagues have raised is what we have identified as a serious encroachment there. But you may even want to go further, Chair, but I know that successor entitled, meaning that even the previous a shareholder where the rot started with regard to the appointment of the community, what do you call them, community liaison to be in the board to an extent that he was acting. It was even before the appointment of the current, what you call. So I'm not trying to separate the two, but I'm saying that I think it's important that we should sort of, maybe next week, spend a little bit of time around this area here. But clearly, the person that appoints is the president. So we must be able to craft something in a way that when we send it to the president, it must hold water, having made sure that all those processes, because if you find that the board, in fact, itself has agreed that these powers can go away, you know, we may find that we are limping a little bit. So I'm suggesting that let's spend more time on that point. We have noted these issues. Next week, when we meet on Tuesday, maybe we'll have sort of consulted with the minutes of submitted minutes and go zoom specifically into the process in which that MOI has gone through. If it has gone to the board and the position and the resolution of the board, those are things that we must package so that when you send it to the president, you are able to say either she has misled even the board itself or the board has agreed to give away their powers to the minister. So we need to be very clear on that. But in principle, I agree that these issues are issues that are very important and we'll definitely have to put our foot there.
Chairperson, yes, I don't have a problem with the first two, 14.2.1 and 14.2.2, but I have a very serious problem with regards to 14.2.3. Okay. Okay, Chairperson, but that is not what I understood from Honourable Van Damme, because she came in with a complete new addition. Remember, she made reference to, and then you said no, but it should not necessarily, we should differentiate between going forward and retrospective. So,
No, put your point. All I'm saying is, let's not halfway through the process do something different, because that's what we did. We did everything, then we said come back to one, then we did, I know Mahlangu made a mistake innocently. We must agree whether we're doing it clause by clause or we're doing everything, but let's allow you to do what you want to do and then take a decision, because I really thought we were dealing with clause 1, clause 2, and clause 3.
Chairperson, I will hold back, but...
No, do it. No, fine. In fact, going forward, I'm saying we'll do it that way, because you've started. Carry on.
Chair, I just feel that we must be perfectly clear of how we see the role of the shareholder representative. Because the SABC is a public institution. It belongs to the people of South Africa, and as elected representatives, Parliament is representing the public. The minister is the shareholder representative, because she has specific duties to oversee its efficiency and effective ability to discharge its duties in terms of the Act. Yep. Now, Chair, I say that just because I want to make sure that we are all on the same page as far as that is concerned. Going forward, I don't see the need for having a requirement that the amendment to the Public Broadcasting Act be processed with speed. I do, however, see that the role of the shareholder retrospectively could be found to have been wanting once the Lubisi court case, the court has decided on that. Because remember, that was done when the board members were chopped. That was taken on review to the courts, and the court could find that that was a serious transgression of the Broadcasting Act and the acts which govern the SABC. But we'll get to that. I think in terms of what we have in paragraph 3. Yeah, okay. Chair, okay, I will not go any further.
Let's be fair. But just to indicate to members, when Honourable Killian says 423 must be scrapped, the point we were making is that we all, during this whole process, we said there is an Amendment Act somewhere. It was somewhere, not an Amendment Act, a bill. It's somewhere. And we were saying, whatever that bill was intended to do, over and above that, that bill must address the matter of the supremacy of or it must not dissolve or undermine, because somebody here said, the bill that's coming, the minister wants to change it so that the powers come to her. So what we were saying in a nutshell, that bill that's there, whatever it's there for, I'm not sure, it must not tamper with the fact that the Public Broadcasting Act is supreme, and therefore everything else must be aligned to that principal act. That was the intention of this thing. So we can't say that the bill, it's a reality, it's there somewhere. All we're guarding against is whatever you guys do there, don't do what we are saying. I think that was the intention. But you see, no, I don't want to talk even to that one, because then you are going all over the show. No, it was not you, it was Skubisa. It was Skubisa. Hey? I'm doing my list, it's Skubisa, Bab. Yeah.
Yeah, Thank you, Chair. Chairperson, thank you. There has been some huge interference by the incumbent shareholder representative in the work of the SABC board, etc. And we say therefore the president must use his prerogative to appoint, to reconsider her position in that portfolio, based on the understanding that it is his prerogative to appoint ministers. Then secondly, saying the power of the minister to interfere in the functioning of the SABC board must be curtailed by coming out with clear legislative guidelines to ensure that the actions of the minister are congruent with her oversight role.
Chair, thank you. Chair, the mere fact that the minister wrote and signed the MOI, which transgressed the Broadcasting Act, was illegal in the first place. It's irrelevant what the board did with it. She took the first step. And the fact that she's put an amendment bill before Parliament which further increases the centralization of power just shows where she's going. So given what the evidence that's been given before this committee and what Honourable Van Dam mentioned as far as the Constitution and the Acts are concerned, I'd like us to change the first sentence to, and I'll just, we're dealing with 421, that the shareholders' representative abuse of her role and responsibility needs to be investigated, blah, blah, blah. And there's 4 steps I would like to recommend. The first one that's been mentioned before is that we request the president to fire her with immediate effect, and a proviso that she does not get any other executive position, because that's what often happens when people get fired from ministry positions to get promoted or sidelined somewhere else. That's because she's shown she abuses her power in a position of authority. The second one is we write to the public protector for her to investigate her transgressions as far as the Constitution, the Executive Ethics Code, and the Powers and Privileges Act. The third step is we write to the Ethics Committee in Parliament for them to investigate her, as well, Parliament. We can do that. We write to the Ethics Committee for them to investigate the fact that she abused her Executive Ethics Code. And fourthly, we lay criminal charges against her at the police station with regards to the transgression of the Powers and Privileges Act. That's my suggestion. Thank you very much.
No, I agree. No, I said there's no holy cows. But when we say we, it must just be clear that these are recommendations to Parliament, and they only take force once Parliament is adopted them. That's all that I was saying, So that's clear. But your points have all been noted. It'll be Swartz and then Konza.
Chair.
And Kwankwa, I beg your pardon, no. It'll be Swartz, Kwankwa, and then Konza.
Chair,
Honourable Swartz.
we need to distinguish, as you've correctly said, between going forward, and so I like 1421 for going forward, how it should be. And then the comments by the other members about holding the present minister accountable must be almost in a separate section, where we look in where we are at the moment, and it could relate to previous ministers as well. But let's just curtail ourselves, because Chapter 2 of the Broadcasting Bill says, being empowered to act on behalf of the nation, the minister has the ultimate responsibility to fulfill obligations relating to use, protection, and access to broadcasting services. So the buck stops with her. And Chair, so I share the sentiments of my colleagues about the bill that is before us, about the MOI, about other issues of the evidence that we've heard, that the minister must be held accountable, and at the very least we need to support the recommendations that there should be an investigation into her role with the possible discharge of her as the minister. Thank you, Chair. But I support that and those clauses going forward. We need to separate the two. I think that's very important. How we would like it, they say in Latin, de lege ferenda, how we would like it going forward, de facto how it is now. So let's try to separate those two issues.
That's fine, because nobody has spoken against 421 for going forward. Most people have been commenting on 421 and related for what you're talking de facto type of thing. We're clear on that one. When I say de facto, I'm saying what must happen because of what has happened. You with me, Chauke? I'm saying most people have been saying that. It's fine. And we're trying to distribute it because what we had here at some point, I think, was accountability. In other words, 14.5. But we'll find a proper home for it. But we just must be clear. Something is what we're saying must happen now, and something is what we're saying must be consequences, basically. Honorable Nkwankwa, and then Honorable Khosa will be the last one on this matter.
Chairperson, thank you very much. I think Honorable Swart has taken the words out of my mouth, because indeed the issue is about if we were to put in whatever the story we want to put in about the current minister under 14.2.1, that would then affect the whole structure of the report. Right, we'd have to do that under each and every section where we're talking about recommendations. Because what we're talking about are our findings. Some of the details obviously are captured under the observation. So we should have that under a separate part indeed, so that we can say, how do we solve the current problem? How do we address the problem that the minister is part and parcel of that problem? So that is as a recommendation to the president. There's this issue which was, I think, an important point which was also captured by Honorable Chauke earlier, saying that, remember when we do that recommendation 4.2.1, I don't think we're only doing it for the SABC. I think we should view it as a recommendation. I'm saying someone who reads the report, say who sits in a different portfolio committee or works in the parastatal, must be able to understand exactly which pieces of legislation, the relevant pieces of legislation that would ensure that that clearly demarcates the role, for an example, that the shareholder should play, right, in a board, for instance. I think we should make reference in that point to the relevant legislations that would actually firm up or strengthen our point insofar as 14.2.1 is concerned. I don't want to start talking about the empowerment issues because we are 14.2.1. I think it will follow up later on. Chairperson, thank you.
And then Honorable Khosa, you'll be the last one on 14.2.1 and related matters.
Chair, I wanted to say, when the challenge that I had with the way we are discussing with 14.21 is that we are already running to the consequence, and yet I thought we are also, as the committee, trying to make recommendations for the minister, whoever the minister is, not necessarily the current incumbent, but, you know, to sensitize the minister on the issues that SABC faced and the role that was played by the former minister or the current minister or whatever, but it's not necessarily about a specific minister. It's about the shareholder representative within this context. And therefore, Chair, I do think that we need to craft a recommendation under accountability, as opposed, if whatever recommendation that we're coming up with, let it come under accountability. And again, members must also remember, and I think the point that was made by Van Dam, that the best we could do, the options that are available, is to probably refer this matter to the Ethics Committee, which has the power and the jurisdiction over this matter in terms of disciplining or whatever, of, you know, going through the normal processes. But as this committee, we can only recommend to that structure. The decision of that structure does not reside with us, because we are only concerned with the board. But because we've picked up this matter, we are then saying, let's refer this matter to them to further investigate and take the necessary actions.
I'll continue to remind members, because remember, we're not talking to ourselves. When we say we will transfer it, I think what we must be saying is we will ask Parliament to transfer it. Because otherwise there'll be a wrong impression created out there that the ad hoc committee is going to write or the ad hoc committee is going to transfer. So I'll keep on going back to this thing that eventually, whatever recommendations is accepted, we are saying to Parliament, do this, not this ad hoc committee. So nobody must go out and say the ad hoc committee is about to fire or the ad hoc committee is about to transfer or the ad hoc committee is about to promote or anything. We will recommend to Parliament and Parliament will do the necessary. So the National Assembly, I beg your pardon, not Parliament, the National Assembly. So I'll keep on reminding you that, but I must also appeal to you that when you do it in that, because this is also about education, honorable members. So when we speak so that those that don't understand never walk out of here or go to bed confused that Labantu Laba, they're going to do X, Y, and Z.
Chair, my point, just to reinforce what the colleagues have raised, is that let us make sure that as we submit to Parliament, we submit even a detail of those transgressions, making sure that, you know, every ground is covered. Because if we just throw it rough and then say we have found the full, I think it must just be one separate, even it's a one-pager with regard to the role of the shareholder, and then submit that so that they then find something that they can begin to work on it. And that's my appeal. But in principle, I think what the Honorable Khoza has put forward, in fact, it works so that this committee is not meant to be chasing, but is meant to be identifying where problems are and then make a recommendation. Thank you very much, Chair.
Honorable Van Dam, and like I said, it's work in progress. You know, we were supposed to do 4.1. We spent 2 hours on 4.1, only on 4.1. Because we all agreed 1 minute, but I can show you, in the absence of one person, or even if there is one that has spoken, we said 1 bite, 1 minute. That's what we said, 1 bite, 1 minute. And everybody keeps on saying, no, I've got a new idea, I've got a new idea. We'll allow you. Understand these things come with consequences. Van Dam, do you still want to talk to 4.21?
No, I'm just speaking about the point Honorable Chauke raised about giving a detailed report to Parliament. So I spoke earlier on when the observations related to the shareholder and also the board about specific sections in the legislation. I'm happy to work on that over the weekend and send it to the committee. The more detailed reports about which specific sections were violated and how, what sanctions are recommended by legislation for those violations.
That's fine, you can send it to us because it'll only go to Parliament or anybody else if we as a committee agree eventually that that's the route we're going to go. But there's no harm in us arming ourselves. Nikatele, because you guys don't follow instructions that you, or not instructions, you don't follow the things that you yourself agree to. But Sizospana till we're done on Friday. Now I'm looking at the time, Cindy, it's 10 to 6. And I'm not, and we've not done with shareholder. Can we at least deal with the shareholder one? We can't leave the shareholder in limbo. Is that agree, honorable members? No, we were only, strictly speaking, we were only doing 4.21, but you guys decided to go all over the show. It's fine. No, Chauke, let me do this first. No. No, it's fine. I am saying we've got 10 minutes, and we've got 14.22 and 14.23 that we've not processed. And there's a new 14, I think, that has come in that we've processed. But these two, is there anybody that wants to speak on these two? And honorable members, it's 1 minute, 1 bite. Can we agree to that one? Okay, and we're dealing with 14, only with 14.22. Don't come with anything new. No. Oh, you want to do both of them? It's still going to be 1 minute for both of them. All right, it's fine. Can I get an indication on who wants to speak on either 14.22 or 14.23 or both? Indications, we will start with Mukwena. We'll go then to Kubisa. We will then go to Waters. We will then go to Swartz. We will then go to childcare, and then we will end with Honorable Van Dam. You wanted to speak as well? Yes. Honorable Van Dam. Anybody else? Honorable members, 1 minute, 1 bite. For 1422, 1423, or both of them. Can you kick off for us, Honorable Mukwen?
No, Chair, I think 1423 could be confusing because it could be saying to the minister that she must carry on with her work and fast track it. And that's not the idea that we want. We want her to retract the changes that she wants to make because we have already ascertained that they are not in line with the Broadcasting Act. That's the first thing. So, however, I understand the sentiment that you wanted to put forward, but I think it needs to be reworded. But she must retract what she's put there. That's one. And then, 14.22, there's no problem with it.
Yeah, I wanted to say we have already spoken to the fact that the current incumbent kept on interfering with the SABC matters. And our suggestion, therefore, was for the president to consider her position in that manner. But with regard to this one, I'd say the incumbent, the shareholder representative, should abide by the legislative prescript that define his or her role within in the SABC matters, should abide by all legislative prescripts that define the role of the shareholder representative. I think that is important. 14.22, it speaks about making a proactive role. Because at the end of the day, an incumbent, even if there's a new incumbent, he or she will have to play a role, but it must be played within the legal prescripts.
Thank you very much. Honorable Waters.
Thank you, Chair. Chair, I agree that this section 1423 I'm talking to is misleading in the fact, I understand your sentiment, what you're saying, but we would rather see the amendment bill being withdrawn. I don't know if we have the power to say that, but the fact of the matter is, we're deeply concerned about the minister centralizing power, as I said earlier. But also, the wording isn't quite clear for me because it gives the impression that we want the MOI, that the legislation to align to the MOI. It should be the other way around. The MOI should always be aligned to the legislation, if you know what I mean. So in this way, we've got the tail wagging the dog. As far as I read it, maybe I've got the wrong end of the stick here. But so the fact of the matter is, we do want to stress that the Broadcasting Act is the principal act that governs SABC, and it comes first. So that we must say. But as far as the amendment is concerned, that must be withdrawn. And the MOI should always talk to the principal act and not exceed it, as what's happened. Yeah.
That was the intention here, that we were saying, we'll clean it up. We'll clean it up, but I think that was the sentiment that we'll find a way that's saying, but what we're understanding members to be saying is, because we were saying whatever it's there, tighten it, but members seem to be saying, withdraw that one, unless, because we're moving on the assumption that that amendment only talks to that one item, because if it talks to all other items, that's why we thought that if we were, and I don't know what is in there, if it's only for this item, then maybe you're right. But if it's talking about this item and 10 other items, we can't say withdraw it because there's a chink in one. We rather say fix up that chink. And so that is why we did this. But I'm saying the sentiment is don't fall into the same trap. And once you've sorted it out, however you sort it out, all the subordinates must talk to the principal. That's basically what we're saying. We'll try and fix it up accordingly, and we'll look at it when we when we revisited. Honorable Swartz.
Thank you, Chair. The two issues that need to be separated here is the present amendment bill that contains certain issues, and then what we are saying is proposing an amendment bill to make sure that the Broadcasting Act trumps the Companies Act when it comes, in both cases, to the appointment and dismissal of board members. That's a very crisp issue. So, Chair, maybe we need to formulate something that the present Broadcasting Amendment Bill serving before Parliament be reconsidered, particularly as it seeks to remove the role of the National Assembly in the appointment and removal of the bill. Because but that must be a committee, because Parliament's already said, I don't know where that bill is, but Parliament has already forwarded it to the Portfolio Committee, so it's there somewhere. But we need to express a view as the committee that we've got reservations in view of our observations about the removal of Parliament's role in that regard. So that is a formulation that I would suggest. And then we then also deal with, in view of the perceived differences of opinion between the shareholder representative and this committee on whether the Broadcasting Act trumps the Companies Act, this committee suggests that this is made eminently clear in an amendment bill to ensure the Broadcasting Act trumps the Companies Act. Those are the two crisp issues, if I've captured you correctly. We
Okay.
can't. So, did you follow that? Yeah.
We followed it. We'll put it that way, but those that are cleverer than us will be able to explain.
Yes, just
should
those-
it be 2 steps? Could we do it in 1 step?
Absolutely,
And all? But
absolutely.
the sentiment is captured.
Absolutely.
Yeah. There's 2 aspects to it, but how we do it is something else. We have captured it. Cindy, you want to say? Honorable Chauke, Honorable Van Dam,
No, no.
and then Honorable Killian, you will be the last one.
14.23, I think Honorable Waters has dealt with the issue of alignment, Chair, which I concur. The point that I want to bring, Chair, around the amendment bill that we have been talking about for quite some time now. Now, the bill process does not only start with the minister and end with the minister. It starts with the minister, it goes to cabinet. Cabinet approves it, it comes to Parliament. Now, we have been referring to the bill for quite some time now. What I'm going to propose, Chair, is that, because I can see that Honorable Swart has a copy, and you have already yourself made a point that we can't just call for a general withdrawal of the bill without understanding the content of it, therefore. It may be addressing other issues. It's important that maybe in the next meeting, when we meet either on Tuesday, Chair, Honorable Swart, because it seems that he has a copy of that, identify within the bill a clause that is against the spirit of what we're dealing with currently now, or a clause that deals with the removal of powers of Parliament to the minister, so that we are very clear. We can't just call for withdrawal of the bill without understanding the content of that bill, and meaning that if you look at the principle of the bill, it will be covering a number of things. So the memorandum of the bill tells you of removal of power. So those things, Chair, are things that you don't just come and kick them out and say, let them go. You look at the object of the bill. What is it addressing? Then you go into a particular clause that is against the process that we are dealing with. Then we can call for the removal of a particular clause in the bill. If the bill addresses other areas, the bill can go through. So I'm saying that in the next meeting when we meet, we'll have to look at that point. We can suspend this part now. We don't have to rush it. But we must be very clear so that we don't find ourselves having to crash what government has brought to Parliament.
Yeah, sorry, Chair, sorry. Yeah, sorry, no, I just wanted to clarify this. The bill is actually only dealing with the composition of the board and the powers of the minister in respect of the appointments.
I'm still on the floor.
Oh, no, but you can't be on your 1 minute. It's fine. It's fine. You can talk when there's clarification. People were asking if there's any other one. It seems to be talking purely on the matters that we've experienced now. That seems to be what she's saying. Do you want to, can I give you 1 minute because you wanted clarity? Then it's going to be Van Dam and Killian, you're going to be the last.
No, therefore, Chair, if it's confirmed in that way, it means that that bill must come before us here. We must look at it. So that when we make a recommendation, Chair, we are making it on an informed, having gone through the bill itself ourselves. I think you'll agree with that part. No, but you have to present it for us so that we can engage. You can't have it in piecemeal. Let's have, so that in our report, Chair, we can reflect. Because the withdrawal of the bill is not just an issue of a hearsay there or the bill is there. It must be a process that, because the powers given to us is the same powers of the committee. Therefore, we must be able to go through it, look at it, someone present it proper, we look at it, and then, in fact, you can find that we can even make a recommendation to correct it properly.
Your time is up. We will think about it again. I'm just saying, honourable members, already our work is onerous. I know it's late and we now wanting to it's fine, we can do all those type of things. I'm just saying when we make undertakings ourselves, let them be realistic. It's not as if somebody will come with a bill for 5 minutes, give us a presentation, and we'll be authoritatively empowered to make a decision. I'm not saying it's right or wrong, but we will capture it. Honourable members must just think about it when we come there. Van Dam, you've got 1 minute, and it'll be a little bit more because everybody else has taken a little bit more, and then Killian, but 1.5 at the absolute most. Thank you, ma'am.
Thanks, Chair. I've actually done extensive work on that bill because it's currently before my committee. So other than removing Parliament's role in appointing board members and giving that to the Minister, it reduces the board from 12 to 9, it reduces the quorum to 9 to 7, and sets in place new procedures for the appointment removal of the board. But if Honourable Chauke would like a presentation on it, I'm sure the legal advisors would be more than happy to do so. But speaking about 4.2.2, I don't. If you're a member of the cabinet, you should know what your job is. If you don't know what your job is, then you shouldn't be a member of cabinet. So I don't know if it's our place to tell the minister to, equip herself with the knowledge about her job. If you don't know what your job is, educate yourself. And how many years is it now? 2 years into your job, you still don't know what your job is, then goodbye, you must be fired. And then in terms of documents that we think should be withdrawn, I absolutely agree that we must say the Broadcasting Amendment Bill must be withdrawn, along with the MOI, and also the Delegation of Authority Framework. But in terms of, once again, what recommendations we are very strong about is the Executive Ethics Investigation, the Public Protector Investigation, the criminal charges, and that she must be dismissed from her position as a Minister of Communications. She's unfit to hold that office.
I want to name, no, look, this is a political terrain and we shouldn't worry about it because we've dealt with something, we come back, we reinforce it, we come back, and I'm saying it's fine. Let's play that game. I'm just wary that, and I'm looking at other members, because there's always the temptation to say, if X said it, I'll say it times 2. Because we're all politicians here. And I'm just saying, let's hamburger all of us. I'll keep on trying to goad you to play the game properly. Because I'm seeing Chauke is already raising his hand. And no, I know you want to clarify. I know you want to clarify. All right. We have Killian, and then Chauke, you'll clarify. But I'm saying this rival, no, it's Killian first. I really don't want us to be divided around political lines. I really don't want to. Killian and then Chauke, you'll clarify.
Chairperson, thank you. Chairperson, there was adequate evidence before us that the MOI had different versions and that there were criticism that it was not compliant with the Broadcasting Act. So its validity is under question. I would like to suggest that 14.2.3 is not the shareholder representative responsibility to fast-track the amendment or any revision of the broad. Should there be uncertainty, it's Parliament's responsibility. So I would like to suggest that we actually look at the role of the Portfolio Committee to complete fast-track if in case there is any uncertainty, and I just want to say that because of this particular section of the bill, of the Act, and that is save to extent stipulated in this Act, the Broadcasting Act and not the Companies Act applies. So Honourable Swart mentioned that there must be certainty what trumps what. We have no uncertainty. We know exactly. But the point is, if we can further strengthen the Broadcasting Act, let the Portfolio Committee do so through the legislative process. The second point that I just want to raise is that is the Portfolio Committee should also obtain a legal opinion about the validity of the MOI, seeing that we regard it as contradicting the Broadcasting Act. So I would like to suggest that it's only the shareholder compact that is really the agreement between the corporation and the shareholder. But not the MOI is the Articles of Association of this company, and that is regulated by the Broadcasting Act. That's where that clear line, separation of powers, comes into. So I would like to rewrite that section and actually allocate it to the section where we come to parliamentary oversight and what must be processed there. Thank you.
Honourable Chowke.
My lovely chairperson, I fully agree with you. This thing is not about Chowke, as Honourable Van Dam was saying. This thing is about the process that we must follow if we're to make such a recommendation. You cannot make a recommendation because there are certain members who are privileged because they have that access to that information because of the fact that they serve in a particular forum. It cannot work like that, Chair. It had to come here, identify which clauses in that bill that we don't agree. If it's the entire bill, then we can make a proper recommendation. So how do you make it here without even discussing the whole thing? You can't. So I'm proposing that we're not going to rush. Come Tuesday, if you can, then I can go and get that bill. Get legal advisor, it's here already. I got that they have information about it. They can talk about it. Then we take an informed decision, all of us as a committee. Then we'll be okay.
Yeah. We can do that. We will continue to teach each other. Not teach each other, but remind each other. Let's refrain from trying to micromanage other people. I mean, I think the point is we're saying in our work we've identified these things. As Parliament, remember we're sending it to Parliament, and Parliament will find the relevant bodies to do it. I'm not sure, Mkwena, if somebody came to present that piece of intended legislation to me and you, maybe you, but me, I'm not sure that I'll understand it. So why, you understand what I'm saying? So I'm just saying, and I hear what you're saying. I'm always going to keep us on the straight and narrow that we're not the brightest people in Parliament. We're not the know-all. Ours has picked something up, and we'll say to Parliament, this is a red flag, send it to the people who can resolve it. Because it's not our job to resolve the problems of whatever, but we hear that point, and we'll mull over it over the weekend. We'll certainly put it in there, both versions. I'm just saying members must mull over it over the weekend. It's 10 past, honourable members, and we've done the shareholders and the stakeholders, but because I'm also a politician and I understand how people work, Van Dam and Chowke, both of you, I'm talking to you because you are the biggest culprits. I don't want you guys now to not come back to this committee because you think, because for me, those are probably the most juiciest ones, the shareholder and the thing. The others, we're no longer going to come because now they're talking mundane stuff. Everything you are still going to work with us with, all of you. And it was good that we had this robust debate. I want to thank everybody because even in our political posturing, I think there was a decorum of what is the important thing to do. So there's no difficulty with that. The final thing I want to say to everybody is that let us understand that these are just deliberations. You can make inferences of what each political party or each member's leaning is towards, but the official committee position will only be known round about the 22nd, I think, according to our own new program. So nobody's going to phone anybody and say, now, what is the leaning of the committee chairperson? These are just discussions and deliberations. And people are free to air their views. We will continue to refine them, but thank you very much. Just to reiterate to everybody, the program is going to be that we're going to meet, and in specific terms, I think we've got 6, if you want to call it subheadings left, to deal with. And they are, well, we've dealt with the shareholder and the board. It's what we're calling here, and we'll change it, the legal status and governance that really deals with the stuff members were talking about, legislative framework, basically. And then we talk about what we call here corporate governance, but really deals with the administration. And then there is an issue on accountability, which is really, in our understanding, the whole issue that we're talking about, because they get 3%, they don't think they account to Parliament and that type of stuff. And then there would, of course, be the matters that related to ICASA and so on, the journalistic parliamentary oversight. And then you'll recall yesterday we called it testimony and all those type of things, but it's really the accountability. So there are a few things that we have to deal with next week. We might not even go to Friday, honourable members, quite honestly. But we'll mull through them starting Tuesday. Once we've done them, you are going to have to give us, when I say us, I'm talking me and the rest of the team, you're going to have to give us at least 48 hours to put it together. We will then give it back to you and give you minimum 24 hours before we call the next meeting. In other words, to consider whether our document has captured what you've done. And the worst case scenario is that will happen on the 27th, isn't it? 26, 27, that's the worst case scenario, that we will deal with that, then send it out to affected parties until around about the 16th or so of March, but we'll give you the exact date next week, so that will go into around about the 16th or 18th of March. I don't have my piece of paper. February. And then instead of us having adopted a formal report as we had planned on the 15th of February, that is now going to happen around about the 22nd of February. So everything has been moved out by a week. Fortunately, we had that week's grace. So everything will be moved out by a week, and we will still, I'm convinced, meet our 28th deadline, if all of us play the game. So we will do that, honourable members. You don't have to work overnight. We reconvene in this venue? Yeah, it could change. Okay. No, we'll reconvene. We'll tell you which venue it is, because committees start next week again. We'll try and keep this venue, but if not, we will tell you. But we will reconvene on Tuesday and start with chapter 3 of this and move on Tuesday at 10 o'clock. And on Tuesday, we'll tell you about what's going to happen on Wednesday and so on. So Tuesday, 10 o'clock, we will start with part 3 of the 8-part recommendations. Honourable members, having said that, thank you very much for your patience and your part. Fridays are very difficult to have people here. Meeting will stand over until Tuesday at 10 o'clock. Thank you so much. Oh, no, these guys will never forget. They're saying to me, please remind people about supper. I'm saying they'll never forget about supper. Supper is available for you somewhere.